Be cool, be kind, be classy. A cupcake so sweet and sexy. Have fun, enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. Not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. There's a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Meshegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcake's sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good morning. Good morning, sunshines. How's everybody today? Today is Wednesday, May 28th, 2025, day 22 of the Re-Persecution of Karen Reed, season 2, day 22, episode 22. We're here for it. Judson Blair Welcher. Sounds like something out of Gossip Girl, doesn't it? Is still currently on the stand under direct examination by Hank Brennan. And it was my understanding that court was going to start at 9 today, and the jury wasn't coming until 10. But actually, the jury, nothing is starting until 10. So we're here. We're here for it. We're going to hear the judge's ruling on the motion yesterday regarding the improper opinion testimony that was elicited from Judson B. Welcher, who could have been a doctor. He could have been a medical doctor, but his father was a doctor, and his father didn't want him to become a doctor, and so he's not a doctor. He's a biomedical engineer, not a biomechanical engineer, but a biomedical engineer. But then when I was listening back to some of his testimony yesterday, at one point he did say that he was a biomechanical engineer. So I'm not really quite sure. I'm not sure if he's even really quite sure. And how many of you went back and watched that testimony again? Because it was a lot. It was a lot. It was cosplay. It was Nickelodeon. It was like he was slimed. It was grease paint. It was a lot to digest. Amanda, good morning. Thanks for becoming a member. Sidebar chick. I took a screenshot John O'Keefe's arm and did a Google camera search. Even AI says it's a dog bite. Well, that's interesting, right? Come on, Commonwealth, let's end this charade, or charade, as Bev would say. Thank you, Sidebar chick. Look at Bianca coming in and gifted a membership so early, and to the lucky recipient, welcome. Welcome. Enjoy the emojis. Got lots of emojis for this trial. I don't know what is going on. It was like being in the Twilight Zone yesterday. It was so, finger paint. Alessi will straighten it out, but listen, that opinion testimony that was elicited from him yesterday was really, really off the charts. I mean, the jury is the one who is supposed to decide. They're the finder of fact in this case, the jury. It is up to them to decide whether or not John O'Keefe was hit by a car and whether Karen hit John with her car. The problem is the expert testimony should have come in that, yes, it's my opinion that according to everything that I reviewed, it is my opinion that there was an impact with the vehicle. And he basically said his opinion was that she did it. And that is just highly improper. It should be stricken. I don't know what the remedy should be. We're going to see what she decides. And, The way that Hank Brennan got up there and started really stomping his feet and whining like a baby was borderline embarrassing. And it's like, what exactly is it that you say you do here? Because apparently you don't understand how to elicit expert testimony. In fact, he kept asking him, do you have an opinion with a reasonable degree of engineering certainty? Okay, there is no engineering certainty. It's either scientific certainty or reasonable degree of medical certainty. There's no engineering certainty. And so remember when, I think it was during the first trial, in the middle of the first trial, because in the middle of the first trial is when the judge allowed Lally to conduct voir dires of not only Dr. Marie Russell, but also Dr. Wolf and Dr. Rentschler, the crash daddies. And she had a big problem because Dr. Marie Russell did not say the magic words. The magic words, I have an opinion with a reasonable degree of medical certainty. And it was like the judge almost kind of mocked her for not knowing the magic words. And it's not up to the witness to know the magic words. It's up to the attorney to ask the question using the magic words. Do you have an opinion with a reasonable degree of medical certainty? Yes, I do. And what is that opinion? And then the expert states their opinion. The attorney does not frame the question in a leading way. Oh, and is it your opinion that John O'Keefe got hit by a car in the arm and then Karen Reed hit him with a car and killed him? And then it is not for the witness to say, yes, that's my opinion. I don't know. I feel like we're in an alternate universe here, which obviously we are, because it is the inside out, upside down mishigas of a Shonda that is Norfolk County, Massachusetts. There's a glitch in the matrix and we're all here. We're all in on the same joke. We're all in on the same joke. She does it all the time, Sherry. Sherry says Brennan knew what he was leading the witness to say. Bev knew it was coming and wrong and yet allowed it. Case needs to be over and Karen Freed, such BS. Well, he's been doing this historically for the entire trial. The entire trial. He will ask a leading question of the witness, and the answer to the question is in the question. And then the objection is sustained, and then he asks it again. God to save us from the Commonwealth. And they have the answer. There we go.
All right. Good morning, everybody. All right, so Dr. Welcher can testify that the data he downloaded and analyzed and the damage to the Lexus is consistent with Ms. Reed's vehicle being in a collision on January 29th at 12:32 a.m. because he's a qualified expert and his opinion is based on reliable methodology appropriately applied. In addition, Dr. Welcher can testify that Mr. O'Keefe's injuries are consistent with his having been struck by a Lexus that is physically identical to Ms. Reed's Lexus, because this opinion is based upon, among other things, his experimental work that came into evidence without objection as to scientific methodology and application. However, he may not testify that Ms. Reed's Lexus collided with Mr. O'Keefe because that conclusion is not based on the application of reliable scientific methodology. The problem here is not that the opinion concerns the ultimate issue, because in Massachusetts, that's not a bar to admissibility. Rather, it is that Dr. Welcher, the expert, is drawing an inference based upon more than scientific method. His opinions set the stage for argument and a permissible inference to be drawn by jurors through the application of their sound judgment to the opinions that they find credible. But the jurors are as well positioned to draw or reject the inference as is the expert. That is, the inference is not compelled by the application of any scientific method. So that's the ruling. All right, so the jurors are lining up.
Is she going to hear them?
Have them momentarily.
Is she going to hear the attorneys if they have something to say?
Okay.
Why is she so out of breath? Where are the grave concerns here? Where are the grave
Is
concerns?
Dr. Welcher right around? Why don't we bring him in if he's here before the jurors?
Here's the problem. During the first trial, the judge made a ruling that Dr. Rentschler, despite the fact that this is his expertise as a biomechanical engineer who's way more highly qualified than Welcher could not opine that the injuries did not come from a car accident because he was not a medical doctor. That was the ruling in the first trial. Now, all of a sudden, everything has changed because there's new players. It's a new game. It's a new game here. It's a whole new game. Now, a non-medical witness.
We provided a copy to the defense with all the redactions.
Okay.
The
Are you in agreement with this, Mr. Alessi?
I haven't gone through it, but I have no reason to believe that I wouldn't be in agreement. So
Okay.
I can just go away with any of this.
there is one slide, so I'll admit it conditional to redactions that you didn't rule on, but I feel as though you probably will exclude, and that is in that version. I didn't want to pull it out with the court's order, but I'll talk to.
Do you know the number? You don't have to find it if you
Well,
don't.
we've got your number, Mr. Brennan.
131.
Oh, is this was it 130? Was it 131 yesterday too?
It was.
So at sidebar, I said we could go back to that. And Mr. Alessi agreed that we could go back to that. So, and I know I thought we were starting there, and I think Dr. Welcher thought we were starting there, and then you went to 132. That was my understanding at sidebar.
It is, but subject to me being able to object. I was basically, because we wanted the jury to come in, so I want to look at the slide.
Okay, so look at it again. That's not my understanding, Mr. Alessi. It was you were concerned just about the heading, and then I said we'd go back to both slides.
Oh, yeah, no, I'm okay with that.
Yeah.
That one, yes, your honor's recollection is correct.
Yeah,
I was okay with the heading movement.
And we were going to start on that, but you thought because I struck it based on the objection, but then at sidebar, I said we could go back to that. That's your understanding too.
Correct, Your Honor. And I'm sure that Dr. Welcher took off the heading on 131.
I think he did, but because I think he took off from 124 to 1.
I think he did as well.
I did.
Thank you very much.
Okay.
I would like your prediction to come true.
Are they out there, Paul? Okay, thank you.
Is it just me, or did she seem relieved that nobody argued with her? I've never seen a non-medical doctor be able to opine about the causation of injuries to a human. This judge didn't allow it last time, but she's allowing it now. And in my mind, that opens the door for Dr. Rentschler to be able to come in and say, these injuries absolutely did not happen from a car accident. The damages to the car were not caused by hitting a pedestrian. The world is watching. She doesn't seem to care, but she looks very nervous.
All persons have any business before the Honorable Beverly Cannoni, Justice of the Norfolk Superior Court, and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is now open. You may be seated.
All right, good morning again, counsel. Good morning again, Ms. Reed. Good morning, Dr. Welcher.
Good morning, Your Honor.
And good morning, jurors. I have to ask you those same 3 questions. Was everyone able to follow my instructions and refrain from discussing this case with anyone since we left yesterday? Yes. Everyone said yes or nodded affirmatively. Were you also able to follow the instruction and refrain from doing any independent research or investigation into this case? Yes. Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday? Everyone said no or shook their heads. Thank you very much. All right, Mr. Brennan.
Thank you, Your Honor.
How much longer do you think Boss Baby is going to be today? How much longer can we stand listening to this?
Morning, Dr. Welcher.
Good morning.
When we left off yesterday, I was asking you about some of your opinions. I'm going to ask you those questions again, but before we do, I'm going to ask you 2 other questions. The first is I'd ask you to turn to your PowerPoint, slide 110.
110. 110.
You want me to display it?
Please.
Court TV says this
Going
is
to ask you a
Commonwealth.
question about a series of your slides regarding this effort. This is 110. Could you also follow through to 111, 12, 13, 14, 15?
You want me to play the videos?
You don't need to play the videos. I just want to acquaint you for the question.
111,
12,
112, 113,
Blue Man Group.
114, 115.
How many times did you engage in testing where your arm and forearm touched the rear right of the exemplar Lexus?
3 times.
In any of those 3 times, did it ever leave any paint on the underside of your arm or forearm?
No.
If you could turn to slide 130, please. What? Could you go back one, please?
So therefore it's not dog bites, right? Really? How much of a contortionist do you need to be to come to that theory? Really scientific,
Perhaps
exactly.
it's 131, Dr. Welcher. There we go. Could you explain the significance of this slide, please?
Your Honor, this is.
Oh, could you take that down, Dr. Welcher?
Sure. Thank you, Mr. Brennan.
We're going to
Oops.
move forward.
Oops. I forgot I'm not allowed to
Yesterday,
show
when
that
we
one.
left off, I had asked you,
So we need to take this.
Sorry.
you could take the PowerPoint down, please.
That was in a different spot on the slide. Hold on a second.
Let's show all the slides we're not allowed to show and then pretend we did it like an oops.
That's better.
In case you're keeping
Thank
track,
you.
he's got 140.
So I had asked you yesterday about some of your opinions. I
Correct.
want to ask you about some of your opinions relative to that last effort that you made regarding testing between the Lexus and your arm.
Correct.
You had mentioned earlier on in your testimony that you reviewed a number of pieces of information and offered that you relied on some of those pieces for your opinion. Can you share with us, for this part of your analysis, what pieces of evidence or information did you rely on for the opinions I'm going to ask you?
Relative to the testing on the arm contact on the taillight.
Yes.
So it was the physical evidence at the scene, the photographs of Miss Reed's vehicle, to a certain extent, my analysis of the Ring doorbell and the One Meadows event, the nature and
Excuse me, Your Honor, pardon my interruption. I just want to know if he's reading from something or not reading.
Looks like he's counting on his fingers. Are you reading from something?
no, I am counting on my finger.
Okay, thank you.
So, I am counting on my fingers. The Ring video doorbell, Mr. O'Keefe's height, the type of shoes he's wearing, because I need this.
The Ring video doorbell footage? What doorbell footage from a Ring video? Anybody? Bueller?
Same type of shoes, my exemplar inspection where I matched up the heights, the locations of the lacerations, and then the text stream data as well.
That information that you considered, in addition to the text stream data you considered, considering both those areas of information, do you have an opinion to a reasonable degree of engineering certainty in whether the damage to the defendant's Lexus is consistent with a collision with Mr. John O'Keefe on January 29th, 2022 at around 12:32 a.m.?
So there's been 2 potential theories that I've seen on that issue. One is a glass was thrown at the rear of the vehicle and shattered it. The second one was an impact to the arm. If the impact is basically more than approximately 8 miles an hour, it will likely break the taillight lens.
Do you have an opinion whether, based on the data and based on the physical damage and your testing, whether that is consistent with a collision or a impact with Mr. John O'Keefe?
It is consistent with the collision as long as it's greater than approximately 8 miles an hour.
Do you have an opinion whether it's consistent with an impact or collision with Mr. John O'Keefe on January 29, 2022 at around 12:32 a.m.?
With that caveat, yes.
In your testing, did you consider, or do you have an opinion to a reasonable degree of engineering certainty, whether John O'Keefe's injuries on his arm, and inevitably in the back of his head, are consistent with being struck by a Lexus identical to the defendant's Lexus on January 29, 2022.
Yes,
What's your opinion?
that it is. It is consistent with being struck by a Lexus and ultimately contacting a hard surface such as frozen ground.
And does that specifically pertain to January 29, 2022, around 12:30 a.m.?
Objection, Your Honor.
Leading.
I'm going to allow that.
Yes, it does.
To finish, I'd like to ask you a few more questions. You've written some papers on side swipe collisions or clipping. Can you describe for the jury and explain what a side swipe collision is or a clipping and how that may or may not differ from a direct hit on a pedestrian impact?
Sure. So what generally differentiates, say, side swipes or clipping contacts compared to, say, an inline impact or, say, a T-bone impact is what refers to that the object that you're hitting isn't accelerated up to the speed of the object that's coming in. So, for example, if I rear end a car, that car will be accelerated up as a result of the contact, and they reach what's called common velocity, and then they separate. And so in a glancing hit, you can have a glancing hit and you don't have what's called complete momentum transfer, meaning the momentum from the car, because it's a glancing hit, doesn't completely transfer to the object being struck. For example, you can drive down the road at 100 miles an hour and clip the mirror of a parked car and you'll break the mirror off, but you're not going to go from 100 to 0 instantaneously. You're just going to keep going because you don't have all that momentum transfer. So when you have glancing contacts, you can have much higher speeds without a lot of damage to the car because you're only in momentary contact and it's a glancing type hit.
You mentioned about potential damage to a car. How about potential damage to the pedestrian?
It's the same thing. So when you have a glancing hit to a pedestrian, this is referred to as a fender vault. In this case, they call it a fender. Fenders on the front of cars because most pedestrian impacts involve the front of cars. In this case, it would be called a quarter panel vault, which means you're kind of vaulting off the corner of the car. Those are much more complicated because you don't have that common velocity that I referred to. So it's difficult to calculate the exact speeds at which the vehicle contacted without a whole bunch of information in that type of crash. If the impact had occurred in the center of the vehicle and we knew where the point of impact was and the point of rest, we'd have a much better chance of determining how fast the vehicle was going. But when you have just a corner clipping or glancing, it makes it more difficult to determine, even when you have an area of impact, which is where the person was when they got hit, and a point of rest where they landed, makes it more difficult for glancing contacts because you have that side swipe problem where they don't obtain what's called common velocity.
And what are some of the other?
The problem is that it didn't happen. The problem is that they said in the first trial it was 24.2 miles an hour. Now you're saying you don't know how fast she was going, allegedly. And now it's a quarter panel vault. Will that be an Olympic category in the next gymnastics competition? A quarter panel vault.
Difficulties in obtaining specificity in a side swipe or being hit by a quarter panel as opposed to a fender?
So for a pedestrian, correct?
Yes.
So pedestrian impacts and how you move post-impact are very sensitive to your exact body position. For example, whether your right foot is on the ground or off the ground, whether your left foot is on the ground, off the ground, whether you jump up in response to the crash. Simply raising and lowering your arm changes the amount of rotation that's going to happen.
Pirouette?
Post-impact motion of the person. So cadavers, crash dummies, don't have any muscle reaction. So the motion of a crash dummy is just going to be like you're hitting a dead body, to where people will step, try and regain their balance if possible, will do additional activities that alters where they come to rest.
In your studies of direct pedestrian collisions by front or back bumper, as opposed to side swipe or clipping somebody, is there a similarity or difference in type of injuries that you see?
Yes.
And what is the difference?
So in direct centralized impacts, you tend to get much more severe injuries. Really what's occurring is you're getting that momentum transfer. So it's more, you're accelerating the person up to the vehicle. They can wrap onto the side in front of the vehicle at higher severities. Their head will hit the hood, their head will hit the rear of the vehicle. So when you have that direct contact, there's actually more momentum transferred to the actual occupant. There's more applied force to the occupant as well.
When you see direct impacts, is there ever the existence of lower body extremity injuries, broken bones in the legs?
So there can be both, depending, and again, it's very sensitive to where the foot is on the ground, whether the foot's on the ground, as well as the severity of the crash. In the presentation that I gave at the Actual Reconstruction Collision Safety Institute on pedestrian injuries, I went through all the literature on lower extremity injuries and looked at what parameters affected that. And so depending on how it was loaded, some at 15 miles an hour had no injuries. Some at 15 miles an hour had some fractures. It depended on how exactly the foot was loaded.
Is it uncommon in sideswipe pedestrian accidents to see no lower body broken bone?
No, it is not uncommon.
It's not uncommon.
Have you had cases that you've studied or been involved with where you've studied the effect of a sideswipe or a clipping impact where there's an absence of broken bones in the lower body extremities?
Yes.
I'd ask you to turn to slide 139, please.
Thank you, Wim, for tuning in from the Netherlands and gifting 20 memberships. You are so kind and generous. I appreciate you. To the 20 new members, randomly selected by YouTube. Welcome. Welcome. I think you're going to like it here. Thank you, Wim.
I fixed those other two slides.
Okay.
I fixed those other two slides, Hank. I got
Could you share with the jury what this represents?
Sure. So this was a trial that I was involved with in downtown Los Angeles. I've redacted the name at the top. But this was an instance where we had, this is a image from the police report. Well, let me see if I can.
He's just putting up slides of another case that he handled as an exemplar. In what world
So
is this?
AOI in this diagram stands for area of impact. That's where the pedestrian was when they got hit. AOR is area of rest. And you can see we have information on exactly how far the pedestrian was thrown. Then on the right-hand side, we have.
Come to your screen if you're not on scaffolding or driving a motor vehicle or an 18-wheeler or a tractor. Look at the damage to the front of this car. Pretty heavy damage to the front of this car.
Photographs. Then on the right-hand side, we have photographs showing the impact to the pedestrian. This was determined by experts on both sides of this case to be between a 25 to 35 mile an hour impact.
That's what they were saying.
And then what you see is a close-up on the bottom slide of where there was DNA transfers, hair and tissue samples on the vehicle from the individual that was hit by the vehicle.
Again, we don't have any of that here. No hair or tissue samples. Oh, but there's one apparent hair that could have belonged to anyone in the maternal line of John O'Keefe, but no blood, no tissue on the car at all, or the taillight pieces.
Next slide, please. And what does this represent?
So this is the
dead
decedent
body.
in the case, the person that was hit. He was killed at the scene. What you see on the left-hand image, oops.
I'm going to cover that up a bit.
On the left-hand image
Is the body.
is he had a massive laceration to his right forearm, but it didn't break his arm. There was no broken bones in his arm.
Can you still hear
On the
it?
right-hand side of this image, you see the autopsy report. What you'll notice is he had red marks on his leg, left buttocks, but he had no leg fractures. And again, this individual was hit at between 25 to 35 miles an hour.
Can you
Thrown.
expand that? I'm sorry.
Yes, yes, Your
Do you want that expanded like other times?
I don't need to see that dead body again,
There you go.
but you should be able to hear it if they could put it back up and
No,
I
my
take it
pleasure.
off.
Thank you. So at the top, he had a severe brain injury, which again is the most common injury in pedestrian crashes.
No, it's not.
He did have fractures of the right 11th and 12th rib and a liver laceration. If you look at the extremities, it says right upper extremity. Again, that's from the shoulder to the end of the hand. Extremity wound with vascular injury.
I'm taking it
So
off.
no fractures. If you look where I was talking about the multiple abrasions, so when they're looking at the lower extremities, they're noting a number of red marks, but there was notably no fractures to the lower extremities.
Thank you. You can take that down, please.
Okay.
I have no words. I have no words.
Dr. Welcher, regarding your analysis of the data and the evidence in this case, do you have an opinion to a reasonable degree of engineering certainty
It's not a
whether
thing.
the absence of lower body brakes to Mr. O'Keefe is consistent with
Breaks.
the defendant's Lexus impacting in a side swipe or a clipping Mr. O'Keefe?
Yes, you could definitely have this type of impact and not have anything beyond, say, red marks to the lower extremity.
There were no red marks
Thank
to
you,
his lower
Dr.
extremity.
Welcher.
My
Your
pleasure.
Honor, I would move into evidence subject to redactions. Dr. Welcher's PowerPoint presentation.
That's by agreement, Mr. Wilson, with that
That is, Your
caveat.
Honor. Thank you.
They're only allowing it in because they think it's a joke. Apparently, Alessi's going to be like, yeah, let them watch his PowerPoint. Red marks. With the absence of lower body brakes, he said. Lower body brakes. Does the jury think he meant BRAKES? What he meant to say was fractures in his question, Brennan, but he said the absence of lower body brakes. Is this a joke? Are we all in on the same joke?
Book.
On representation, it's consistent with it, it's the same as that I know.
So let's put them both together now and decide later,
Thank
okay?
you.
Yeah, let's just decide later. No big deal.
Those two slides are incorrect on the flash.
Yeah, that-
Okay, so we'll switch that.
that was-
I love the witness saying in front of the jury, those two slides are incorrect. Like I was wrong. He said it now twice.
What exhibit number is it?
This is a circus.
206, thank you.
Exhibits 206 A and B.
It's okay. Alessi is coming.
All right, Mr. Alessi, whenever you are ready.
We're ready.
Sure.
Hear the sighing? The judge is sighing already. Oh boy. Buckle up, buttercups. We're a little behind, but just a tiny bit scooch. Tiny little scooch. Well, welcome to Bobby Alessi's barbecue. Slice and dice. This guy doesn't know what he's in for.
Morning, Dr. Welcher.
Good morning. We haven't been formally introduced. Your whole name?
Robert Alessi, sir.
Robert Alessi. Nice to meet you.
Nice to meet you.
Wow. Wow. Starting off with a bang.
Dr. Welcher, the area in which you engage can also include, and I believe you used the term on direct, forensics, correct? Do you engage in any forensic activity in your profession?
Yes, the general umbrella of you basically coming in, giving scientific evidence in court applies to forensics. So my main job is action reconstruction and biomechanics. And so that's what I do. Sometimes it doesn't involve court. When it goes to court, that's generally forensics.
Right. So you're here today. That is my question. You're here today, at least in part, with regard to forensics, correct? Because forensics is the Latin term for it is basically you're going to have some type of court or jury presentation. It's for law, correct? Would you agree with that? It's for law, forensics?
I mean, exactly the way you asked that, no. It's for engineering and it's for biomechanics. It's in the court of law, I think is what you're asking.
That's exactly it.
Okay,
yes.
yeah, certainly for the court of law,
It
yes.
ends up to a court of law, and forensics is a common term.
Yes, sir.
So
Yes.
it relates to, or it's used in, or it's suitable for a court of law, the analysis. You'd agree with that? It's a general principle?
Yes.
Not a trick question. Okay. And so in forensics, what you're doing, among other things, is you're applying the scientific method and principles in here in a criminal matter, correct?
Yeah, you try and apply as much as possible.
Right. And so the primary goal of forensic science is to uncover the truth and to provide objective evidence that can be presented in court.
That is generally correct. Again, there are elements, for example, this analysis that are relying sort of on subjective evidence, like the testimonial, the witness statements.
Sort of.
So it's not solely based, but ideally you'd want it as much as possible based on objective data.
So you would agree that truth and objective evidence is part of the presentation in terms of information for forensics in a court of law?
Certainly objective information, truth sometimes, again, can be subjective.
Oh, so you don't
Truth
believe
can be
truth?
subjective.
You believe sometimes truth applies and sometimes it doesn't?
If you know for a fact it is true, but if you take someone's deposition testimony, you have to look at it relative to the evidence, and it's either consistent with the evidence or not.
Okay, so now let's go to your direct examination that you just went through.
Please.
Hopefully this is fairly straightforward. You have testified to, and it's varied a bit, a reasonable degree of engineering certainty.
Yes.
Is that correct?
Correct.
You've also, have you used the word sometimes to reasonable degree of scientific certainty?
I may have.
Right. So
I don't know.
in terms of your role as a biomechanical engineer and accident reconstructionist, is it important to engage in a critical analysis of the data?
Critical analysis? Yeah, I think it's important to have a critical analysis. You want to try and look at it from all sides, consider all possibilities.
So it is therefore important to try to review the data as objectively as possible. You had mentioned sometimes subjectivity comes in, but I understand the goal is to try to look at it as objectively as possible, correct?
Correct.
Now, you stated with respect to your conclusions early on in your direct testimony and your analysis that you don't, and I think I've got it quoted, you don't have a dog in the fight. Is that what you said, sir?
Yes, he did.
And that you, quote, don't care, end quote, about the outcome. That's what you made a point of saying in the beginning,
That is
correct?
100% correct.
Now, you simply follow the data. Is that correct?
I try to do that.
You try to do that.
I'm not perfect. So
Okay.
I do my best. I believe I've done it here.
I'm not perfect.
Okay, so in terms of you've agreed that you apply the scientific method, so I want to see if you're in agreement generally so the jury can understand what the scientific method is. Are you familiar with NIST, National Institute?
Yes.
Yeah, so would you agree with this definition of the scientific method? The systematic pursuit of knowledge involving the recognition and definition of a problem, the collection of data through observation and experimentation, analysis of the data, the formulation, evaluation, and testing of hypotheses, and where possible, the selection of a final hypothesis. Is that a general fair statement of the scientific method?
So for forensics, you'd have to add in the testimonial evidence aspect of it. So those are testimonial or things are in evidence. So frequently there's one or two versions and you're trying to match which version is most consistent with the evidence.
Okay, adding that to what I stated relative to NIST, you would agree that evaluation and testing of hypotheses, and where possible, the selection of a final hypothesis is the scientific method, correct?
Generally, yes.
Is it correct that a proper biomechanical injury analysis utilizes a sound scientific methodology that's been subjected to peer-reviewed and a publication that's been generally accepted in the engineering community?
Well, I can't. So this, I've done my analysis here, biomechanical analysis. I can't submit this analysis to peer review. I'm not allowed to give this to people outside the court. So there would be no way for me to submit my analysis for peer review. So this occurs forensics all the time. The forensic analysis in court generally never goes under a peer review process. The methodologies underneath it and looking at, like, for example, I think I referenced 25 papers in my report. That goes to the issue of trying to follow the science. 26.
So I think you may have misunderstood my question, sir.
Absolutely.
I was talking about your methodology,
Mhm.
your biomechanical injury methodology. The methodology that you use and apply is to be subject to peer review and general acceptance in the engineering community. Is that correct?
So I have no way of publishing this analysis.
I'm
So
sorry, sir,
to
to
get
interrupt
peer,
you.
I need to.
Go ahead and answer your question.
He really thinks
You're
he's
asked
smarter
peer
than us.
reviewed, like you said, means I give it to my peers. I send it out to somebody to review for the scientific method. That's what the peer review process is. So I will gladly send this out to peer review with the court's permission, but I haven't and cannot do that.
We're-
Sir, my question is
Mhm.
not your analysis here in this case.
Oh.
My question regards the methodology that you used here. Is the methodology, you said 26 references, right? My question is simply, is the methodology that you used for your analysis in this matter, is the methodology for a proper biomechanical analysis, should that methodology be generally accepted in the engineering community?
I think with the forensic application, yes.
Okay, that was my question, just the methodology. Thank you.
You're welcome.
Thank you, Denise. I agree. You can't
Now,
dazzle them with
The
brilliance.
scientific method that you've used in this case, part of the use of scientific method, the purpose is to avoid what is called bias in the scientific method, right? Not cultural bias, but just bias in terms of the application of methodologies and principles. You would agree that's a pretty fundamental purpose of the scientific method, is to avoid biases?
The purpose of the scientific method is to get the most logical and correct answer
Logical.
without bias.
Exactly. To do it apply the scientific method without bias being part of the application of the method, correct?
That's hopefully what you can do.
That's hopefully what you can do. That is the goal, right?
That is one of many goals, yes.
So are you familiar with the term confirmation bias?
I am.
And that relates, confirmation bias is part of a larger term. Are you familiar with cognitive bias?
Generally, I'm not a human factors expert, though.
Pardon me?
I'm not a human factors expert.
All right, biases are, don't you agree that cognitive biases are not just for one category? You would agree it applies to medical analyses, it applies to doctors doing studies, engineers doing studies, and other scientists doing studies?
So I'm not a cognitive expert. I think I would generally agree with it, but I don't want to step out of my lane. I'm not an expert on cognitive. I can talk to you about confirmational bias if you
Fair.
like.
Let's talk.
You've already stepped out of your lane, sir, in a big way. And the fact that you are arguing about simple questions makes me think that this is going to go on for days because he can't even answer the simple questions without an argument. Wow, just wow.
About confirmation bias. Now, confirmation bias is actually when someone selectively gathers and interprets evidence to confirm one or another's beliefs, as well as neglecting evidence that contradicts those beliefs. Is that a fair statement of confirmation bias?
That is a statement. Yeah, it could be broader, but sure.
But you would agree that that is generally correct, what
Generally, yes.
confirmation bias is. And an example of confirmation bias is not considering alternative hypotheses once an initial hypothesis has been selected, even though data and information might contradict the initial hypothesis. Is that an example of confirmation bias?
That could be, yes.
And confirmation bias is antithetical. It's against the scientific method. It's to be avoided, correct?
You would like to avoid it, yes.
Are you familiar with the term failure analysis?
Generally, you might need to define how you're using it for me.
Sure. So is failure analysis the enablement of a scientific examination of an alleged incident by beginning at the undesired consequences? Is that a fair use of that phrase?
I was thinking something different, like a piece of metal failing. I guess it could fall into that category.
Okay. And would you agree that the first question, or one of the first questions that are to be asked by a biomechanical engineer when conducting an analysis of, say, an injury is, how did this happen? Is that one of the first few questions that you ask?
No, that's usually the last question.
Oh, so for you.
So hold on a second.
Okay, I'm sorry.
Generally, what you want to do is gather data. You want to know what injuries there are, what evidence there is, like, for example, on the vehicles. And then the very last thing you want to know or define is, given all that information, how did it happen? So that's the end.
I think you may have misunderstood my question, sir.
Again.
I wasn't talking about the method or the process. I was talking about when you get to answering questions, whenever that is in the process. Isn't one of the questions, and maybe one of the first questions, how did this happen?
No, that's not one of the first questions. One of the first questions is, where's the damage? What are the injuries? What's the evidence? What black box or tech stream data do we have?
So he works
what physical
backwards?
evidence was at the scene? So that is certainly not one. It is a question, but that question is at or near the end.
Isn't every one of the questions that you just mentioned part of the data gathering?
Correct. But,
Okay.
but when you're gathering data, you're always asking yourself questions along the way, like, what is this? Where did it come from?
But you would
Why
agree
is he so mad already?
that for you, at least some point, it's how did this happen, correct?
Yes.
And don't you ask that question to come up with hypotheses?
I generally have many working hypotheses as I'm working on the case. And then as the evidence comes in, I'm applying that to my hypotheses and either accepting or rejecting the hypotheses based upon the factual information.
Sir, how then is it just a matter of logic or a syllogism? If you don't ask the question, how did this happen, until the end, how do you then not get your hypotheses up front when, under the scientific method, you should be having different hypotheses up front? How is it that you ask the how did it happen at the end and not go through hypotheses in the beginning? Can you help me with that logic?
Sure, I guess I misunderstood. Like, I was trying to give you an answer to how it happened. So when you're answering how it happened, or you want to be able to answer that question, You want to make sure you've looked at the totality of the data, accepted, rejected, things as they came along, to be able to answer that final question, how did it happen? But along the way, like for example, a right eye laceration, you want to know how that happened. So you look for the evidence of how that may have happened.
So you would agree then that questions of how it happened, formulating and identifying hypotheses, does and can happen toward the beginning of the analysis. It doesn't happen at the end all the time. Would you agree with that?
So the ultimate question of how did it happen happens at the end. The questions about the elements of what occurred to make it happen, those occur at the beginning, middle, all along the way.
You would agree that creating hypotheses occurs more toward the beginning than toward the end of the analysis. Is that correct?
There are probably more hypotheses in the beginning, but I am continually forming, looking at hypotheses, either accepting or rejecting them upon the evidence.
So you would agree that the creation of hypotheses does occur more toward the beginning of the analysis. You would agree with that?
There are more towards the beginning. The process occurs throughout the whole investigation.
Right. I'm asking about the hypotheses, sir. You would agree that the hypotheses occur more toward the beginning than the end, just the hypothesis.
So I don't know if you and I are saying different things. More hypotheses in the beginning because you have more questions in the beginning. You continue to form hypotheses as the data presents itself. So you don't stop the formation of hypotheses. It's just as you get more evidence, you window down the number of questions.
Maybe I can just this last question and make it clearer for you, sir. You would agree, not analysis, which you added, as I heard it to the last part, just hypotheses.
Mhm.
You would agree that even though hypotheses can be created and changed, perhaps all the way up to the end,
Mhm.
you would agree that it's important in the analysis to create at least some hypotheses, plural, in the beginning, correct?
Yes.
Wow. Can you see why a good trial lawyer also needs to be an oral surgeon? Because getting information out of this combative witness who has no reason to be combative if he's got no dog in this fight, right? If he doesn't care, which he also brought out, there's no reason for him to be so combative on basic questions of scientific methodology and hypotheses. It's going to be a long day, my friends. I have a feeling. Maybe go fill up your drinks.
And once you create these hypotheses, would you agree that those hypotheses should be tested?
So if you take the word testing to mean testing compared to testimony, compared to physical evidence, yes.
And when you test those hypotheses, isn't it often the case that particularly in your line of work, the one that most consistently produces the same injury will emerge as the mechanism of injury?
I guess it depends on the scientific evidence behind it. Again, sometimes we get very unique injuries.
So my question, sir, is this.
Mhm.
Isn't it the case that when you have multiple hypotheses,
Well, hypotheses.
the one that
He's taking notes?
most out of all of them, it's a relative
Okay.
thing, the one that most consistent.
The witness is now looking down into like his lap or his whatever's in front of him on the podium. Thank you, geriatric nurse. Agreed. Thank you, Rich Schiffer, for coming in and watching BS Paul's hack. He is like taking notes right now during the questioning. This is also improper. I'm sure Alessi will ask about it.
Produces most out of all of them, it's a relative.
Hypotheses.
The one that most, out of all of them, it's a relative thing. The one that most consistently produces the same injury emerges as the mechanism of injury. Is that a fair statement?
He's writing something down.
I think generally, again, it's on a case-by-case
got a
basis. You
pen
have
in
to
his
look at
hand.
the science and the facts of what you're basing it upon. I think as a general premise, what you're saying is accurate,
Okay,
but there's exceptions.
fair enough. But as a general principle,
Sure.
with some exceptions, that's a fair statement, correct?
Yes, sir.
We're going to have several topics, sir, and what I'm going to try to do to make it a little clear is I'm going to say when I'm switching topics.
Oh, good.
So what I'd like to do now is switch topics.
Okay.
He likes
You're
that.
aware that the Massachusetts State Police has troopers who specialize in accident reconstruction, correct?
Yes.
And there are troopers within the Massachusetts State Police Collision Analysis and Reconstruction section whose sole responsibility is to engage in accident reconstruction. Do you know that?
I do not know that.
Do you know that there are troopers within the Massachusetts State Police Collision Analysis and Reconstruction section who engage in accident reconstruction?
Just based on what I've seen in this case.
Trooper Paul.
Right, based upon what you've seen in the case, that's a fair statement.
And I just know that those people are doing it.
Are you familiar with a Massachusetts state trooper named Joseph Paul, P-A-U-L?
Yes.
And you
Well,
know,
I'm familiar with his reports. I don't know the man.
okay, familiar with Trooper Paul through his reports in this case, correct?
Correct.
And are you aware that he was assigned by lead investigator, former trooper Michael Proctor, to be a reconstructionist in this case on January 29th of 2022, as evidenced by that report or those reports of Trooper Paul? Do you know that?
Well, you put a lot of things in there. I know he issued a reconstruction report. I don't know who told him to do it. So the first party question, I don't know, but I did see a reconstruction report from him.
You were retained, and so do you recall, is it the date, January 29th of 2022? Is that a rough time period of him being assigned, or you don't know when he was assigned?
Don't know. That might have been in his report, but I wouldn't have paid attention to when he received an assignment.
Do
He did air
you
quotes. He did air quotes just now.
know when the date of the first report of Trooper Joseph Paul in this case?
I can pull it up. I do not know off the top of my head.
You know that the date of the incident in question is January 29th, 2022, correct?
Correct.
Yet your firm and you were retained for this case by the Commonwealth 2.5 years after the incident in question. You were retained, your firm, on September 23rd, 2024. Is that correct, sir?
No, I believe we were retained a couple days before that.
A couple days. Okay.
Right.
So
Actually, I might be able to find out if you'd like me to look at the documents.
it's not all that important. You would say it's within a week of September 23rd, 2000. It was in September of 2024.
I believe it was in September, yes.
Right,
I would
so-
want to double check.
That's 2.5 years from the date of the incident in question, if I did the math right, correct?
Oh, I never thought about it. Yeah, approximately.
And as we just discussed, and you stated on your direct examination, you have no dog in this fight, correct?
Correct.
He's going to use that and beat it to
On
death.
November 5th of
Love it.
2024, your firm Aperture was paid $44,500 by the Norfolk County District Attorney's Office to conduct work that was at least similar to the work of Trooper Paul, correct?
I have no idea. I don't get the billing or the statements.
Do you
44,500 to begin.
whether Aperture has Well, do you believe Aperture is working for free in this matter?
Oh, no, I don't believe that. No,
So you
we're an
would,
engineering company. We bill for our time.
so you know that Aperture is getting paid for its work in this case, correct?
We are billing for our analysis work.
Well, you're not just billing, you're billing and getting paid, correct?
So I have not seen any of the payments. I would assume that we're getting paid, but I don't know that.
Sir, you are a senior vice president of Aperture, are you not?
I am.
You would know, wouldn't you, if your firm was not getting paid for work since September 23rd of 2024, wouldn't you?
It's a simple question.
No, probably not. Usually it takes, 9, 10, 12 months of not getting paid before the accounting department reaches out to me.
Oh, really?
Exactly. So you've been on this for 2.5 years. So if it would take 9 months or 12 months, if you weren't getting paid, you would have been notified by that by now,
A year
correct?
and a half.
According to your own answer you just gave.
I've not been on this case for 2.5 years.
I'm sorry, sir. Let me go back to the question of payment.
Hold on. You said I've been on this case for 2.5 years. I was retained in September 17th-ish of 2024. So that's what,
Oh,
less than a year ago.
Understood. I'm moving on to the next question because I want to move away from that
Right.
discussion and just
Okay.
go right
About
to
8
the bill.
8 months ago.
You, as you sit here today, do not have a recollection of whether Aperture has been paid. Is that your testimony?
It has nothing to do with recollection. I'm not part of that process. We have an accounting department. I don't have any involvement in that.
Are you, so is your testimony you have no knowledge about any contractual relationship between Aperture and the Commonwealth?
Oh, no. I was sent a contract by the Commonwealth
Oh, no, no.
signed. So I'm aware of the contractual agreement, but the day-to-day or month-to-month invoicing and billing, I'm not involved in that.
Okay, so you're aware there's a contract between Aperture and the Commonwealth,
I signed it.
and you signed it. And wasn't that contract obligating the Commonwealth to pay for the services of Aperture? Isn't that the purpose of the contract, in part?
In part, sure.
Yeah, it's a legal obligation of the Commonwealth. Your firm does work and the Commonwealth pays for it, correct?
That's the idea.
Right. And so you know about that contract because you signed it.
Correct.
Also, you testified on direct that there was a purchase of a Lexus exemplar for your testing.
Correct.
Who pays for that Lexus
Yes.
exemplar?
Aperture?
And is that then cost passed on to the Commonwealth?
No.
So you pay for the Lexus, you don't pass that cost on, correct?
So what we're doing is we paid for the Lexus. We're keeping it till the trial's over. We're selling it and charging the Commonwealth the difference in the price.
Exactly. That was where I was going, sir. So,
But they're only paying the difference. So, and in theory, if we sell it for more in California, then we'll reduce the bill.
okay, I don't want to speculate. I just wanted to see what the obligation was. So
The
if
obligation is the difference.
Exactly. So the obligation is the difference. Are you aware that on April 5th, 2025, the Norfolk County District Attorney's Office amended your contract? Are you aware of that, sir?
Oh.
I am.
And isn't it the case that that amendment authorized the amount of $325,000 to be paid to Aperture? Isn't that what that amendment contract states?
I believe that's correct.
So the Commonwealth
325.
is obligated to pay at least $325,000. And is that correct?
That is you're asking me a legal opinion now about a contract. That is
Really?
my understanding of how contracts work, but I'm certainly not an attorney.
And on top of that,
You're certainly not an attorney, but you did sell your company to Aperture for something like $270 million. So to sit there with that smirk on your face and insinuate that you don't understand how this works is ridiculous. They were already billed $44,500. We don't know if they've paid that. And then again, the contract was amended to $325,000. Guess how much ARCA was? I mean, now you can ballpark how much ARCA was. Hell, a lot more.
Are you aware that Aperture has been already paid $44,510 for its work? Are you aware of that?
The second time you asked me, no, I'm not aware of anything we've been paid.
Don't be so rude. Do you think the jury is
And as you stated yourself, those amounts reflect, as you say, less than 6 months worth of work?
That's not what I said.
Well, no, my question is, you've been on the case, you said, since September of 2024, when we were talking about dates. You said that was about 6 months that your firm's been retained. Did I have your answer correct about how long you've been on it?
I guess it's closer to 8 months.
All right, so 8 months. So for 8 months of work,
it's like
about $400,000. Is that correct?
So there's 3 offices working on the case.
Oh,
There's the Boston office, there's Mr. Burgess's office, and there's my office in Long Beach. I only know about the billing from my office.
But you signed the contract on behalf of all of Aperture, not just your office, correct?
That I don't know, but I definitely did sign a contract.
Would it refresh your recollection as to who you signed the contract on behalf of, whether it's all of Aperture in all offices, if I showed you the contract?
Sure.
May I put you on it?
Yes.
this guy is combative for no reason.
Sir,
Could you direct me so we're not wasting time?
well, it's your, what I'd like to do, Your Honor.
Can you direct me so we're not wasting time? Your entire testimony is a waste of time, sir. I have all the new motions, or I have 2 of them. I don't know how many there are, but I've got them. We'll look at them at the break.
With the witness, Your Honor, is just ask the witness a question with regard to it.
Why don't you just take a look at that, Dr. Burgess?
Thank you, Your Honor.
We're a little behind, but I just want to watch Alessi's facial expressions, so I'm not scooching quite yet.
And then when he's done, Mr. Alessi, you can take it back to the podium.
Yes, Your Honor. Thank you.
It's not a good look. It's not a good look for this witness. I don't know that the jury is going to appreciate this seemingly combative nature of this witness for no apparent reason. Somebody asked about declaring him a hostile witness. That only happens when you call the witness. He's automatically a hostile witness because he's on the other side, and he wasn't. He's on cross-examination by Alessi.
So go ahead and start with me first. Go back to the podium, please.
Sure.
Thank you.
Thank you, Your Honor.
She's treating him like such a child. Oh, I just can't.
Dr. Welcher, does that refresh your recollection as to the contract you signed on behalf of Aperture with the Commonwealth?
So it lists the legal address as my office. So for my office, yes.
So are you saying that therefore, and did you see the amount that was in the contract? Did that refresh your recollection?
Oh, no, I didn't even look at that.
Do you recall the amount that of obligation that the contract relates to in this document? Do you recall that?
You just asked me that earlier, and I'm taking what you said to be true. So I was like $325,000. I have no reason to disbelieve that.
And is there also a total, do you recall the total maximum obligation for the contract that's listed in the contract? You
No.
recall it? May I approach, Your Honor?
Okay.
Yeah, what's the total maximum amount?
And Dr. Welcher, I am now going to, you asked me last time, I hope this is helpful.
Please.
You said, please point to the applicable part so we can do it faster. I am now pointing to that part and see if you can just look at that and see whether this refreshes your recollection on the maximum obligation of the contract pursuant to this contract. Without saying what it is, just does it refresh your recollection?
No, but I don't have any reason to believe it's not correct.
They're all
And
prepped
that
the
is my
same way.
signature on it.
Didn't ask me that question. Now he's helpful. If they ask you if it refreshes your recollection, just say no.
And we got started on this conversation tying it to, well, we got started on this conversation with regard to a statement you made earlier in your direct that you didn't have any dog in the hunt. You recall that statement in the beginning of your direct testimony.
Dog in the
Misquoted me. I don't have any dog in the fight.
You
Oh.
don't have any dog in the fight.
He was good.
Thank you. Now, switching topics,
Okay.
you submitted
He's not a golfer, clearly.
an updated PowerPoint presentation, the one that you went over on your direct examination. You created that presentation quite recently, correct, sir?
The updated one was where I had redacted or taken out slides. So in terms of taking out slides, I did add one alternative path a couple weeks ago.
Okay, my question, sir, is this.
Mhm.
The updated presentation, we'll get to the changes later, but the updated presentation, you created just how many days ago?
I'm gonna say weeks ago.
Weeks, 2 weeks?
I don't actually know without looking at the documents.
Well, was it more than 3 weeks ago that you created it?
I still don't know without looking at the documents.
Do you know when the trial started in this matter, sir?
I do not.
Assume the trial started approximately April 22nd of 2024.
Okay.
Did you create your updated presentation before or after April 22nd of 2024?
I don't know.
25. It's 25. It's 25.
Do you know when?
Hold on one second. Dr. Welcher, I'd ask that you not do.
Not look at,
anything.
okay, I was gonna try and answer his question. My apologies. I will shut it
He's got
down.
notes. Oh, I will shut it down. He's on his
What?
laptop now looking for answers. What are we
If I may, Your Honor,
doing?
continue. Are you able to determine when you created the updated presentation?
I think so. That's what I was attempting to
Your
do.
Honor, may he do that?
Yes, I'm going to see counsel at sidebar while you pull that up.
He's got a laptop. He's taking notes. This is not an open book test, sir. She needs to get better control of her courtroom and she needs to shut this nonsense down. This witness should not be taking notes. He should not have a laptop in front of him. He should not be reading, Googling things while he's on the stand. This is outrageous. It strains credulity.
You need for Dr. Welcher, what I'm going to ask you to do is get whatever information you need for Mr. Alessi's last question. Mr. Alessi, I need you over there. So,
Yep.
what I was saying,
and once you get that answer, I'm going to ask you to shut your computer down, or at least put down the cover. Thank you. All right, so you can answer Mr. Alessi's question.
Thank you, Your Honor.
Could you give me the
Thank you.
question again, please?
Court reporter, supporter.
When did you
Exactly.
create the updated presentation that you reviewed in your direct testimony?
So that addition I made was taken out. It wasn't in my
Good,
direct
sir.
testimony.
If you can just hear my question, it's this.
This is so big.
The version of the presentation that you put on the screen,
Mhm.
when did you create that version? I'm just looking for a date.
So to answer your question about the version on the screen, I created that yesterday when the judge asked me to take off some of the headers. So yesterday.
Okay, good. Now, the version before that you created yesterday, when did you create that version?
The day before.
And then the version before that one, when did you create that?
I mean, I save it every day.
Understood.
So every day.
So you've changed the presentation every day since when?
No, I don't think I've changed the presentation every day.
That's my question. My question is, how many times have you changed it within the last 2 weeks,
I gotta take
your
my notes.
presentation?
Let me try and cut to the chase here.
Sure.
That slide was added on May 13th, and then it was taken out before I presented it here. So it was not in my presentation here.
Right. So thank you for that answer. So
May
to
13th.
the question. Your first version, as I understand it, of the slide presentation was January 30th, 2025. Is that correct?
Correct.
When was the next time after January 30th, 2025 that you changed that presentation?
May 13th.
Assuming the trial started April 22nd of 2025, you changed your
Taking
PowerPoint
notes.
presentation during this trial, correct?
Correct.
And how many times did you change your presentation after April 22nd of 2025?
Well, the last time I changed it was like 10 minutes ago. So in response to various discussions, I've been making continuous changes to it.
I want to make sure you finish your answer, so I didn't
No,
interrupt you.
I'm not sure how much granularity you want to that answer.
Right, so you
Keeps
created
changing.
on January 30th, 2025, you made your,
13th.
pardon me?
Oh, the original one. Sorry,
Yeah.
January 30th, modified May 13th.
Right, if I could finish my question, and I might be able to shortcut this, thank you. So you created the original one on January 30th, 2025. You made your first amendment May 13th of 2025. And then before you sat for your testimony, which was yesterday, correct? That was the first time you sat for your testimony.
That is correct. I was here yesterday.
Days get foggy when we're in a courtroom, but it was yesterday. How many times had you changed your presentation from January 30th, 2025 until when you first walked in the courthouse yesterday?
Do you mind if I count?
Not at all.
So there was the May 13th change. Half of that was in response to objections from the defense. I had to add all the paths to where everything was. Then when I got out here, Mr. Brennan asked me to take out references to evidence about statements that I was not allowed to present. So that would have been within the last 3 days. And then I've modified it a couple times today based on rulings from the judge.
Okay, let's break that down. You said half of the changes you made on May 13th related to
Objections from the defense.
what? Because I want to know about the other half. that
Sure,
you
there was
didn't
two
state.
changes. I added the extra path of 138. And then I was told that the defense was having problems with my PowerPoint. So I had to go in and add the paths to every single slide about where the evidence came from, because they were saying I didn't provide everything, and I had provided everything.
All right, so
That was the second half.
got it. I want to go to the first half, sir.
Sure.
And I'm going to try to shortcut this. And
Please.
if I'm not clear, you just let me know. I want to talk about the first half. You called it, I didn't hear, it was like, did you say path?
Path.
P-A-T-H?
Correct. The path Miss Reed was driving.
Right. The what you made the change for May 13th, that first half, that wasn't something that was triggered by the defense. That was something irrespective of the defense, correct?
It was based upon her statements. Is she part of the defense?
All right, so
She's
that's what I wanted to get to.
Defendant.
You changed the first half based upon statements you allege that Ms. Reed made. Is that correct?
It's because I changed one slide. There was 130 slides originally, or something like that. So half of the changes on that day, which was one slide, I added one line to the bottom of the previous slide.
Did you consider that change significant?
No,
Well, then why did you make it in the middle of trial if it wasn't significant? Why didn't you just leave it off and then discuss it in terms of testimony?
so A, it ultimately was left off. B, because it was insignificant and I didn't need to have it. So the way it got presented was exactly the way it was before May 13th. So It didn't change anything.
Something
But
funny?
it was
Mr.
significant enough for you to make a change to your presentation, correct?
So my goal is to be as accurate as possible. So when I saw the path that I gave, the way she could drive, I gave the possible paths. That was one of the possible paths that hadn't originally been included. So in striving to be as accurate as possible, including as much information as I could, I wanted to make sure I included that.
So you were striving. The clip that you used to make the change, you say you made the change based upon a clip you observed with regard to Miss Reed. Is that correct?
I believe that, yes, that is correct.
Do you know that clip has been in existence for months?
I don't believe I got it until April.
So a clip that has been, assume the clip's been in existence for months. You just got the
Hold on,
clip.
Dr. Welcher, I have to ask you
Oh, I'm
not to
sorry.
refer to
I'm
that.
trying to be helpful.
Close your
Yeah,
computer.
let me close it.
This
Sorry.
is-
I was trying to answer his question.
Where are we? First of all, instead of path, I wish that they would use the word route, the route that she took, not the path. The path to me is a scientific thing. The path to his opinions, I don't know what the hell they're talking about. And these clips are the video clips of Karen's own statements that have been shown in court. Has he been watching the trial? I need to know that. He needs to shut his effing laptop and get with the program, act like a professional, and stop arguing. I think this is going horribly for the Commonwealth. I don't know if the jury's going to get annoyed with Alessi for harping on this stuff, but this is all important stuff. It all goes to his credibility, his methodology, the way that he arrived, his opinions, his pompous ass nature. I don't think is going to help him, in my opinion. This is really, really painful. It's painful to watch. It's embarrassing to listen to. It should not be this difficult if you are a professional expert to just simply answer the question. How horribly is he going to argue when it gets to the substance of his opinions?
I'm going to ask you to close the top.
Yeah, that's probably a good idea.
Just flat down. Thank you.
Thank you, Your Honor. So assume the clip that you
I thought he closed
said
it
was the
before.
basis for changing your PowerPoint on May 13th after the trial started had been in existence for months. You just got that clip, you say, in April?
I believe so, yes.
What was tell me the circumstances by which you got the clip. Did you ask for it?
I was told there was a new interview.
Was told by
Okay.
Tully? Who told you?
Who
Tully?
initiated the conversation about the new interview?
I don't know if it was Mr. Brennan.
It was someone associated with the prosecution?
Yes, I
Brennan?
wouldn't have known about it.
Exactly. So somebody affirmatively communicated with you when about this clip?
I need to look, but I remember it being about mid-April,
Mid-April.
if I'm thinking of the correct clip.
What were you asked to do, if anything, with regard to that clip?
When I got the clip, I wasn't asked to do anything.
What did you do with the clip once you got it?
So they then indicated there was this suggestion of an alternative route. So then I looked at the alternative route description and added the alternative route.
So it was suggested to you by the prosecution that you look at the clip and they pointed out that there was an alternative route they wanted you to look at?
So I took it to be, we have additional evidence. Please look at the additional evidence and add it to your analysis.
I need a lorazepam. Maybe some arsenic. I don't know if the defense can see that he's taking notes on the stand. We can see it because of the camera
On the
angle.
topic of additional analysis by Aperture, while this trial is going on, are you aware of Mr. Burgess submitting a report dated May 8th of 2025 in this case?
Yes, I received that report on May 8th.
Right. And so you were aware of the creation of that report on May 8th because you got a copy of it, right?
Correct.
were you aware that Mr. Burgess was intending to submit that May 8th report to the Commonwealth?
Yes, we'd had a discussion before that he had found new information that changed the timing.
Oh, he had found new information. What is your basis for saying he found new information as opposed to the information always existed? It's just it was pointed out to him that that should be looked at. What's the basis of your understanding that he found new information?
Objection to the question.
Sorry,
I'm going
why?
to allow the question, but you have to ask it differently. Mr.
I will, Your
President.
Honor. Thank you. What is the basis for the statement you made that Mr. Burgess found new information?
I guess it was his meeting in our discussions. He indicated that he had found new information.
Did you ask him, what do you mean by new?
No, I took it at what it said.
So do you, as you sit here today, have any basis to say that that information is new as opposed to it's always been in existence?
Yes,
What is that?
what he told me.
Oh, so you relied upon the representation of Mr. Burgess. You didn't have any independent document to determine whether in fact it was new.
I don't quite frankly care whether it's new or not. I just care what's in the data, whether it's new, old, I don't care.
He doesn't care about anything.
It's not relevant to what I'm doing.
He doesn't
I
care
don't
about-
say this is new data, this is old data. I just care what the data is.
He doesn't care about getting paid.
Has Aperture ever submitted a report, a changed report in the middle of a trial to your knowledge?
I have no idea.
Do you know whether Aperture has ever submitted an amended report in the middle of a trial? You said you testified in federal and state courts. Can you recall one instance where Aperture has submitted an amended report in the middle of a trial?
So Aperture is like 290 people.
Like,
I can only speak for myself.
oh, like,
I have certainly done amended analysis. Only certain courts and certain legal systems require reports. But for example, rebuttal, analyzing testimony that comes up in court, getting trial transcripts. I very frequently have come up with new analysis during the trial.
Sir, my question is, as you sit here now, can you state one court case where you or Aperture has submitted an amended report in the middle of a trial?
I cannot speak for Aperture. I can only speak for myself.
Can you answer, speak for yourself, sir. Can you then for yourself recall any instance where you submitted an amended report in the middle of a trial?
Amended reports, no. Amended analysis, yes.
Thank you.
You're welcome.
there's a woman
Mr.
facing
Alessi,
life
is
in
this good
prison
time for
and
break or
It-
5 more minutes?
he doesn't care.
It's a good time, Your
He doesn't
Honor.
care.
All right, folks, why don't we take our morning recess? Again, Dr. Welcher, I like behind.
You didn't s-
Love to do the rest.
He goes, I'd love to hear the rest of it. Hold on. Did you just hear that hot mic moment? Listen to this. Why don't we just take a break? We just got started an hour ago. Maybe. Listen to his hot mic.
For break or
It-
5 more minutes?
It's a good time, Your Honor.
Okay. All right, folks, why don't we take our morning recess? Again, Dr. Welcher, I like behind.
Great. Love to do the rest.
Love to hear the rest of it. What is he going to love to hear? Oh, love to use the restroom? I thought he said I'd love to hear the rest of it. Okay. There are no words, really. There are no words. I'm usually never at a loss for words, but right now I just have no words to explain how insane this is. So let's go to some questions. Massachusetts is having a visceral reaction to this witness. I think you're not alone. Bruni Saint tuning in from Australia. Good day. Good day to you too. This is just because I'm looking forward to Alessi showing the world how bad a person Welcher is at his job. Thank you for that. Susie points out there's a document filed in Massachusetts in 2011, Society of Automotive Engineers, that debunks Welcher's work and much more. Thank you. I haven't seen it, so I'm not familiar. Tracy Giuliano, everyone is saying that the 4 witnesses on the list to authenticate the records are Proctor's school buddies. Yes. Yes, Tracy. Yesterday, after I went back after the show and went through the chat, there was someone in chat who said, I went to high school with all of those people, and all of those people on the amended or supplemental witness list from yesterday are people who are on that text chain with Proctor. So I'm glad we solved that mystery. Thank you for reminding me to address it today. We are all Karen Reed says, after yesterday's all-day direct, I discovered a new level of discomfort beyond hangry. I call it hankry. Hankry, having to hear Brennan go unchecked by Cross. Portia Milner wants to know, why can't Judge Cannoni make a decision at the bench? It is rare. It is few and far between. We rarely see it. It just is. That's just the way it's done here. Hard plastic and static mannequin, adding to the prior comment, Judson Welcher was deemed unqualified to testify in a Massachusetts court case in 2022. Thank you for that. Same thing happened, though, with Jessica Hyde, remember? And the judge wouldn't allow it in. Annie says, my autistic son walks past the TV yesterday and asks if he's a bit old for finger painting. Thanks, Annie, for tuning in from across the pond. Whatever Clever wants to know, are you in 11-year-old New York Times video, The Shame of the Catholic Church? I don't think there's a video, but I'm sure there are a lot of articles. I did sue the Rockville Central Diocese on behalf of 50 or 60 victims of clergy SA. That case goes back to 2002, so I'm not sure what you're looking at. But yes, I am the same attorney, Melanie Little, that was involved in the cases against the Diocese of Rockville Center here in New York. Crafty Councilwoman, Cross is going to be lit, and I'm here for it. Welcher is insufferable. I'll probably rage finish this blanket today and start another one. See? We have a Rage Crochet Club for those who are interested. Thank you, Glenn Suze. I have that motion. Rule 14 violation, trying to kneecap ARCA. I have that already. Don't worry about it. Why don't we take a look at it now? Since we seem to have a moment while they're on break, and we might as well get it while it's hot off the press, as it were. This was filed this morning. It is docket number 698, docket number 698. This is the Commonwealth's motion to preclude the attempted use of any information not produced in violation of Rule 14. Both the Commonwealth and defense are bound by Rule 14 obligations. During the course of this trial, notably during Shannon Burgess's testimony, the defense presented documents that were not previously provided, which eliminated the ability to review and vet the documents. Notably, the defense presented a CV provided in 2023 that noted a graduation date of 2024. The effort of providing documents as a witness is being confronted with documents is improper, trial by ambush, a violation of Rule 14, and creates needless delay, resulting in objection, unnecessary sidebars, and a waste of time for the jury. The Commonwealth seeks a ruling precluding the use of any materials that were not noticed by the defense other than materials in the witness's CV referred to during presentation or discussed during testimony. This was stamped, it looks like today, 9:30 this morning. Today's the 28th. Yeah. So apparently, we've discussed this before in this courtroom. This judge was requiring the attorneys to turn over any impeachment evidence. However, I don't know if something like this would have been required to have been turned over. And therefore, he was caught in several lies about his qualifications and his representation of his qualifications over the years and the filings in federal court having to do so. There seem to be many, many versions of his curriculum vitae, and he was impeached with it. And Hanky's mad, and he wants mommy to issue a ruling to save him. Yeah, he wants to blame them for not doing his homework. 100%. Here's docket number 699. This was also filed, looks like today. And this is a trial memorandum on expert opinions. We'll get through as much as we can before this break is over. The Commonwealth intends on asking Dr. Welcher, based on his review of all the evidence analyzed and reviewed, a number of opinions, including but not limited to: 1, whether his opinion of whether the lacerations on John O'Keefe's right forearm and arm are consistent with contact with the Lexus right rear tail light. 2, whether his opinion is that the Lexus collided in a clipping or sideswipe manner with John O'Keefe. And 3, whether the collision occurred at substantially the same time as the reverse maneuver, which he identified from the Lexus's trigger event at 1162-2. Important to point out that she already ruled on this earlier this morning, but we will keep reading so that we have a little more insight into what it is that she ruled on. So I imagine this was the date on this. It was filed today and it's dated today. So when did they turn this over? Who knows? There are no rules here. They can do whatever they want. They go on to say in paragraph 2, expert testimony on matters within the expert's field of expertise is admissible, even if the expert's opinion touches on the ultimate issue. On the ultimate issue that the jury must decide. See Commonwealth v. Mendrea. And whose filing is this? It doesn't say. Yeah, this is Hank Brennan's filing. Of course it doesn't say. It doesn't say Commonwealth's trial memorandum on expert opinions. It doesn't. They're on break. Don't worry. I have the fan up. And they cite some case law. The only limitation is that the subject matter discussed be within the witness's field of expertise and that the witness not directly express his views on the defendant's guilt. Citing some other cases. The Commonwealth is not asking Dr. Welcher to provide his opinion whether the defendant was under the influence, negligent, reckless, or had malice. The Commonwealth's expected opinions are admissible because they are within Dr. Welcher's field of expertise based on the evidence he relied on, and they are not directly expressing or opining on the defendant's guilt. Additionally, but separately, these opinions directly rebut what was said by defense counsel repeatedly, that there was no collision. I just want to point out that opening statements by attorneys are not evidence. Opening statements are designed to say what the attorneys think the evidence will show. And in the opening of the defense, they did say the evidence will show that there was no collision. They didn't say those exact words, but it is implied there was no collision. That is what the evidence will show. Trial law students 101 understand that, but not Mr. Brennan. Additionally, but separately, these opinions directly rebut what was said by defense counsel repeatedly, that there was no collision. The scientific evidence, specifically Dr. Welcher's opinions, directly refute defense counsel's opening statement. For example, the defense asserted that, quote, the evidence in this case will establish above everything else 3 points. There was no collision with John O'Keefe. There was no collision. There was no collision. Similarly, quote, John O'Keefe did not die from being hit by a vehicle, period. Because at the end of the day, folks, there was no collision with John O'Keefe. You will learn that John did not have a single injury consistent with being hit by a car. Let me say that again. The evidence will establish that John did not suffer a single injury on his body consistent with having been hit by a car, not one. Further, nothing consistent with a car accident, despite the Commonwealth's contention that he was slammed into by a 6,000-pound SUV, not a bruise. Dr. La Posada will tell you with medical certainty, and in fact, John was not struck by a vehicle. Dr. La Posada will tell you with medical certainty, and in fact, John was not struck by a vehicle. Medically and scientifically, he could not have been struck by a vehicle. Therefore, as I said, there was no collision. Folks, the science will not lie. The physics cannot lie. And that science will tell you with certainty there was no collision with John O'Keefe. The defense cited Commonwealth v. Coleman without providing a copy of the case or a summary. Oh my, do you not have Google, Mr. Brennan? Citing a case name does not make the case relevant or applicable. In Coleman, the medical examiner testified that in his opinion, the cause of death was, quote, homicide. The court referenced Commonwealth v. Lannon, opining the better course was to exclude such opinion testimony, but here it was innocuous. In the Lannon case, accident was offered as a defense and homicide could be taken to contradict the defense theory. Here, homicide does not seem to have such a contradictory implication as to the defense theory of self-defense, i.e. justifiable homicide. In Lannon, the medical examiner went into detail about the autopsy procedure he had followed to reach the conclusion of death by, quote, gunshot wound of the chest, massive hemorrhage, and homicide. And the jury could not have imagined he was expressing an expert opinion on how the shot came to be fired, as opposed to the results of the shot. Based on the data, physical evidence, and expertise of Dr. Welcher, in his opinion, to a reasonable degree of scientific and engineering certainty, that there was a collision between the defendant's SUV and John O'Keefe that occurred around the time of the defendant's backing maneuver in front of 34 Fairview Road on January 29th of 2022. XOXO. Hank Brennan, specially appointed district attorney, Adam Lally, assistant district attorney, Laura McLaughlin, assistant district attorney, and Caleb Schillinger is in on this one too. He's their appellate counsel, also as assistant district attorney. She ruled on that earlier this morning, and she did rule that he was allowed to testify as to his opinions, but not to say that, in fact, John O'Keefe was hit by a car. And here we sit, still waiting for them to come back from break. Back to some more questions. So that was docket number. Those are the two new filings from this morning. 698 and 699. So the next one will be Lucky 700. Lucky 700. It just... Tequila is now my social lubricant, says so Bev is allowing paint exhibits from this clown. It's beyond me how she can try and stop Crash Daddies from disputing this hodgepodge theory. Well, I don't know if she will after this. Alessi is my hero crush, says, thank you for your super chat. From Australia, apparently text stream data on this model of Lexus has date and timestamps, but not shown by Hank. I don't know where that came from, and I cannot confirm or deny. Guess we'll see what the defense experts have to say in their case in chief, if it ever starts. Richie Rich, thanks for the 10. If the acceleration going backwards, how to wheel spin, and the snow at 1232 was very light, there would have been skid marks on the road, right? Well, I'm not a biomechanical engineer or an accident reconstructionist, so I don't know the answer to that. But I guess we can hear more expert testimony. We know that they didn't find any skid marks, but there was snow. They can't have been expected to do a great investigation, right? I don't know what the coefficient of friction would have been. I don't know how much. We know there was enough snow to track a cat. I don't know if that would have led to skid marks or not, so I cannot give you an answer on that. Angie, what did Judd take out of his pocket and just put on the stand? Look, I don't know, but he had a laptop up there. He was taking notes for sure. He took out, I don't know, but we can go back, or you can go back and see if you can figure it out. All kinds of impropriety was going on the stand. He had his laptop open. He was reading off of it. My head has popped off. It's currently in Connecticut. It's on its way north to you guys. If you see it, could you send it back to me on the ferry? Thank you. Expert architect. We did the hat and the nose, and she turned into a newt. So if she weighs as much as a duck, then she's a witch. I believe that's a Monty Python reference. Expert architect, and I will always allow it. Llama's mama from Texas said, I guess Mr. Welcher wanted the name of his executor. Thank you to I do not recall for gifting a membership, and also to Anne for gifting a membership. You guys are amazing. Leanne said she emailed me that information about Welcher being excluded from another case. Thank you very much for that. The new motion from this morning, Crystal Pond, thank you for that. We just went over it. KW Dredd, he's getting his He's getting his back in. I don't know what that is. A drop for Shannon Burgess. This guy is literally running the courtroom. He's the judge. He's the one doing the cross-exam, and he's working the jury as well. Get this sassy dude out of here ASAP. Thank you. Narrative proctored and approved from Australia. Ah, yes, Dr. Welcher backed his theory up to 50 feet at 3/4 throttle, ran a snowless cosplay crash demo, ignored medical evidence and phone data, science-ish storytelling at its finest. Yes. Thank you for your super chat. KS Mass says, he reminds me of Michael Scott from The Office, but I can't take him as seriously. Thank you. Chastity Danielle, thank you for gifting a membership. Debbie Marie says, so very happy you made the 100K, been on replay, made a live on time today. Love your snark and analysis. We'd be excited to see your silver award. Thank you so much. It takes a couple of weeks because I guess they got to make sure that the subscriber count is accurate. There's no bottery involved and stuff like that. But we'll do an unboxing if and when it arrives. Thank you so much. Just Me says, Welcher sounds so hard. Welcher works so hard to sound like an expert in everything. And to me, an actual MD, he sounds pathetic when he responds. Thank you, doctor, because I value your opinion more than I value his. Expert architect pointing out that the Norfolk DA's budget for year 2025 is $14.8 million and change. Thank you. And we know now that they've already paid $44,500 to Aperture, and they extended their contract for another $325,000 just to pin it on the girl, just to replace Trooper Paul's ridiculous theory and replace it with another one, another ridiculous theory. No, I didn't hear this. Did expert witness for hire, BS and BS, UF Shannon said, did you hear Bev call Welcher Dr. Burgess? No, I didn't. But if the shoe fits, right? Wow. Wow. Crystal Pond says, my husband's tired of hearing me talk about Alessi. He knows I love smart men. Tequila is now my social lubricant. Thanks for the super chat again. I love Alessi, but I feel he's off right now. Is it just me? No, I feel like he's trying to get answers out of a very, very difficult witness, and it is like pulling teeth. But he needs to get the answers because the answers are important. And if he argues that much about the minor things, how greatly, how strongly is he going to argue, Judson Blair Welcher, about the important stuff? This is the guy that mansplains. Yes, if you seek Amy, yes, yes, yes. Terry wants to know if Welcher factored in John O'Keefe's BAC, which we know was 0.28, according to his vitreous humor, and that was taken at autopsy a few days later. I don't know if he mentioned that in his direct anywhere. Did he? I don't know. I don't think so, but I'm sure it's coming. On top, thanks for your super sticker. Kimberly, rent money for your head bucket. Thanks for the 10 because my head has popped all the way off. It's insane. Spock's brainworm says if this is honesty, his best if this is honestly his best, he should consider a career change. Embarrassing and pathetic. Thank you for that. Private info. Thank you for a very generous $50 super chat. Says this is insanity. How is Bev still on the bench? And 2, how is she winning some huge award? Oh, she was honored as Person of the Year last Wednesday at the Norfolk County Bar Association dinner. Person of the Year. Someone needs to bring some beer to my office ASAP. Yeah, can we DoorDash you? I don't know where you are, but I would if I could, but I don't know. And I suggest you keep your info private, as in your username. But thank you so very much for your very kind and generous super chat. You're amazing. Deleted comment queen. Can you imagine if the ARCA guys were questioning Dr. Welcher? Beam me up, someone. Thank you, Melanie, for keeping us somewhat sane. Prayers and much love from a sunny UK. Oh, I'm so happy it's sunny for you guys today. It's not today. It's dreary here. Dreary, rainy, and cold. Cheryl with an S. Hello from the buffer zone. Hey, buffer zoners. Hi, guys. Stay warm. I don't know what the weather's like in Dedham today, but free Karen Reed, 100%. Thank you for watching. You guys, we share in your outrage, and thank you for being there and for supporting. New Hampshire woman is loving Alessi's slice and dice. Motion for the BS button, says Mrs. Bouquet. I don't know why this actually does make noise, but I guess because my mic has like the background, reduce the background noise. Let me unreduce the background noise and unreduce, automatically adjust the volume. Tell me if you can hear the BS button.
Oh, come on now. That ain't even bullshit. That's horse shit.
Can you hear it? Because it actually speaks. Not as good as the Mr. T keychain. I'll play it again.
Warning,
I don't know if you could hear it, but I got to reduce the background noise and adjust the mic volume. Thank you, Mrs. Bouquet, for reminding me to do that. You could hear it? Okay. So when I hold it up and press it, because the mic is reduced, it's you can't hear it, but you can also hear if I do that again, and I will because it's fun. I would like you to hear the Mr. T keychain because it too can be very appropriate for this trial.
I pity the fool.
I pity the fool.
Don't give me no back talk, sucker.
Don't give me no back talk, sucker.
Don't make me mad.
Don't make me mad. Oh, that's a good one. I'm going to remind myself that's the middle button on the right side. Don't make me mad.
Don't make me mad. Shut up, fool.
Shut up, fool. Bottom button. I got to make a little key for myself.
First name, Mr. Middle name, period. Last name, T.
And then we have, what's this one?
Quit your jibber jabber.
Quit your jibba jabba. Quit your jibba jabba. Loving it. I'm loving it. I have to make myself a key so I can use it. Thank you. This is a vintage Mr. T in your pocket keychain. I don't even know if you can get this anymore. So I guard this with my life because I don't have that fancy sound effects that a lot of other channels have. Changes. At Midnight Mike, I put it on the list. We have a mixtape for this trial. It is in the show notes below. It's on Spotify. I think we're up to something like 12 hours of music. All kinds of music, because I think in song lyrics, and many of you do too. Maybe I'll pin it in the chat. Dirt McGirt, was this guy Shannon's college? This goofy mofo. Maybe. Oh, I hear the sound. I'm just disgusted. Thanks, Cat Q. Needs wine. No judgment zone. Mary, thank you. Patio. Thank you, Patio. Are the Commonwealth experts coached to be this difficult? I'm beginning to wonder, and I think yes. I think they are. If they ask you if something's going to refresh your recollection, just say no, and then they won't be able to get it in. And we can dodge that bullet. Yeah.
All right, whenever you're ready, Mr. Alessi.
Thank you, Your Honor. And if I could please address an administrative matter that I wish I didn't have to address. Dr. Welcher was just using, at least my observation, his computer. He still has monitors on his desk. Could we have all that removed?
I mean, are you kidding?
It was
Closed, yes.
Would he open?
So it's just, did you just turn it off?
No, but I will. I closed it.
How about take it away from him? This is like a child
Like,
who's
want the
cheating on a
computer
test in
all the way
school.
off, or just everything.
Is he going to need to turn his computer back on?
I do not see a need for the computer to be turned on. Do we have the ability
Thank
to
you.
put the presentation and documents from our
So I'm
sub?
going to see counsel at sidebar,
Sure.
please.
Please do, because he's also been taking notes, Your Honor. Netwoman wants to know if Brennan is sending texts on laptop. I'm wondering too. I would say, can we see your computer? Can we see what he's doing on there? He could be doing anything. We don't know. Let's see who's in the press box today. Oh, that's a nice man from Canton Community TV. Does anybody know his first name? I forget his first name. Steve. I don't want to misname him, but he's on the left hand of the high top there, and he's so nice. He sends me video and he lets me use things that he's amazing. Canton Community TV is doing the Lord's work. Doing the Lord's work. Do we need to chalk on agreed terminology, Melanie? I think at this point we do. Everyone, don't forget to like the stream. You have to do it daily. It always trips me up. Thank you, Press Your Duck.
I'm sorry?
During the lunch break, I know it takes you a while to set up in the
Yeah.
morning. I'm going to ask you to take all
Tim,
that
it's
down
Tim.
during the
Hi,
lunch break,
Tim
okay?
from Canton Community TV. I love you. We love you. You're doing it all. You're doing all the good stuff. Thank you for your
May I,
service.
Your Honor?
Yes.
Thank you. Dr. Welcher, we left talking about the amendments you made to your PowerPoint presentation. And in terms of the amendments, are you aware that the defense counsel received your amended PowerPoint presentation at 3 p.m. on Memorial Day? Are you aware of that?
No.
I'm sorry, what? I have to hear that again. Because we are in the land of the lost. We have to put up Chaka, and they just received his whatever, something on Memorial Day, which was 2 days ago.
Amendments terms of presentation, about the amendments you made to your PowerPoint presentation, and in terms of the amendments, are you aware that the defense counsel received your amended PowerPoint presentation at 3 p.m. on Memorial Day? Are you aware of that?
No.
It's Chaka because we're in the land of the lost.
Began testifying the day after yesterday, correct, sir? Day after Memorial Day.
The day
I
before his
testified
testimony.
yesterday.
Yes.
Can't make this up. That's not trial by ambush? Okay. Got it. Got it. That's not trial by ambush. Chaka is lost too. And that's Chaka possessed up there.
Are you aware of any activity in this trial of any kind before you testified yesterday?
Again, as I mentioned, I've been getting random emails, and then I've been seeing it pop up on my news feeds as well.
Oh,
But once I was aware of the reclusion, I made sure to not review any of that. But as recently as last night, I got an email that said biomechanical engineering job, or like applying for a job. And I opened it up and it was some internet troll.
Sure. I'm asking about emails
internet
from the
troll.
prosecution.
Oh, no, there's been no emails about what's been going. I mean, there's been scheduling, when am I going to come, things like that.
How then was it determined that you were going to be able to amend your power presentation if you weren't communicating with the prosecution?
I mean, they asked me about the witness statement of 138 right around May 13th.
How did they ask you about that, sir?
I don't recall if it was a Zoom meeting, a phone call.
Wasn't that long ago.
With the prosecution. Might have been by Zoom, might have been by another method, but there were communications while this trial is going on relative to you amending your PowerPoint that ended up with an amended PowerPoint on May 13th. Do I have that correct?
I believe so.
Going to switch topics.
Okay.
Sorry.
One of the goals of Aperture's analysis and reconstruction was to determine the location and timing of certain text stream events, correct?
Correct.
EDR data.
I'm sorry, my role.
Your role, yes. EDR, and just for clarification, EDR is Event Data Recorder, correct?
Correct.
So I'm going to refer to that, as you have before, as EDR, Event Data Recorder.
Sounds good.
EDR data does not show the location associated with a text stream event, correct?
In this particular vehicle, it does not.
And the EDR data for this particular vehicle, namely the Lexus SUV, also does not provide the time associated with a text stream event, correct?
Not at the time of this event.
So the answer is no, correct?
That is not correct.
So let me ask the question slightly different way. The EDR data does not provide the time. The EDR data for the Lexus SUV that you've been talking about does not provide the time associated with a text stream event, correct?
That is correct.
Instead, every text stream event is associated with a particular key cycle on the vehicle, right?
Correct.
There can be multiple text stream events in a single key cycle, right?
Correct.
And every time you start the car, this one you push the button, that's a new key cycle, right?
That will cause a key cycle.
And the EDR data indicates the number of seconds into the key cycle that the particular event occurred, correct?
The EDR data, no.
So EDR data gives you no information about the number of seconds into the key cycle that a particular event occurred.
You're confusing EDR data and text stream.
I'm not, sir, I'm just
Oh, you're not?
asking a question.
So
If it's yes or no, I'm fine with that.
EDR data will, depending on the vehicle, sometimes it has information about GPS date and time. Sometimes it has ignition cycles, which are a little bit different than key cycles, which is why you frequently have different ignition cycles versus key cycles in EDRs compared to text stream.
So let me ask it a different way.
Okay.
The text stream data indicates the number of seconds into the key cycle that a particular event occurs.
Yes.
Is that correct?
That is correct.
In order to properly determine the location and the timing of a text stream event, it's important that you correctly identify the trip that is associated with a particular key cycle, correct?
I think I'm going to say yes, that text stream tells you the trip.
I'm just asking if it's important that you correctly identify the trip associated with a particular key cycle. And do so by determining, in order to properly determine the location and timing of a text stream event.
So the text stream tells you the trigger event and it tells you the key cycle. So I'm not determining that, I'm reading that from the text stream data.
Okay, so in order to properly read, to use your verb, the location and timing of a text stream event, it's important that you correctly identify the trip that is associated with a particular key cycle. Is that a fair statement?
We're all tripping
I
right
think
now.
that's a fair statement.
We all took the same
If you
blotter.
associate the wrong trip with the wrong key cycle, then your estimate of when the text stream event occurred will be wrong, correct?
It can. I mean, you need to take the totality of the evidence in the text stream with the mileage, the overall timing into account.
So are you saying, sir, that if you have the wrong trip with the wrong key cycle, you can get the correct text stream event?
No, not necessarily. Again, you have to take the totality of the data.
My question is with regard to if you have the wrong trip with the wrong key cycle, then your estimate of when the text stream event occurred will also be wrong. Isn't that just a matter of logic, sir?
So again, the text stream event tells you the trip and it tells you the time. If you're saying I'm, say, associating that with the wrong infotainment information or vice versa, then that would be wrong. But the text stream data tells you how much time is associated with each trip. There's no difference there.
If you associate the wrong trip with the wrong key cycle, then your estimate of where the text stream event occurred will be wrong. Is that correct?
You can't associate the wrong event with the wrong key cycle because it keys in the key cycle with the event.
Let me
Thank you,
try it a
she's-
different way.
Let me try it a different way with a different tool, like that, whatever tools oral surgeons use. I don't know. Tell me the name of their tools. She's Like Texas gifted 20 memberships. Thank you so very much. You're so kind and generous, and I appreciate you with all of my heart.
Your analysis or anyone's analysis in conclusions regarding the timing and the location of the text stream data are only as good as your ability to correctly associate a key cycle with a particular event. Is that an accurate statement?
No.
Or so
Again, you need to take the totality of the data. So that is one element. You need to look, for example, at the mileage. You need to look at the timing of the events. So this is considered a tool in the analysis process.
Oh, you're
You
a
need to
tool.
look at the totality of data to see how it matches up with the physical evidence.
So are you saying that you can have an incorrect key cycle with a particular trip but you can still get accurate timing and location of tech stream data?
So again, you don't get incorrect key cycle with the trip. The trip and the key cycle are coded in by the text stream. If you are attributing an event to the wrong trip, which has a fixed key cycle, that could be a problem.
Exactly. So if we could go, if Your Honor, if we could publish a slide, please, that is in evidence.
Okay.
Thank you.
What are we looking at?
Pardon me,
What
Your-
slide number?
I've got slide 9. Mr. Wolk, yes, I've got the correct one. Thank you, Your Honor.
Good citizen. I don't know who would
So-
approve that payment, the DA or
I'm
the
going to use the
governor.
acronym
I don't know.
VCH that you've used on your, do you recall using the acronym VCH on your direct testimony?
Yes, sir.
And VCH stands for Vehicle Control History, correct?
Correct.
You viewed the vehicle control history on September 23rd of 2024, correct?
In addition to the PCS data.
You viewed the vehicle control history on September 23rd, 2024. Yes?
That is yes.
You took photographs of the vehicle control history, including key cycle 1167.
Correct.
And in this screenshot, we can see 4 text stream events that
Actually,
are,
can you zoom in on the key cycle?
oh, sure.
Because I think when I got to, no, scroll. So when I got to it, you can see it was that key cycle 1264. The blue highlight was the last file that was written on key cycle 1167.
Right.
So
But-
to answer your question, I got it at 1264.
So if we can go back so we can see the 4 text stream events, I just want to reestablish the foundation here. In this screenshot, we can see 4 text stream events that are associated with key cycle 1167, correct?
Hold on. When he got the vehicle in September of 2024, it was a key cycle 1264. I don't know about my math, but that means there were 100 more key cycles since 1164. He got it at 100 times that car was started since it's been in MSP custody, because Trooper Joe Paul said his key cycle was 1164. Now it's 1264. What were they doing for 100 key cycles? I don't know. I have questions. It's a lot of key cycles, right? Okay. Just checking to make sure my head has not popped off to the point where I can't even think anymore.
Correct.
But isn't it true, Dr. Welcher, that there were actually 10 text stream events associated with just that one key cycle 1167?
Correct. I gave you the original files.
Right. So you are aware that the Commonwealth had maintained up into your firm's engagement that
Are you
Didn't
saying
even
there's no
finish
basis for the
the
question?
question.
All right, I'm going to allow the question and I'll hear it.
Mr. Brennan, are you saying there's no basis for the question? Is that your grounds, Mr. Brennan? Let's hear the question from the beginning again, because we were so rudely interrupted.
Correct. I gave you the original files.
right. So you are aware that the Commonwealth had maintained up into your firm's engagement that
Are you saying there's no basis for the question? All right, I'm going to allow the question and I'll hear it.
you are aware that the Commonwealth has maintained up until your engagement in September of 2024 that all text stream events associated with key cycles 1164, 1165, and 1167 occurred while the Lexus was in the custody
Yes.
of the Massachusetts State Police at the Canton Police Department.
That's right.
So the objection sustained. You need a foundation, Mr. Alessi.
Oh, this is-
Sir, as part of your work in your review of the many documents that you referenced on your direct examination, did you review the text stream events associated with the Lexus SUV?
I reviewed the one I downloaded.
Pardon me?
I reviewed the one I downloaded.
Right. And did that, what you download, include key cycles 1164? Did it include that?
It did.
Did it include 1165?
It did.
And did it include 1167?
It did. It did not include 1166.
I didn't mention 1166, sir. I only mentioned 1164, 1165, and 1167. I purposefully skipped because I didn't understand you had reviewed it. So here's my question. You therefore, based upon the fact that you reviewed them, and you said it's important to understand timing, etc. That's very important in your forensic analysis, correct?
Yes, sir.
So let's go to the timing question and you understand where the Lexus has been at various points in time. You testified to that in direct, whether it was at the Canton Police Department, whether it was being towed, correct?
In addition to having Mr. Burgess analysis of the data.
In addition to Mr. Burgess analysis, so in that analysis contained locations of where the Lexus had been.
It contained where it had been, and also include date and time, when it was turned on, when it was turned off.
Exactly. So not only did you have all the locations, you had dates and times associated with the location where the SUV, the Lexus SUV, had been, correct?
Correct.
Now to the question. Based upon that review, that knowledge, that understanding, those bases, you're aware, and you've reviewed, by the way, Trooper Paul's reports, correct?
I have.
There were two reports of Trooper Paul. There was his original CARS report and then a supplemental report that were listed in the documents you reviewed. Do you recall that?
I don't recall that, but I'll take your word for it.
I don't want you to have to take my word. Do you recall, sir,
No, I
that
don't.
there were do you recall that there was a report of Trooper Paul?
Yes,
Okay. And you read that report, I assume, sir.
I did.
And it would be important for you to read that report and read it carefully because it addressed the subject matter that you were addressing, correct?
No, I did my own independent analysis. As a matter of fact, it'd probably be more important that I don't do that to avoid confirmational bias.
But you did read Trooper Paul's report.
Of
correct?
course.
So you therefore are aware that the Commonwealth has maintained up into your engagement.
Yeah, I'm going to see a sidebar on this.
One second. I go off camera to eat because I don't like to eat on camera. And I'm trying to just get something like a protein bar scarfed down while we're doing this because he's 100% right. We've been screaming about this for a long time. 1164 is Trooper Paul's testing of the Lexus outside Canton PD. We know it. You know it. We all know it. We all were here for season 1, and we have watched the episodes of season 1 multiple times, many of us. And she needs to allow this because that's outrageous. If they didn't tell him, they must have told him, because if he had Trooper Paul's report, it's in the report that his own testing that he did, Joe Paul, was key cycle 1164. Outrageous. Busted flash. Can his laptop be put into evidence now? And someone else asked a very similar question. Barney, didn't Dr. Judd just allow the contents of his laptop into evidence as it was used during cross? I don't know the Massachusetts rules. I'm in New York. Typically, in depositions, for example, I would always tell my clients not to bring anything with them. Don't bring any files. Don't bring any folders. Don't bring any calendars with you. Don't bring your diary with you, because anything that you bring with you during a deposition has to be turned over to the other side. I don't know the rules in Massachusetts enough to give you a straight answer on that, but I will find out. And that is my question too. Whatever he's using up there to help himself and refresh his recollection, and perhaps Google or whoever he's communicating with, should be fair game for the other side to at least look at. Whether it would come into evidence, I don't know. Well done, Olaf, the Russian metalhead. Aperture LLC, the Fire Festival of Forensic Experts. That's a thing of beauty what you just did there. Josie Mojo, the ongoing obvious obfuscation is annoying. Thank you for watching from South Africa. The world is indeed watching, and you guys are the world. You are the world, and you are my children, and that's why Kindergarten Cop is one of my moderators. Bruni Saint from Australia. So in the land of upside down, Brennan is okay to add new information to his witnesses, but not okay for the defense. Got it. Yeah, 100%. 100%. LC McJD says never works out well when an expert employs ignorance as their evasive tactic, because they're supposed to be an expert. 100%. RNM said, Brennan, how dare the defense discredit my witness with his own words? Yes, that is exactly. Piney Woods Law and Crime is here. She's a retired attorney. Hello, everyone. This judge needs to instruct this obstructive witness to answer the bloody question. I'm still outraged. Always love seeing Melanie and y'all in the chat. Free can read. Thank you. Thank you to Crafty Councilwoman for gifting a membership. You're amazing. Gail, great question. Mel, we know what Alessi is doing, but this is risky, losing the jury, right? It could be. It could be risky. If they find, it depends on how they feel about Alessi, and it depends on how they feel about this witness. It could work against Alessi. It could work against the witness. But yes, it could frustrate the jury. And now, again, we're on the fan. Thank you. Vet Girl RWB, you let me know what you think. And I'm sorry about yesterday's poll. I put the poll up and then I forgot to get the results of the poll, and now I don't know where to find them. And the thing is that on StreamYard, it doesn't show you your poll. So you have to have YouTube open on another tab, and it uses so much memory. Sometimes you get the snap. So let's do the poll again. Thank you, Vet Girl. Congrats on 100K. Doesn't the hospital that treated Officer O'Keefe have a policy and procedure in treating an MVA with life-threatening injuries? Where are the medical peeps that treated Officer O'Keefe? Yes, I've been asking that too. Why didn't they call Justin Rice? Justin Rice is the doctor who treated John O'Keefe when he came into the ER. They didn't call him, the Commonwealth. They called him at the first trial. They did not call him. The jury might be wondering why as well. Why are we hearing about all these people like Proctor, Higgins? Why are you not calling them? What are you afraid of? Where are the people who treated him in the ER? Why did you only call the medical examiner? You told us all that he had to be taken into the ER and warmed up before he could be declared. Where are the treating providers who treated him then? Is the only witness that you're giving us the doctor who examined his body after he had passed? Why? The only other medical witnesses were EMTs. Nobody was an actual medical doctor. JB Guthrie, OMG, I think I know where this is going. Alessi's asking questions about the cost, knowing Brennan will too. This could potentially open the door to the fact that they were hired by the FBI. You may be right. I may be crazy. But it just may be a lunatic you're looking for. Jennifer Fields, he doesn't have a dog in the fight. He has over 400,000 dogs in the fight. Yeah. But I think he made something like 270 mil from selling his own company to Aperture. So he's got 270 million reasons not to care about his credibility anymore because he doesn't need to work. Do you think? If that's true, sidebars and testimony, pass, go, get out free. Love you. Thank you. We're back for now. I think we're on real time. We are. This is a masterclass being done with surgical precision, but is he losing the jury? I don't know. Let me know if anybody's tweeting live from the courtroom jury reactions so that we can look at it. Thank you. Chitty chitty bang bang. Chitty bang bang. Chitty chitty bang bang. Chitty bang
May
bang.
I?
Yes.
Thank you.
Thank you, Bling is the new black. Oh, you made that
Are
video.
you aware that over the
Put it on
course of the
Instagram.
Commonwealth's and your investigation into this case, that the theorized time of the alleged contact of the SUV?
So there's two words to
Okay. We're going to start that again because he's objecting before the question is even finished, as always. Back to the top.
Are you aware that over the course of the Commonwealth's and your investigation into this case, that the theorized time of the alleged contact of the SUV?
So there's two words, just strike theorized.
Okay. Thank you, Your Honor. Are you aware that over the course of the Commonwealth's investigation and your
Hold on, Mr. Alessi, court reporter copy.
Thank you. I will.
Sue is tweeting. Thank you.
I'll object again to the question that's coming.
I'll object to the question that's coming. You haven't heard it, you mook. Moron. Oh my God, I
Can
can't
I
stand her.
Go
begin
ahead
my
and
question?
ask an appropriate question, Mr.
Sure. Do you have knowledge whether there is one time or more than one time for the Commonwealth's position, as you know it from reading documents that you said you've reviewed, that there are different times alleged for the incident to have occurred at 34 Fairview?
Objection.
Sustained. You can ask the question, remove part of it.
I'm sorry, Your Honor.
You have to remove part of that statement.
Okay, understood, Your Honor.
They keep changing their timeline.
Do you know whether there is more than one time that has been proposed by the Commonwealth for the impact alleged to have occurred at 34 Fairview?
Objection.
Sustained.
I'm going to ask for an instruction.
I'm not giving the instruction now.
Dr. Welcher,
She said no to him. I'm not giving the instruction now.
in terms of the analyses that you have reviewed in this case, is there one time that you understand there to be for a hypothesis for the time of the impact at 34 Fairview?
Objection.
I'm going to see you again, folks. I'm sorry about this.
The jury is entitled to know that the Commonwealth keeps changing their theory about the time of events. They already know that Jennifer McCabe texted John O'Keefe at 12:45 a.m. when he was outside. She said she saw the car outside at 12:45 and that she was texting like, pull up behind me or here or something. And she said at the same time, 12:45, she saw the car out there. That's why their first theory in season 1 was 12:45. Now they've moved it back to 12:31. Now it's 12:32 because time drifts and all kinds of stuff like that. Shout out to Patricia and the liquor store that she is managing right now. One of her employees just told her that she needs to stop watching for the day or she'll have to fire her. She said this witness is going to drive her to drinking. Shout out to all the people in the liquor store watching. At least you guys have a coping mechanism available to you immediately, right there where you are. It's outrageous. It's insane. It should outrage you. We are outraged, and we have emojis that even say we are outraged. See some of those in the chat. We are outraged. We've got wait for us. We've got lies, 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 Thompson twins, and all of it. Barbara has found my head on the beach in Palm Coast, Florida. With a hat and a cocktail nearby. Thank you so very much. I'm glad that you're keeping my head company because it has been popping off forever. Just me, who is actually a medical doctor, says he behaves like he's never been a witness before. Yep. Midnight Mike, I did put changes on the playlist, I think yesterday. Thank you for asking. Big Haas, never felt so dumb and lost at the same time. It's not just you. You are not alone. That is my favorite court officer. Please, does anybody know her name? Can you please find out her name? She's sitting today next to Mr. Reed, and I love her so. Hi. I need to know your name so I can say hi to you on camera because you're amazing. And you are every one of us watching this case. And girl, you got to keep it together. And I feel bad because that's a hard job. USMC Cowgirl says, in my opinion, 3-point turn at 12:32. She was maneuvering big SUV in the small driveway to line up with the garage. Wi-Fi connected when she pulled into it. Love you, Mel. I love you more. Semper Fi, girl. Semper Fi. Rebs 13. Welcher, weird and smug as Harry Ellis's character from first Die Hard movie. Freaked out. Hans Gruber. This cosplay oddity is freaking out everyone. It really is. It really is. I've never seen anything like it. we are lost together. That we are. And that is why Chaka is on the upper right-hand corner of your screen. That is Chaka from the Land of the Lost. If you guys are like anything after Gen X, you might not remember the Land of the Lost, but that is where we are. He's our mascot. And that is from an episode of Land of the Lost called Possessed. And he looks possessed and he's a little bit creepy, freaky, but he's friendly and he's with us because we need protection from this. Jerby, I've been traveling for the past 12 days, Pennsylvania to Colorado and a drive to California. You helped keep me company along the way. I appreciate your humor and style so much. Oh, I am honored that you allow me to keep you company. I just hope that I'm not causing any accidents with, my humor. Scaffolding. We have a lot of construction crews. Shout out to all the construction crews that are also watching or listening, because you shouldn't be really watching while you're on scaffolding, operating heavy equipment. The tractor drivers, the mail carriers. We have a lot of mail carriers, a lot of nail salons and hair salons that have us on. And that is why we try and keep it clean for the sake of the customers who are there watching as well, because the world is watching. You're all watching. Somebody sent me a picture of a nail salon in Oregon that had just opened. And I was on the TV in the nail salon. And I love that for all of us. The woman in blue, I think, is a relative. The woman to the right of your screen from Peggy O'Keefe, I believe she's a cousin. You guys can let me know if I'm right. But Paul O'Keefe is sitting behind his mother. He has been demoted to the back row. I'm not sure why, but the rumor and speculation is because of his glares at Karen Reed. And I don't know exactly what had happened. Aiden, I don't know if Aiden got in today. Someone said he was number 11, and then someone else said that he was in the courtroom. So I don't know. I haven't seen him yet. Aggressive Carpet says, I wish they could ask him to confirm the obvious. He was given a timeline by the Commonwealth and asked to make it work. No one is this defensive if they have no skin in the game. I know. And he keeps saying, I got no dog in this fight. Daniel Wolf's Dimples. Hi from the east coast of Australia for your song list. Hazard by Richard Marx. Thank you. They're watching down under. Hank Brennan's floating timeline is here. It's clear now why the feds hired ARCA and not Aperture. Hello to my son in Texas, Joshua. Mama loves you. Mama loves you, Joshy. Thank you for your 20. Clinton Nix, this is so gross. Carl Steinbeck was so upset on his live yesterday, fuming. Thank you. My name's Kel. What is the stop-start feature? Car goes on and off. Anybody watch the season finale of Handmaid's Tale yet? Because I don't want to spoil it for anyone, but I watched it last night and it was good. Kind of sad to see the series end because I'm a big fan. And it is so interesting to me that Gilead was headquartered in Boston. And Boston got its freedom eventually, but Gilead, Boston, so many similarities. Aunt Lydia under her eye. Praise be. Blessed be the fruit. And this is very Handmaid's-esque. Handmaid's Tale-esque, isn't it? Clinton would love to see you and Carl B discuss this together. I don't know Carl. I haven't met Carl, but I do watch him occasionally, and I do find his analysis to be very good and interesting. So thank you. I'm not sure if that's who you're talking about. You said Carl B. I don't know if you meant Carl Steinbeck. Bex, thanks for gifting a membership. And Midnight Mike coming in here and gifting another 5. You're awesome. It's almost 12:30 here on the East Coast. She's going to take lunch in half an hour. What are we doing here? Becky, is John O'Keefe's family allowed to give dirty looks at Karen as she walks by while they are facing the jury? Well, they've been doing it since season 1 consistently. And I know that one day during the trial, the judge kicked everyone off the second floor and had a meeting with the family of both sides and the attorneys. And it was a closed door meeting and no one's allowed to talk about it. I don't know what happened during that meeting. I don't know if people were given warnings about facial expressions. I just don't know. The answer is it should not be happening. And because of the wonky layout of this courtroom, where you see the O'Keefe family sitting kind of like right on top of Karen, and shout out to King David Yannetti, who has been in that seat protecting her all the way through season 1 and all the way through season 2, because Paul O'Keefe typically was sitting on the end where this woman in the black sweater and purple shirt underneath it was sitting, and would consistently, what we thought in our opinion was glaring at Karen with daggers in his eyes. They are facing the jury. This is a tiny courtroom. There are only 10 seats available for the O'Keefe family and friends. There are 10 seats available for Karen's family and friends. There are 10 high top seats behind the O'Keefe family for media, and they're on a lottery system. And then right across from where you see the O'Keefe family sitting on the other side, the jury is facing them. And to the right of the jury, in very close proximity, is the witness stand. It's a weird layout, and it's tiny, and it's claustrophobic, and that's why they had to keep turning off the air conditioning last year, because it was hot, and they couldn't hear the witness over the air conditioning. Thank you, Lester. He says trigger event 1162-2, 16,629 miles. Well, I'll go over this later in greater detail, but thank you. Do you always get hungry before an execution, says Glamassus? All of us, I think we do. Judge,
Yeah, Your Honor?
Yes.
Occiput Boner. Excellent name.
I'm going to move to, for the moment, we'll come back to the other topic a little bit later.
That's the timeline topic. That is very important, by the way.
As we discussed earlier, you've got on various documents, you're a biomechanical engineer, but I've also heard you make reference to biomedical. Can you just tell me what you consider yourself, sir? Is
Sure.
is biomechanical engineer something you consider yourself to be?
Sure. My degrees are in biomedical engineering. The discipline within biomedical engineering that I practice is biomechanics.
Right. And so is it accurate to say that you are a biomechanical engineer?
Yes.
And you say that much in your report, correct?
And the CV and resume I gave you.
Right. Now, in your report, and Your Honor, I have no issue if he refers to the
Thank you.
page of his report.
Do you have a paper copy or do you need your?
I do.
If you, sir, could turn to page 9 of your report.
Okay.
And on page 9, you state, as a biomechanical engineer, I have no opinion on any aspect of, and I think you're referring to Mr. O'Keefe's, medical treatment or medical diagnoses. I have conducted an accident reconstruction and biomechanical engineering analysis of this matter. Did I read that correctly?
Did?
In that statement, I assume, given you wrote it, is a fair representation of your professional role in this case?
Yes.
And you go on to add on page 9, my biomechanical engineering analysis is determining the effects of physical forces on the human anatomy. Did I read that correct?
You did?
And on your direct examination, is it correct that you stated as a civil engineer, you made an analogy, you assessed the cables and beams of a bridge as you would assess the cables and beams of a bridge, you assess the human anatomy. You made that analogy, correct?
The analogy that bones are my bridge elements, cables are muscles and ligaments.
Right. And you stated that it's the job of a biomechanical engineer to quantify the force acting upon a person to determine the cause of their injuries, correct?
That is part of what we do.
It's part of, but it is therefore something that a biomechanical engineer does, correct?
Given sufficient data, yes.
So you know do you know what a force calculation is, sir, when I refer to that term?
I believe so.
What do you believe it to be?
Well, force is usually a physical measurement, but you can also use Newton's second law, which is force equals mass times acceleration.
That's exactly what I wanted to get to. Newton's second law is, and sometimes referred to as the second law of motion. And in the second law is force equals mass times acceleration, correct?
Correct.
And just sort of like simple algebra, sometimes you have one or more of those, but I'm focusing on when you're trying to determine, sir, you're pulling something out.
Calculator. I thought you were going to ask me numbers, do calculations.
All right. We're going to do that. We need to do it with the court's permission. So
Sorry.
if you feel you need to do that, just let me
You
know.
can just leave it right
All
there.
right.
So I just want to get the principles down first. So Newton's second law, force equals mass times acceleration. And force is oftentimes what you're trying to calculate in a force calculation, correct? Using-
Calculate or measure, yes.
Yeah. And Newton's first law is the law of generally inertia. An object at rest tends to stay at rest. Object in motion tends to stay in motion. We're not talking about that in force. We're talking about Newton's just second law, correct?
You asked me two questions. Newton's first law is generally, as you said, it could be at rest or at constant velocity, but yes.
Okay. And that Newton's second law is generally just a mathematical calculation, correct?
Yes.
So what I'd like to do is to turn to page 11 of your report. And on page 11, you discuss the force calculation in conjunction with the part of your report where you discuss your experiment where you dropped a test dummy backwards, correct?
Correct.
You determined that a fall of 69 inches, at that fall, Mr. O'Keefe's head would have accelerated with 458 G's of force.
That's what we actually measured.
Right.
In the test.
And can you tell the jury what is meant by G's?
So G's is a measure of acceleration. If you take, usually acceleration is measured in feet per second squared. If you divide it by 1G, which is 32.174 feet per second squared, that gives it to you in G's. People often heard about fighter pilots losing consciousness at 6 or 7 G's, basically because your blood's getting sucked away from your head, not because you're being impacted. But G forces, or G's as they're more properly called, is a measure of the acceleration. It's just whatever the acceleration is divided by what we all feel when we're standing here, which is 1G of gravity.
And you estimated Mr. O'Keefe's head weight of approximately 15.7 pounds. You used a percentage. Is 15.7 about right for the mass of,
Yes.
of the head? So if we apply Newton's second law, we keep F force open as the unknown. We take and apply the mass, which is 15.7, multiply it by the acceleration. You end up with a force acting upon Mr. O'Keefe's head of 7,200 pounds. Do I have that right? That's right out of your report.
So that math is all correct. Falling backwards onto a hard surface from his standing height will give you approximately 7,200 pounds of force.
That math.
And that
is right.
7,200 pounds is the previous unknown F in the Newton's second law equation, correct?
Correct.
So now we have an answer for F, 7,200 pounds. Now you then go on to note that the applicable scientific literature states that a fracture to the occipital bone, and just to review, the occipital bone is the back of the head right here, right?
Correct.
No, no,
So you then,
it's the occiput boner. Remember we learned that yesterday, Mr. Alessi. It's the occiput boner. Let the jokes begin.
as I understand it, you go to the scientific literature and you concluded that a fracture to the occipital bone can occur with an average force of 1,634 pounds from a fall distance of 40 inches, correct? I'm sorry.
How many inches?
40.
Is she
That's in
taking-
your report?
Is she
Well,
taking
you
notes
mixed
too?
two things together. There was stuff that reported force data. You had those numbers correct. A range of between 1,150 and 2,150, a mean of 1,634 pounds. And then it says, and a drop distance as low as 40 inches.
Right. And is the number 634 pounds a proper number for an average force?
Did you say 1,634 pounds?
1,634.
Yes.
Okay. So what I want to do is see if this is correct. So if you can get a fracture of the occipital bone in an average force of 634 pounds.
No.
I'm sorry.
1,634.
I thought that's what I said. If I did, I missed.
Oh, I'm sorry. I just heard 634.
No, 1,634.
My apologies.
And you compare that to the 7,200 pounds of force that you calculated, surely you're going to have a fracture of the occipital bones through that calculation in that comparison, correct?
Correct. Falling on a hard surface can definitely fracture
Right.
your skull.
So I'm not getting at the manner. I'm just applying the Newton's second law. Newton's second law doesn't look at manner, does it? It just looks at force equals mass times acceleration. Newton's second law doesn't look at the surface, does it?
So it's a function of the surface. The A value is a function of the surface you hit.
So you're saying acceleration depends upon the surface?
Yes, of course.
Okay, all right.
For an impact, it does.
Yes, of course.
Now, let's go to the study you cited. Injuries to pedestrians in real accidents in their relation to collision and car characteristics. That's in your report, correct?
What reference number?
May I, Your Honor, grab the report?
Yes.
Fire pilot's wife gifted 20 memberships. Thank you so much for your kind and generous gifting today. You're amazing. 20 more new members today. Make sure you smash the like button while you're here. I appreciate you all so very much for choosing to spend your entire day with me.
Is it number 25?
That's the one I think it is. I just want to check your report.
Would you like me to actually pull up the paper?
No,
He's
Okay.
so helpful, isn't
just
he?
want to get to the. That's it, number 25. We're talking about the same one. Now, isn't it true that this study states that head injuries are the most common injury type for motor vehicle collisions, constituting more than 61% of all injuries sustained from motor vehicle collisions?
Or can the witness see the document that's being referred to?
Do you have your report in front of you?
I have my report, but reference 25 is not in the section he's referring to.
So combative.
I do not have with me a copy of the report he cites in his reference. He did, can I ask another question? Your Honor?
Yes.
Thank you. Dr. Welcher, on your direct testimony, did you not discuss the percentage of pedestrian injuries and relate it to heads? Did you not, on your direct, talk about percentages of injuries that are head injuries in impacts of pedestrians with cars?
Yes, I did.
Okay, so you came up with a number. What I'm trying to do is to compare that number to the number in the study that you cite. If you don't remember, that's okay. We'll just move to the next
Can I
question.
go to my slide?
Whatever you can use to determine what was the percentage that's in the study that you cite in footnote 25 of your report.
Sure. That was also from my presentation that I gave. It's 61.5 for all injuries, 12.7 for fatal injuries.
Thank you.
You're
So I'll
welcome.
repeat my question and then we'll get it in logic. So that study states that head injuries are the most common injury type from motor vehicle collisions, constituting slightly more than 61% of all injuries sustained from motor vehicle collisions, correct?
Mhm.
That number is correct. You're quoting a sentence. I would want to pull the paper up, but the number is correct.
Okay, so doesn't this article also state that of all head injuries sustained by motor vehicle collisions, only 12.7 of them are fatal?
That does, yes.
Did you mention that only 12.7 are fatal on your direct examination?
No.
It's circled with a red box on my slide.
Did you mention that on your testimony
I
on direct?
thought I did.
This article was published back in 1979, correct?
I believe that's correct.
It's 46 years old. Therefore, if I did the math correct, right?
That sounds correct.
Are you aware that given advancements in science since 1979, advancements in medicine, advancements in technology, The currently understood most common injuries as a result of pedestrian motor vehicle collisions are injuries to the lower extremities.
Thank you. Praise be.
I'd have to see the study. It wouldn't surprise me. Car technology, especially, for example, with pedestrian safety systems.
It wouldn't surprise you, but on your direct examination, you led the jury and the world to believe that the current #1 injury sustained in pedestrian versus motor vehicle accidents is head injuries. We were here, we screamed about it, and now when Mr. Alessi brings it up on cross-examination, now all of a sudden you say it wouldn't surprise you to find out that the real #1 injury in pedestrian collisions versus motor vehicle is lower body injuries. Are you flipping kidding me? We got to hear it again. Wouldn't surprise me. Yeah, because I would have relied on a 46-year-old study, and that's what I told the jury was the truth. But now I'm going to change my truth because I need to speak my truth, because this will now become my truth because you caught me in a lie. Listen.
Advancements in Are you aware that given advancements in science since 1979, advancements in medicine, advancements in technology, the currently understood most common injuries as a result of pedestrian motor vehicle collisions are injuries to the lower extremities?
I'd have to see the study. It wouldn't surprise me. Car technology, especially, for example, with pedestrian safety systems, has caused autonomous braking. So you're getting fewer higher severity crashes, which results in a higher propensity for lower extremity injuries. It's the higher extremity crash that causes the head to either slap into the hood or the window or bounce off.
Or the
where if you
windshield.
get the lower severity crashes, you can still maintain a standing posture. So it wouldn't surprise me if that's accurate.
So you would agree that as of January 2022,
Wow.
the most common injury
He's writing it
as a result
down.
of a pedestrian motor vehicle collision is one to lower extremities.
No, I wouldn't necessarily agree with that date. And again, you have to look at frontals versus rears.
So you can test that the most commonly understood injury as a result of a pedestrian motor vehicle collision is injuries to lower extremities.
So I'll allow the question.
So I'd want to see the data. Again, most cars, for example, this Lexus has a pre-collision system in it that will start to apply the brakes if it senses a pedestrian at the front of the car. And so for frontal collisions, it's transitioning, taking what were head injuries, because they're more severe, higher speed crashes, making them lower speed crashes and shifting the injuries to the lower extremities. Just like airbags shifted the head injuries away from the severe ones, and we started getting more or higher ankle and lower leg injuries.
He doth protest
So the
too
change in the
much.
technology, but for backing, that may not be the case because you have different geometry on the vehicles and you have different safety systems.
I'll try it a different way.
Mhm.
Do you have knowledge, as you sit here today, whether the most common injury from a motor vehicle accident is to the lower extremities?
I'd have to look at the literature.
So-
I have the article I gave you.
So the answer is you don't know the answer to that question. Is that correct, sir?
I don't know it off the top of my head.
All right.
Wow.
He's
a pretzel.
Newton's second law analysis that we went through, force equals mass times acceleration, where we came up with the 7,200 number. You didn't discuss that calculation on your direct examination, did you?
I don't think so. We didn't discuss a whole bunch of those things that were that wasn't necessarily an opinion. That was a sub-opinion or basis for my opinion.
A
You
sub-opinion.
didn't discuss that Newton law calculation on your direct examination, did you, sir?
So in a way I did, because I said my drop testing shows that you can do this.
Drop
So I
testing.
didn't quote that number, but we are going through the specific numbers now. But I absolutely did say, as a matter of fact, I showed a video of my drop testing and
If you didn't see his drop testing from yesterday, you got to go back and watch it. He hugs the crash test dummy. They hug it out. And then he just drops them like a bad habit right on the floor. It was fantastic. It was delightful. It was some of the best comedy we've seen all trial. And that is saying quite something.
talked about how falling onto a rigid surface, a hard surface, can cause a skull fracture.
Did you discuss on your direct examination
An occiput boner, to be exact.
applying 15.7 of the head weight to 458 Gs and come up with a number of 7,200? Did you do that on your direct examination?
Those specific numbers, no.
Thank
The
you.
general concept of the drop testing and what it showed, yes.
So instead of that calculation, you referred to a flow chart comparing injury characteristics of flaws versus blows. Do you recall doing that on your direct?
So you asked me two questions. You said instead of, so that's no, it's not instead of. They're two completely different topics. So no, I didn't do that instead of.
Okay.
I looked at a force analysis, then I looked at 3 peer-reviewed publications that were attempting to differentiate whether an injury is associated with a fall or a blow, an assault, and they came up with a metric for doing that. Those things are completely separate.
Let's ask it this way. Did you, on your slide presentation that you presented to this jury, did you put the inputs into F equals M times A in your slide presentation with the numbers we talked about of 15.7 for the M and 458 for the G to come up with 7,200? Was that anywhere on your slide presentation?
So the slide presentation showed the 458 Gs. The rest of it was not on there.
Thank you.
You're welcome.
You also indicated that the laceration above Mr. O'Keefe's right eye is consistent with the shape and height of the fin on the top of the Lexus SUV. Do you recall that?
Correct. It's actually properly called a spoiler.
And so you would call it a spoiler instead of a fin?
Correct.
Fair enough. We'll call it a spoiler.
Somebody called it yesterday. He called
You
it like a
visited the
wind
scene at
wing.
34 Fairview, correct?
I did.
You stated
Did you go back and watch Melanie Little's show from yesterday wherein you were calling that thing a wind wing? And I said, oh, the wind beneath my wings. And then I said, as far as I'm concerned, back in the 80s, we called it a spoiler. And now you want to call it a spoiler? Okay. It's not a wind wing anymore, sir. And again, Kurt says this guy pulls out more props than Carrot Top. What's next? And Abacus. I was like, he's like a magician pulling a rabbit out of a hat next, or a dove or something. Now he's calling it a spoiler. Okay, good. I'm glad I could school you on that.
call that
Correct. It's actually properly called a spoiler.
with the shape and height of the fin on the top of the Lexus SUV. Do you recall that?
Correct. It's actually properly called a spoiler.
And so you would call it a spoiler instead of a fin?
Correct.
Fair enough. We'll call it a spoiler. You visited the scene at 34 Fairview, correct?
I did.
You stated that you like to visit the scene while you're working as an accident reconstructionist so you can get a better understanding of the data?
I'd use the word like, but we want
You
to
don't
go
like
to the
to go to
scene
the
to
scene?
to see the scene.
When you
know,
visited 34 Fairview, did you go into the garage at 34 Fairview?
No, I actually didn't set foot on the property.
You didn't set foot on the property.
No, I stayed in the street. It's my understanding there were new owners.
wow. Right,
Did you
Nonya?
consider the scene limited to the road?
So the access I had was to the road. The laser scanners and the photographs will extend further, but I didn't have access to the interior of the house.
Oh, so you didn't access the entire scene, correct?
In my opinion,
See
I
what you're doing
did
there.
access the entire scene. I didn't physically step 7 feet onto the grass to the point of rest, but I stood
7
and
feet is the
photographed
point
where
of
that
rest now?
was. I didn't want to trespass.
Where did you understand the body of Mr. O'Keefe was located?
I know it was 7 feet in from the grass. I've seen cruiser cameras showing people around a body. It's slightly north and slightly south and a little bit west of the flagpole.
Has there been any testimony that it was 7 feet from the road? Well, he knows that. He's like Kreskin.
But you didn't access that part of the scene that you just described, correct?
I absolutely did. I took photographs of it. I didn't trespass and stand at that exact location, but I stood right there. We scanned the whole thing. The scanner uses a laser beam that goes out, 150, 200, 300 feet. So we scanned all that stuff.
Did your scan topography?
Yes.
Oh. Where are
Then
those
you
results?
know that there is a berm raised above street level, correct? If you did the scan.
Correct.
Do you know the height of that berm?
I believe it's 4 inches.
It's a 6-inch Cape Cod berm, I believe.
Nowhere in your report, when you're comparing the height of Mr. O'Keefe to the spoiler, do you account for that 4 inches of the berm, do you?
So yes and no. As I indicated, we don't know exactly where the point of impact is, whether he was completely in the road or up on the berm. But for example, where the tire spins on the Lexus, that could be where she's driving up on the curb. And so then that tire will be at the height of the curb. So if he's standing on the higher part and the right rear tire of the Lexus goes up there and spins, then that would be at the same height. We don't know the exact point of impact.
You don't know anything.
So I don't know whether he was on the road or in the street. Excuse me, on the street or on the side of the road.
You have all the police police reports, right? Do you know if there were any tire tracks found on the lawn? It was wet, right? There was enough snow to track a cat. Wouldn't there have been some mud and some tire tracks on the lawn? Don't you think that would have been important to know? Important evidence in this case? They didn't find any of that though, did they? Because you had all the report. You read about 700 documents to come to your nonsensical conclusions, sir. You don't know much of anything now. He was very sure of himself before. Now he doesn't know anything. He doesn't know if the tire was on the lawn.
Exactly, but when you did your depiction on your slide, and you remember you had the ruler, you measured the height, you did all
Absolutely.
that?
Yep.
Where was it? It was you? Was it you in that slide?
It was
Where were your feet?
on the ground.
Not on the berm, correct?
Correct.
Okay, so you chose a measurement, which was the ground to the top toward the spoiler, and you took a measurement. And you said that approximates the height of Mr. O'Keefe, correct?
Of the laceration of Mr. O'Keefe.
Exactly, because what you were doing was you were trying to determine and present testimony on whether or not that laceration could be caused by the spoiler, and to do so, you had to take measurements, correct?
Correct.
So, you chose to place Mr. O'Keefe in your simulation on the ground. You didn't choose to put him on a berm that would be 4 inches higher, did you?
Nor did I put the Lexus 4 inches higher. I didn't do
Correct.
either one of those.
So the point is, it's certainly possible that if there's 4 to 5 more inches, that would take that eye out of the ability to be hit by the spoiler. Isn't that correct?
No, because if it's 4 to 5 inches higher and he leans his head down or reacts to it, again, we don't know the exact position of his head.
Did you, in your slide yesterday, describe the possibility that his head could be down? As I understand it, you're positioned in that photo just like this. You're not positioned like that in any photo you presented to the jury, were you?
I'm trying to make it clear. We don't know his exact body position at the point of impact, nor do we know the exact position on the ground. So, which is part of the reason why I haven't tried to exactly simulate this, because we don't have enough parameters to do that. So I don't have that information. I'm showing the geometry relative to someone of Mr. O'Keefe's height.
So you don't have the information to do that properly, so therefore you can't conclude that he had a laceration to the eye from the the spoiler by your own answer that you just gave, correct?
It was done properly. We don't have absolute information to say where exactly he was. I'm pointing out that the physical evidence, the height, matches the height of the laceration. That is one data point of many data points.
So you would have to at least concede that the level of his eye could be non-contacting that fin or spoiler because you don't have information as you just described.
Sure, it could be from contacting the ground.
Pardon me?
It could be from contacting the ground. It could be from other things.
But you don't have the information necessary to conclude with any certainty that Mr. O'Keefe at the time of impact had a level of his head in an upright such that it hit that spoiler. You don't have that information, correct?
We don't have that level of certainty. We have that the height and geometry matches.
And you didn't take into consideration the berm, and you didn't mention the berm at all when you were discussing this measurement with a jury yesterday, correct?
That is not correct. You asked me two questions. I absolutely considered the berm. And the second question, when I presented to the jury, I mentioned the berm when we showed the picture of the shoe in the snow, but that was it.
That's my question. I'll ask it a different way. When we were talking not about finding a shoe in the snow, and you mentioned a berm, I'm talking about when you did the measurement of whether or not the laceration could be caused by the spoiler, you didn't mention accounting for berm height when you discussed that measurement with the jury, did you?
That is correct.
But you know he definitely got hit by a car. Got it. Karen Connolly, thanks for gifting 10
Likewise.
memberships. You're amazing.
You didn't present any Newton's second law analysis regarding the front of Mr. O'Keefe's head with respect to whether his head was contacted by that spoiler, did you?
Correct. Again, it was a glancing hit. We wouldn't be able to do that.
Oh, so it's a glancing hit to the front of the head is your hypothesis?
This whole pedestrian impact is a glancing hit.
To every part.
So you can have your arm to the side like this.
Oh,
with
show
the
us.
back of the vehicle coming like this.
Show us.
And you
Alessi.
could glance the right eye with the arm out. Is that what you're saying?
That's what my picture shows when I'm standing next to the car.
In your John O'Keefe cosplay
I
outfit.
could probably find the slide for you.
So you didn't do a force analysis to determine how much force would be applying assuming a contact with the right eye, did you?
That's correct.
And force analysis is what biomechanists do, correct? That's what a biomechanist does?
That is part of what we
Part of what they do.
So I lined up his anthropometry relative to the known height of the vehicle.
You attempted to line it up. That's one method, but another method is to apply Newton's second law like you did to the back of the head when he fell, correct?
Correct. If we had more information.
You just make up all the other information. Why not just make up more information to
So why don't we break here?
fit your theory?
Thank you, Your Honor.
So jurors, your lunches are here. We'll see you in 15 minutes.
Who's right for the jury?
Wait, how much time is she giving them?
So jurors, your lunches are here. We'll see you in 15 minutes.
50 minutes. 5-0.
Goodbye.
Goodbye. Oh, yeah. He was on the hot seat and she wanted to help get him off. I guess everyone has to clear the courtroom. They're leaving. And I guess it is a break till approximately 1:55 p.m. Or maybe they'll just round it up to 2 p.m. Chloe Albert's Revenge says if you had an office, the waiting room would have magazines with Marilyn Monroe on the cover. What have we learned, chat? What have we learned? Learned a lot about Newton's laws. We've learned a lot about him not factoring in the berm. I thought it was a 6-inch Cape Cod berm. Does anybody remember it being 4 inches? He says maybe it's 4 inches. Did he measure it? We don't know. He said he went to the scene, but he really didn't go to the scene. He didn't step foot on the scene because that would be trespassing. And he said, well, I wouldn't say I'd like to go to the scene. I wouldn't say I would like to. That's some really annoying elevator music. Let me change the banner. They're on break until 1:50 p.m. 1 minute. Tell me your thoughts, comments, concerns on the testimony so far today, which has been pretty much all Alessi all the time. Oh my. I've learned that Welcher is driving me insane. R&M says Dr. Welcher puts the con in Reconstruction. Free Karen read. Reconstruction. Crafty Councilwoman says, excuse me, sir, do you understand what a freaking variable is? How can you find fact inside a variable, sir? Banging head on table. The silver leaf. Something tells me he has a dog in this fight. Could there be a contract in future payment? Could there be in the contract future payment, right? Like meaning they don't get paid until it's done. Aperture has a culture issue and we are looking right at it. His ego will be the downfall, in my opinion. I'm here for it. Let me know what you think. If you think that Alessi is losing the jury on this, let's see what Sue O'Connell, who's in the courtroom, says. She's a commentator, not a reporter, according to her own Twitter profile for NBC Boston, NECN, South Bay News, and other outlets. She said that the jury was paying attention. And that was about 45 minutes ago. Struggle now between Alessi and Brennan. Jurors are paying attention. And so I guess they're riveted by this testimony. She said 2 hours ago, 4 jurors are taking notes. All are attentive. Some are watching the back and forth between Alessi and Welcher, like a tennis match. That I find interesting. She says Welcher was whistling as he entered the courthouse this morning. So if you're watching or listening to this biased questioning, how is it hitting for you? There are several jurors who look very interested and attentive. She was asking, I guess, the people who are following her on Twitter. A lengthy pushback, this was about 2 hours ago, from Welcher in answering questions that I think are the foundation of the first chapter of every middle school science textbook. All right, Sue, where you go, girl? As Attorney Little hands Alessi a document as he asks Welcher about payment for their work, one juror has a look of anticipation, and that is not me, Attorney Little. That is Eliza Little, no relation. She is no relation to me. Welcher interrupts Alessi to correct how long he has been working the case. He did a lot of interrupting and a lot of correcting in the beginning of his testimony. And she says a juror is smiling and taking notes. Lots of nods from the jury and a couple of smiles when Welcher finally answers that the state will pay the difference of the resale of the Lexus. He did say that. He said, yeah, we pay for the Lexus. And then when the case is over, we sell the Lexus. And, unless we're able to sell it for a profit in California, we bill the Commonwealth the balance of what we paid and the loss that we took on the resale of it. But he seems to think that he can get more money for it in California, and so they'd get a credit. Maybe they wouldn't get a credit because he never billed it to them in the first place. I don't know. He's hella confusing. One juror is nodding up and down as Alessi pressures Welcher on payment and contracts. Some jurors look confused. This has been going on for more than 30 minutes, and Welcher is resistant to answer questions about issues that are not in dispute. The scientific method, payment for services, the contract. The judge asks Welcher not to look at his report. Judge calls a sidebar and tells Welcher he can refer to his report. I'm predicting Buchanan-esque responses to the rest of the cross, she says an hour ago. Then she says the judge instructs Welcher to refer to the report, get the answer, give the answer, and close the report. He had his laptop with him while he was on the witness stand, and he had a pen, and he was taking notes consistently, even after I think they took the laptop away finally. Who knows if he was getting text messages on the laptop? Who knows what he was doing on there? It's highly improper. She goes on to say, Sue O'Connell, there's one juror who looks entertained by Alessi. One juror looks like he's ahead of Alessi. Judge again admonishes Welcher for using his report again, tells him to close it. 12 jurors taking notes during the clip testimony. That's when he talked about Karen Reed's clip or clip of her video, clip of her interview, causing him to change his report. She goes on to say, I wonder if Aperture makes money on the resale of the Lexus if the taxpayers of the Commonwealth will get the profit. At mention of, quote, Burgess, a juror smiles and puts his head down to write. And then there was a recess. That was an hour ago. And then she says, we're back. Alessi asked the judge to ask Welcher to shut off his computer. She calls the sidebar, instructs Welcher to shut off the computer. Alessi, you testified the day after Memorial Day. Welcher, I testified yesterday. Same thing, right? Most jurors are taking notes. She says, I've noticed that the jurors certainly took the judge's instruction about expressions seriously. I've noticed a couple of jurors having an unconscious facial expression, then immediately putting their head down. Jurors are very attentive during the key cycle question and testimony. This is my fourth exposure to key cycles, says Sue O'Connell. I know a lot about them. Key cycles are not associated to a time. Every time you start your engine, you start a key cycle. In order to know when an event happened without other data, you have to count backward from when the data board is removed and account for key cycles after the event, often moving the vehicle onto a tow truck, moving it in the repair or storage yard. Then she says, I don't know anything about tech cycles. When an objection isn't obvious, the judge can ask for a sidebar or ask the counselor for the basis, as she just did with Brennan. We saw that, I think, for the first time in history earlier. Jurors are paying attention and taking notes, she says, except for the one. So there's one juror who's not taking any notes. I find that interesting. Sidebar, it is a perfect spring day in Dedham. The courtroom is comfortable. Court staff aggressively use window ACs during the sidebars and recesses. Having the windows closed makes hearing a lot easier in this old courthouse. And then she shared some observations about the lawyers. Hold for a siren. Judges directing Alessi as to what words he can use in his question. Struggle now between Alessi and Brennan. The jurors are paying attention. That was as of 50 minutes ago. This is great to get her views on the jury because we can't see the jury, and with good reason. The cameras are not allowed to focus on the jurors. Another objection from Brennan. Judge calls a sidebar. And she says, here's an experiment to see if you could be a juror. Every time there's a sidebar, stop what you're doing. Don't use your phone or your computer and wait. You can stand, stretch, but not walk or talk. I think the judge asked one of the court officers if the juror's lunch has been delivered yet. He shook his head no. That was 45 minutes ago. Already she's trying to get a lunch break as of 45 minutes ago. That's a bad sign, getting this testimony going again. Alessi switches topics, asks Welcher for his title, biomechanical engineer, asks him to look at his report. Juror is attentive and paying attention. Welcher pulls out a calculator while Alessi is asking about Newton's laws. Alessi tells him he can't do that without the court's permission. 10 jurors taking notes during the force calculation testimony. Welcher explains G-force to the jury. Several jurors writing vigorously as Alessi lists calculations. One juror is holding his clipboard with his notebook up in front of his face as he writes in it. I don't know, that kind of indicates to me that perhaps he was trying to control or hide his facial expressions and he was unable to. Some jurors are definitely following this testimony. All jurors have been awake and alert since I entered the courtroom. That was of 31 minutes ago. Many jurors write in their notebooks when Alessi cites the age of the report, right? 46 years ago. You're relying on a study from 46 years ago to say that the overwhelming majority of injuries, the most common injury in a pedestrian accident is a massive head wound or a massive head injury. Jurors are paying close attention to Welcher's answer. Welcher finally answers that he doesn't know what the current reports say about what common injuries are from a pedestrian vehicle collision. That's literally your job. You have one job. One job as a biomechanical engineer, biomedical engineer, or whatever it is that you say that you do here. And you're not keeping up with current trends in studies? Did Vehicles even have VIN numbers 46 years ago. When that study that you cited was conducted, I think we learned that VIN numbers were first established in like something like 1954. Remember we Googled it the other day, or you guys did? Because we're so collaborative here. She then says jurors are ping-ponging between Welcher and Alessi during the discussion of Welcher's visit to Fairview. Welcher testifies he doesn't know where the impact was, road or street, that his feet were not on the curb. That's not really that his feet were not on the curb, Welcher's feet. Right. There are some wide eyes in the jury. One juror who has barely moved or shows expression is very attentive during Welcher's answers to Alessi's questions about what he knew and didn't know about the location of the vehicle and John O'Keefe. There's a break for lunch. And after the break for lunch, the judge called the sidebar. So thank you to Sue O'Connell for her detailed notes on what the jury is doing, because we can't see it, but we want to know what's going on. And she's telling us what's going on. So props to Sue O'Connell. Getting back to the questions. Thank you. Bling is the new black for your chitty chitty bang bang Instagram reel that you tagged me in. I shared it on my story and I thought it was amazing, because I did say the other day when I was on Lawyer, Peter said, do you think it would be a problem for her to get back to One Meadows to connect to the Wi-Fi at 12:36 if he was hit and killed at 12:32? And I said, well, not if she was driving chitty chitty bang bang and she could fly back to One Meadows, because even Jennifer McCabe testified. You don't have to take my word for it or Google Maps word for it. Even Jennifer McCabe testified that it took 10 minutes to get from One Meadows to 34 Fairview in that weather. So there's that. Thank you, Bling is the new black, for doing that. It was really funny and really cool, and I shared it. Churicity says, can you imagine how different ARCA is going to be for the jury? None of the ambiguous, quote, I don't know, or I think, real professionals. Yes, and I heard Betterow say yesterday that he thought, in his opinion, that they should call at least one of the crash daddies first in the order to dilute everything that they're hearing here and to show the jury how it's really done. One of my other amazing viewers here had another suggestion, and that was Brian Flynn, who said Proctor should be the first witness to establish no accident report. Therefore, no insurance company investigation. The jury should know this just before ARCA testifies. That's a great point. However, would the judge allow it? Would the judge allow any discussion of car insurance companies or, motor vehicle crash reports? I don't know. We've seen her. We've seen the way she rules in this case. We've been watching it for over a year. We've watched all the pretrial hearings for both trials, and I don't know if she would allow it. I don't know that there's a basis for an objection, but there doesn't seem to be any rhyme or reason about the rulings in this case from this judge. Strong Legs said that Lexus needs a deep scrub. Lots of dirty hands been on it. Collusion, not collision, says next week I'll be watching from Egypt at the beach with AJ. Oh, good for you, girl. Thanks for your great streams every day. Thank you for watching every day. Vivienne is FedExing my head back to me from downtown Toronto. I am a clown. David Cassidy, thank you. Another good suggestion for the playlist. He's a crash reconstruction expert and has not read new info, right? And he's not keeping up with current studies. And the fact that he said he didn't even know that there had been he's being made to look a fool. And Alessi's doing a great job with that. And apparently the jury seems very interested in what's going on. They're watching it like a tennis match. Cupcake Collaboration says for a new song revamp, change Jed to Judge. Thank you. KZ Gypsy Muse, Mel, whatever happened to Alessi being allowed a robust cross by Bev on Aperture witnesses? Well, he's doing it. He's doing it. He's doing a pretty robust cross. The problem that we have, and I have to go back to my notes to see where we are having an issue, is him being allowed to question about the timing of events and how the Commonwealth has changed their theory from trial 1 to trial 2, that originally Trooper Paul and his reports say that John O'Keefe was hit and killed at 12:45, and now they've walked it back and jammed the round peg into the square hole, or the square peg into the round hole, and she didn't let him get into that. So that remains to be seen. It's completely proper questioning. The jury should get to know about it. There's none of this like, oh, new trial, new rules. No, this is all he said, that he read Trooper Paul's report. He doesn't really remember what it said, you know, and he didn't really try to rely on it, but he has it. He read it. And so, yeah, I have questions about that too. And we're going to see what, where we land on that. But I think it's completely proper. And I think he should be allowed to be questioned about it. And we'll wait and see. Helena Thez says, thanks for streaming this. Thank you for watching. Charles from South Africa. This guy pulls his data from his lower aperture. Well done. Well done. Kelly, I was backing out of my drive this AM and my car decided I was going to hit a lamppost. I wasn't. Did an emergency stop, threw me back into my seat. It was angry. I'm sorry that happened to you. Hi, doubt my name is reasonable. I can't see what your emojis are, but thank you for your super chat. Yellow Lab Bowie, hostiles a glancing blow, break a tail light. Yes, I'm still waiting for that. That's where we left off, right? Was the glancing blow and the fact that he scanned the whole property, but he didn't take the berm into account because he really doesn't know where the body was. But he says it was 7 feet from the curb, but he doesn't know if Karen's car was on top of the berm or John O'Keefe's body was on top of the berm that he says is 4 inches. The timeline question is going to have to be addressed again. I don't think it's going to be abandoned at all because it is a huge part of his theory and his cross. But thank you for asking me that. Linda, wait, no, who's that? Contenta 1979. I don't know. He still hasn't explained how those injuries to John O'Keefe's arm got there. He didn't explain the exploding tail light. There's a lot of problems with his testimony, in my opinion. Best gun losing detective, aka Kevin Albert, is here. You should do a news stream after lunch because of that awful picture. I think we're okay on that. I think we're okay. I think I got it off screen quick enough, so we should be good on that. Thank you for suggesting, but I don't know if we need to because I don't know if it really read as a dead body because they did show a dead body. Right now we're good. We'll see. Thank you though for pointing that out. J Future One, Jay McCabe, can you show me? Welcher, let me show you. Yeah, let me show you. Let me get on my calculator. Let me anticipate your questions and start to answer. I'm just trying to help out here. I'm just trying to help out. Let me go forward in my report to find the answers that you think that you want me to testify about. Llama Mama Texas says, I'm done with this guy. Bring on the crash daddies. Can't happen soon enough for me. Cooperate this Hank says he used no science to back up his stupid theories. Will Wallace, sideswipe collision dynamics, dressing up like John O'Keefe was creepy dude, then tops it off with that bogus, bizarre simulation, now lying under oath. Isn't he a beauty? Yeah, but apparently the jury's riveted, so maybe they're picking up the same kind of things that you guys are picking up and trying to hide their facial expressions because they were, Kim Robinson with some breaking news. This just happened, Kim? Hang on. Edward McDonald says, I can say with certainty that there was a collision, but if you have tough questions for me, I simply don't have enough information to answer that. Yes, that is exactly. You're picking up what he's laying down. You are. Kim, where did that go? Kim says the U.S. Attorney's Office, District of Massachusetts, former Deputy Superintendent of the Norfolk County Sheriff's Office, arrested and charged with extortion. Is that breaking news, like right now type breaking news? Or has that happened as such recently? Howie Carr reported it on X. Oh, we love Howie here. You know why? Because Howie watches the show. Thank you. Thank you, Kim Robinson. You always have all of the deets. But this time when I quote Howie, I'm going to have to pull it up because people were saying that I was reporting things that actually I was reading off Howie Carr's Twitter. And that was, I can't even remember what the topic of that was. Do you guys remember what that was? Howie Carr shouted me out on his channel as the place to watch the Karen Reed coverage. So thank you. Let's pull it up because that's what we do here. And Howie Carr tweeted this 1 hour ago. Breaking. Feds arrest Tom Brady. Did you ever think you'd see that headline? Okay, it's not the same Tom Brady, but he is from Norfolk County. And the hack is also a goat. Greediest of all time. And he attaches a press release from the Norfolk County Sheriff's Office. So let's take a look at that press release. Just breaking today, and such divine timing, isn't it, that it's happening in the middle of the re-persecution of Karen Reed. For immediate release from the U.S. District Attorney's Office of the District of Massachusetts, former Deputy Superintendent of the Norfolk County Sheriff's Office arrested and charged with extortion. Boston, the former Deputy Superintendent at the Norfolk County Sheriff's Office. You can't make this up. You just can't make this up. Has been arrested and charged in connection with an alleged extortion scheme to force subordinate employees to perform free labor at his residence. Wow. Thomas Brady, 53 of Norwood, has been indicted by a federal grand jury on 4 counts of extortion and 3 counts of use of interstate facilities to commit bribery and extortion. Brady was arrested this morning and will appear in federal court in Boston later today. Turtle Boy talked about this weeks ago. Yeah, but I guess today he was arrested. So this is today's May 28th, right? That's awesome that Turtle Boy was on top of it. According to the charging documents, from 2021 to 2023, May of 2023, Brady served as the Assistant Deputy Superintendent for jail operations at Norfolk County Sheriff's Office. Brady was promoted in May of 2023 to Deputy Superintendent. It is alleged that between December 2021 and mid-November 2022, Brady utilized his official position and authority as an ADS to order 2 Norfolk County Sheriff Office maintenance officers A and B, who were subordinate in position to Brady, to perform home repairs at his residence during and after work hours. During the first instance in late 2021, Brady allegedly ordered maintenance officer A to install a new shower head at Brady's residence. Because of Brady's position and authority as an ADS at the Norfolk County Sheriff's Office, Maintenance Officer A feared that if they refused Brady's request, Brady would use his official position and authority to negatively affect Maintenance Officer A's job position at the Sheriff's Office, including the possibility of causing Maintenance Officer A to lose their preferred shift schedule position and or employment at the Sheriff's Office. It is alleged that Maintenance Officer A complied with Brady's order, and Brady drove Maintenance Officer A to his residence to install the shower head during Norfolk County Sheriff's Office work hours. Brady then allegedly drove Maintenance Officer A back to the Sheriff's Office to continue their workday. During the second instance, on or about February 13th of 2022, which was a couple of weeks after the murder of John O'Keefe. And they're just arresting this guy now. Are you picking up what I'm laying down? Which was a Sunday, Brady allegedly contacted Maintenance Officer A to fix his water heater. It is alleged that Maintenance Officer A was unavailable that day. However, the following morning, Maintenance Officer A allegedly drove to Brady's residence instead of going back to work at the Sheriff's Office to fix Brady's water heater. Specifically, after arriving at Brady's residence, Maintenance Officer A allegedly disconnected the existing water heater in Brady's basement, carried the water heater to their truck, and drove the water heater and Brady to Home Depot. There, Brady allegedly purchased a new 50-gallon water heater, which Maintenance Officer A carried to their truck, drove back to Brady's residence, carried it into the Brady's residence, and connected. Afterwards, Maintenance Officer A allegedly drove to the Sheriff's Office to finish their shift. Some people are saying this is old news. We knew this was coming. Well, I didn't know it was coming, and a lot of people here might not have known it was coming. So that's cool, but I'm still going to read it because it just broke. Thank you for your commentary. It is further alleged. Afterwards, Maintenance Officer A allegedly drove to the Sheriff's Office to finish their shift. It is further alleged that between October 22 and mid-November 22, Brady ordered Maintenance Officer B to his residence to fix the heating system. Because of Brady's official position and authority as the ADS at the NCSO, Maintenance Officer B allegedly feared that if Maintenance Officer B refused Brady's request to help fix the heating system, Brady would use his official position and authority to negatively affect the Maintenance Officer B's job position at the Norfolk County Sheriff's Office. So this is November 2022, including the possibility of causing Maintenance Officer B to lose their preferred shift schedule, position, and or employment at the Norfolk County Sheriff's Office. Maintenance Officer B allegedly complied with the order and on or about October 6th of 2022, drove to Brady's residence to troubleshoot his heating system during work hours. It is alleged that after Brady had subsequent problems with his heating system and contacted the Maintenance Officer B to replace the circulator pump. On or about October 15th of 2022, Maintenance Officer C allegedly learned that Brady was looking for Maintenance Officer B, and the two exchanged the following text messages. Just a heads up, someone is looking for you today. What the F did I do? The guy replies, and the other guy has the little shrugging emoji. And then he says, if I have to do it tonight, you around if something goes wrong? And then the person responds, for you. Yes. You know what this reminds me of? This reminds me of Nona's. Did you guys watch the movie Nona's that I recommended? I think it's on Netflix. Where he was like running the restaurant, and then he had a fire at the restaurant, and then his boss was looking for him, and all of his co-employees like covered for him so he could get back to his job at the MTA fixing the buses. On 2 occasions between November 1st, 2022 and November 2nd of 2022, Maintenance Officer B allegedly returned to Brady's residence with Maintenance Officer C assisting, where they drained the hot water system, removed the old circulator pump, and installed the new circulator pump. The charge of extortion provides for a sentence of up to 20 years in prison, 3 years of supervised release, and a $250,000 fine. The charge of use of interstate facilities to commit bribery and extortion provides for a sentence of up to 5 years in prison, 3 years of unsupervised release, and a $250,000 fine. Sentences are imposed by a federal district court judge based upon the U.S. sentencing guidelines and statutes which govern the determination of a sentence in a criminal case. 2022 was quite the year, and Nona's was a great movie, and I highly recommend. U.S. Attorney Leah B. Foley, and Kimberly Milka, acting special agent in charge of the FBI Boston Division, made the announcement today. Assistant U.S. Attorney Lucy Sun of the Public Corruption and Special Prosecutions Unit is prosecuting the case. The details contained in the charging documents are allegations. The defendant is presumed innocent unless and until proven guilty beyond a reasonable doubt in a court of law. What does this indicate to you? Feds are looking into Norfolk County for sure. And this guy, who coincidentally is named Tom Brady, is facing 4 counts of extortion. Each one of them carries up to 20 years in prison, and 3 counts of use of interstate facilities, which carries up to, what did we say for that one? Up to 5 years in prison. That's a lot of years for having a couple of guys from the job come fix your water heater. Was it worth it, Tom Brady? Was it worth it? All eyes on Norfolk County, 110%. And guess what? This seems minor in comparison to some of the stuff that we've heard about since just the beginning of the repersecution of Karen Reed, isn't it? Ironic, don't you think? A little too ironic. And yeah, I really do think that lying to a grand jury could carry a pretty stiff penalty, as could lying to the FBI, because that's a federal crime. And it took almost 3 years for them to arrest this guy for bringing a couple of guys from the job to fix his water heater. I mean, that seems kind of like a nothing. That seems kind of like not such a big deal when you compare it to lying to a grand jury and lying to the feds. But you know, what do I know? Just sitting here spitballing with you guys. What does it lead you to believe? My. We're all lost in space. Here's what Lester Harris had to say earlier. Trigger event 1162.2 is at 12,629 miles. Karen's leaving John O'Keefe's house at 5:07 a.m. She backs into John O'Keefe's car, 12,629 miles, plus 3.1 miles to Carrie Roberts, plus 1 mile to Jen McCabe's, plus 2.4 miles to John O'Keefe's, plus 30 miles to Karen Reed equals 12,665.5 miles. One correction I have for you, Lester Harris, is that Karen did not go to Carrie Roberts' house that morning. That might take 3 miles off your calculation, but she went, or however many miles it is from Carrie, she went from One Meadows. She said, I think she did testify, or she doesn't testify, Karen Reed, but she did say she drove around a little bit before she went to Jen McCabe's house. And then Jen McCabe drove her car back to One Meadows, where they ran in the house. Karen didn't take her shoes off, and therefore she's guilty because she must have killed John. That's why she knew she killed John, because she knew he was never coming home, and therefore she killed him. And then the car stayed there until it went to Dighton. That's my understanding. So your calculations are pretty good. But we also know during the first trial, Trooper Paul said his testing was at 1164. He created that key cycle. And I know that he's kind of dopey and doesn't even can't even probably tie his shoes so well without doing the whole loopy thing of the bunny ears and then pulling them. But I would imagine that he knew what key cycle he created, unless they're going to throw him under the bus too. But that needs to be brought out. The judge needs to allow it. And we are outraged. And hopefully it's going to happen. But thank you, Lester, for doing all of that work. And look at Lally's knee symbols coming in from Canada. That's hilarious, because I know where she gets it from. Her husband's account is Lally's Harmonica. I said that during the first trial, Lally was like a one-man band. He tried that whole case himself. It was like he had a harmonica in his mouth. He had cymbals between his knees. He was playing the accordion. He had like a clown horn underneath his armpit, and he was like a one-man band. She says, watching you under the big screen under my husband's account, Lally's Harmonica. We love you, Melanie. Your emotional support, Canadians. Thank you. I'm happy to be. You are my emotional support, Canadians. Thank you so very much. And yes, I'll allow it. Pamela Bailey says, in Massachusetts, expert witnesses are generally allowed to refer to notes and reports while testifying, but it's subject to the judge's discretion and requires a request for permission. Thank you, Pamela, for pointing that out to me, because the rules vary jurisdiction to jurisdiction. I am a New York barred attorney for many decades, and the rules in Massachusetts seem to be defying and straining credulity for so many of us who practice in other parts of the country. Thank you. Vivian, we went over that. Thank you so very much. And thank you, Best Gun Losing Detective. And Glamasu says they will not be able to sell the Lexus in California due to emission laws. Cars have to be specifically made for California, emissions, exhaust, etc. Thank you. Thank you. Thank you, Liz. Liz 58 for your super sticker as well. Michael Geyer says both Welcher and Brian Higgins had a dog in this fight. Oh, well done. I see what you did there. Be a good human. Is it just me, or has Bev seemed a bit more fair this week? Perhaps her award, or maybe comments by lawyers and judges on award night made her think twice about being so biased. That's interesting, because I don't know. Did people get up and speak about her? I'm not aware of any of that stuff, but maybe. Or maybe this indictment being handed down today and the arrest of this Norfolk County sheriff is giving some people in public service in Norfolk County a little pause. And they're saying, wow, if they're going to federally indict the sheriff for bringing 3 maintenance workers to his house to fix his water heater all the way back in 2022, what's going to happen to the people that lie to the grand jury or lie to the feds? It's mind-numbing. Donnie R says, if I were a juror, I would be livid if an expert used data from 1979 to try and trick me. Yep, I agree. Heather says, last night I was talking to my husband about this guy and the spoiler hurting John O'Keefe's eye. My husband said, I thought you said there was a curb at 34 at Fairview, so that would make him 4 to 6 inches taller. And I thought I remembered somebody testifying that it was a 6-inch Cape Cod berm. Does anybody else remember that? Why is the chat frozen on my phone? I don't know. Is YouTube have we broken the internet again with the Karen Reed case and everyone who's streaming it on YouTube and everyone who's watching it on YouTube? Thank you very much. Let me just duck from here for a quick second. I'll be right back to you. But I need to put my lunch order in because while the jury has their lunch available to them, I currently do not. So give me a short break. Seems that they have 10 more minutes on lunch. Everyone go fill up your drinks, get your popcorn, do whatever it is that you need to do to make yourself happy for the rest of this afternoon. And I'll be right back at you in a moment. And we're back, but the court is not. Court is not. Get to some additional questions. Thank you, Donna, for your very generous Venmo. Says we're on our way to Dedham. Please give a shout out to my niece, Sam, and I. Sam and Donna, safe travels. This was from early this morning, so I'm sorry. I'm just getting to this now. Thank you for all you do. Thank you for all you do and for going to support outside the courthouse. I haven't seen many pictures of what's going on outside the courthouse since the buffer zone has been changed. And tell me where I can find those. Oh, the fan is coming back up now. All right. Hang on. Thank you, Jonas, for your free Karen Reed Venmo. Thank you so very, very, very much. Let's see. Should we do Alice in Wonderland today? Alice looks good. I like the blue. We could do tie-dye. With the dancing bear down there. That's kind of cute. Maybe we'll do that one for a little while. Or is it too distracting? I don't know. Too many cooks in the kitchen. Thank you, Jonas, so very much for your Venmo and for saying free Karen Reed. Also, thank you, Linda, for your Venmo. Says thank you. Karen says thank you. Thank you, Karen, for watching. And Carla says thanks for being here. No, thank you guys for being here, because without you guys, I'd be watching this alone and just yelling at my TV. Stephanie, thank you for your very, very generous Venmo. Says, wow, just wow. My head is popped off and following you in somewhere north of Neverland. That's it. It's Neverland. We are in Neverland, Narnia, Inside Out, Upside Down, Hunger Games of Massachusetts. We're feeling it. We're feeling it. This is a mishigas of levels that I've never seen before. Thank you, Caitlin. Says, is rage laundry folding a thing? It is. For some people, they like rage folding laundry. I'll allow it. It is. I'm doing it. This effing guy is abhorrent. Thanks for being you. Thank you, Caitlin, for being you and for watching and for being a fine and upstanding participant of this channel, as is Shelly. Shelly coming in hot says, this poor excuse of an expert thinks he's going to beat King Alessi. Love you. Nope. I love you more. Love you more, Shelly. Meredith says, love your coverage. Thank you, Meredith, for watching. That is where we are at current. We have more questions over here and in here. And this guy keeps taking notes, and I don't like it. I don't like it. They should take his pen away. Okay? They should take his pen away. If he doesn't know his own report and opinions, then he's got no business with having a pen to try and remind himself what his opinion is. Ed Wallace was here earlier. Hi, Ed Wallace. I'm sure your head is somewhere with mine in an undisclosed location. Says, this whole case is a shit show. I mean, in my entire 41 years working in the criminal justice system, and I have testified in 399 trials as a court-qualified forensic expert. He has never seen anything like this ever. Ever. Never, ever, ever. Ed Wallace, Duty Ron, my guys. I had my start with them over 2 years ago. And I highly, highly value both of their opinions. Thank you very much. We covered this. Dennis the Menace from Canada says, cow poof baffles brains. Welcher has more BS than brain cells. Tooth extraction yesterday was less painful than listening to Welcher. Thank you, Dennis the Menace. Kelly, JW, Judson B. Welcher, used his head to show spoiler would hitch on O'Keefe in wound area. Later says head movement not counted, but this would higher or lower or move sideways wound area. Oh, yeah, we're going to get into it a lot more. Ed said his head went all the way to Australia yesterday, says Cindy B. Anyone seen Bev's grave concerns? Great username. Love it. Where are her grave concerns now? How were they just provided with this man's new report at 3 p.m. on Memorial Day, which was not even 48 hours ago, the day before his testimony, based on her new interviews that have been in existence for months and months and months? But I guess we're going to get more into that. Sandy RN from Cali says, Welcher asking Alessi to introduce himself. Oh, yeah. I'm sorry, he said, before Alessi even opened his mouth and was at the podium. Welcher says to him, I'm sorry, we haven't been formally introduced. What's your full name? I mean, the way he started off on that. Yeah, Team Brittany says Jimmy Hoffa had grave concerns too. Sandy says, love you, Melanie. And I'm sure our heads are passing each other when rolling all over the U.S. You can't make it up. You just can't. I'm Cora, not Chloe. Says 46-year-old report equals cherry picking. David Reese, yesterday when I went back through the chat, I saw that you had a mistaken super chat. And if you need my help in trying to get refunded, just email me. My email is in the show notes below, and I will try and do what I can to help you with YouTube, because that must have been very distressing for you. I dig. Dawn Burke says, I can't believe this guy. Thanks for being with me for 9 months, Dawn. And Be a Good Human says, became a member. Welcome, welcome. Some people were asking how they can become a member or get a gifted membership, and you have to be opted into that. There are 3 dots next to your name, depending on your device. Then you have to opt into gifted memberships. And then when someone gifts memberships, like people are doing today in a very generous way, YouTube randomly selects the winners. It has nothing to do with me. Noelle says, have you heard The Fix Is In by Miss Shorty, a beautiful, soulful voice? No, I have not. Listen, thank you. Tamara Combs, hostile expert. He technically, he's a hostile witness because he is already on cross. They didn't call him. The defense didn't call him. And so this is pretty much the definition of one, but he doesn't need to be cleared as one because he's not called by the defense. Lucid Visionary Girl, 88. When I'm writing research papers, clinical-based studies older than 7 years aren't applicable to be used. That's interesting. Thank you for telling us that. Also important to see if the study can be replicated or randomized. Yes, yes. If you weren't here for all of the pretrial shenanigans, tomfoolery, and ballyhoo that we covered, you will know that you would know that Mr. Alessi, who also is a licensed pharmacist, by the way, is very big on methodology and the methodology that needs to be used and how it can be tested and replicated. And so thank you for pointing that out. And know that Alessi is so on it. He's on it like white on rice. RJ Larson, rear tire won't spin like he says. Traction control. Thank you, RJ. Book Hermit from Australia. Playlist Skyhooks, living in the 70s. Thank you. Wait, what? It says, did he calculate the force required to break the taillight? I think we're going to get there, maybe, at some point. Maybe. Apparently, he knows calculations, unlike Trooper Paul, who didn't even know the definition of kinematics. And if you did not watch Trooper Paul's testimony from last year, go back and watch it. It's on my Karen Reed Trial 1 playlist. Tune in for those days because that was some comedy gold. It was so good, in fact, that during this year's Super Bowl, I did a halftime show with my viewers and we rewatched it just for some comedy gold because you couldn't make it up. Crabtree wants you to give Suzanne a shout out, Attorney Melanie Little, and get well soon, Suzanne. Get well soon, Suzanne. Get well soon, Suzanne. I didn't know you were sick. If it's the Suzanne I'm thinking of, and I hope you do get well soon. So thank you, Team Brittany, for pointing that out to me. And I only saw that because I'm watching my phone, because when you guys tag me, it doesn't come up in StreamYard. StreamYard has a lot of things that could be fixed, and they didn't call me. But if they do ever call me for a meeting, StreamYard, call me. I have a lot of suggestions for you because you're charging a lot of money for your service, and really, it's not that great. It's not that great. I mean, fortunately for you, there's not a lot of other options for streamers, but what you got going on here really isn't that great. Wolfram, new song for the Commonwealth, Liar by Three Dog Night. We've got Henry Rollins' Liar on there. Somebody recommended another Liar song that we put on, I think, yesterday. So many songs, so little time. Thank you very much, Wolfram. Charles Argo from South Africa. So an SUV collides with a guy at 24 miles an hour, and he gets a small cut on his eye. The ground would have been soggy wet grass. Thank you. Christina Reynolds, Rage Against the Machine, Shine. Rage Against the Machine, Shine. Know Your Enemy. I think it's on there. Cruelty-free, passionata, snark. All previous sightings of Mel's Head are fake. The real one just passed me as I swim backstroke across the Atlantic from the UK to New York. I swear. I swear it. Thank you so much for your snark and for your super chat. And Todd Sandler, thanks for becoming a member. I'm happy to report that our male viewership has increased quite a bit, and we are up to almost 30% men. When I started this channel, it was around 17%, but the men are coming in hot with the Karen Read case because they are outraged. Many of you are law enforcement, retired or current, and you are outraged by the corruption in this case. Maybe because historically it's more women that watch true crime than men, and I'm so glad to see that you're here, you're participating, you're on it, and I thank you so much for that. Let me just see. Bunch of new songs came in hot yesterday. So many songs that you guys have turned me on to, including this Still Alive song from a video game that mentions Aperture science in it, which is crazy because I'm not a gamer. And so I didn't know about this song, but I have it on my Instagram story today. And it's a crazy song because it says like Aperture science. Remind me of what the, hold on, let me just put on the lyrics for a second. Aperture science, come on, play. We do what we must because we can. Aperture science, we do what we must because we can for the good of all of us, except the ones who are dead. I mean, you can't make that up, right? It's from a video game, apparently. The 6-inch berm was Officer Leafblower. Thank you, thank you, thank you. So it was Gallagher who testified to that, right? That it was a 6-inch concrete or 6-inch asphalt berm. Thank you. It was Gallagher. Gallagher told Good. Gallagher manned the leaf blower, but it was Sean Good's leaf blower that Gallagher said, shoot home to your house, get a leaf blower, shoot back. I thought it was a great idea. There's nothing wrong with the procedure. And Tim Donahue says, Melanie, the game is called Portal from Xbox. Thank you. I'm sure we have an Xbox around here somewhere. Children, if you're watching, do we have that game, Portal? All right, I'll allow it. Yes, thank you so much. Somebody else actually sent me a Google search about the berm and said that Google says it's 4 inches. Mitchell, thank you so much for that. Google says curb is 4.5 inches. But again, I don't like to go by Google and or AI, but I like to go by the testimony of the witnesses. So while some Cape Cod berms could be something like 4 inches, I wanted to know what the testimony was in this case, although I do appreciate your willingness to Google in assistance to me. And so thank you, Mitchell. You're awesome. Hang on. Un momento, por favor. So we have it in the testimony. Thank you very much. And thank you for Ash DeGaulle for your super sticker. And more of Alessi says your response to the chatter who said Tom Brady arrest is old news. Thank you. I call it the Alessi. The Alessi, thank you. The polite answer to rude, unnecessary, unwanted input. Oh, I like that. The Alessi. The Alessi, thank you. The polite answer to rude. I know everyone's like, it's old news. It's not old news to me because I never heard it before. So I thought it was important to share because it just broke today and Howie Carr just tweeted it. And isn't it ironic, don't you think, that it happened in the middle of the re-persecution of Karen Read when there's a guy on the stand who's like the best hired gun that the Commonwealth has, so good, in fact, that he's their closer. He's their closer. They've already paid him $44,500, or his firm, or his former firm that is now Aperture. And they're intending to pay them another $325,000. So, they'll be making it cool, maybe $500,000 by the time it's over. They'll have to do more stuff and things. And if his travel is going to be billed later. Thank you, Sarah C. I'm more of Alessi. I like it. The Alessi, thank you. Unfortunately, sometimes with this case, I need to use the Alessi thank you on the daily. Let's see. Yellow. I'm going back to purple. It's an executive decision. Thank you. Kelly Mack is just back from jury voir dire. So glad I wasn't picked so I can watch this here. But I'm glad that you did show up, Kelly, because jury duty is so important. And I want you all to serve if you can. I wish I could. They're back. God save us from the Commonwealth, my friends. I love Nancy Drew, Tawanda Nazama. I love Nancy Drew. I think I still have the hardcover series. Okay, Smoking Gun. Higgins hit his Jeep and lured John to enter via the backyard to the basement. Nagel's brother saw no Jeep, but Jen said Higgins left 15 to 20
Go
minutes
ahead,
before.
Mr. Alessi, whenever you're ready.
Well done, Tawanda Nzama, aka Nancy Drew. Thank you so much.
Just take a moment, Your Honor, to reorient. I'll be right. Good afternoon, Dr. Welcher.
Good afternoon. Nice to see you again.
Same.
Nice to see you again.
We
Really?
had left off talking about some examples of Newton's second law and the application of it in the parlance of force equals mass times acceleration. And I now want to continue on with that discussion. It is correct that you can conduct a force analysis on any part of the body, correct?
I mean, it's more difficult on internal with live people. Like if you wanted like my appendix, I really necessarily couldn't.
Let's talk about the musculoskeletal system, the outside bones. You can conduct a force analysis
So your the
on any
bones are on
bone.
the inside.
Sir, if I could finish my question, please.
Okay.
You can
So
conduct
rude.
a force analysis on any bone in the body, correct?
More or less, yes.
Not the appendix.
So the force analysis I use as a synonym with Newton's second law is not exclusive to the head, correct? You can do it on other bones in the body, correct?
Correct.
On direct examination, your direct examination here, you did not present a force calculation representing what you allege to be contact between the vehicle and Mr. O'Keefe's right arm, did you?
Correct.
Well, how did it break a tail
And
like that?
nowhere in your report do you present a force calculation for Mr. O'Keefe's right arm, do you?
Correct. We didn't have enough information. to
That's
do it.
fatal to his analysis. in
We're
my
going to get
opinion.
to that.
Okay.
Now,
Thank you, Orly.
given that you stated that, quote, determining the effects of physical forces on the human anatomy, end quote, is the job of a biomechanical engineer, you must have conducted several force calculations related to accidents involving humans in your career, correct?
Hundreds.
Hundreds. Now, you didn't present a force calculation in your materials, as you've stated on direct, with regard to the arm, and I'll include in the right arm going from the shoulder all the way to the tip of the hand. Okay, so that's my definition of a right arm. You didn't present any force calculation on that part of the body of Mr. O'Keefe, did you?
Correct.
Assume, and we're going to apply Newton's second law. Assume Mr. O'Keefe's hand weighed 7 pounds. So that's the M in the F equals MA.
That's not a good assumption.
Well,
It's not a good assumption
What
that the arm weighs 7
number
pounds.
would you like to apply for an M for the hand of Mr. O'Keefe? I'll take any number you got,
Just the hand?
just the hand.
Oh, the whole arm of Mr. O'Keefe weighs approximately 12 pounds.
Okay, fair enough. So the whole arm is from the shoulder down to the tip of the fingers is about 12 pounds, right?
Correct.
Okay. So assume that the Lexus SUV was traveling at 20 miles an hour. All right? Under your theory going backwards, 20 miles an hour. And the third variable I'd like to give you is to assume an impact window of 10 milliseconds.
Okay.
Can you calculate the G's of force from that data?
Does he have his calculator out?
You need more information.
Well, let me ask you this.
We do.
What more information would you need?
So we talked about the glancing impact.
I'm talking about a force calculation of an impact, not as to whether it's glancing or not.
So you want a direct head-on impact in the arm, not a glancing hit to where the Lexus comes in, hits the arm, and they continue off together?
I'd like to start with that, but just so we can hopefully expedite it for the jury.
Okay.
I'm going to want to get to what you have depicted in your diagram of holding the arm out. And that's not a glancing impact. Is that, sir, with the right arm in parallel with the back of the Lexus?
Yes, it is. So really I'm sorry, let me finish, please. What you're concerned about is where the center of mass is, but the center of mass out towards the corner of the car, that becomes a glancing contact. So you don't have a center of mass contact, you have a glancing contact.
Okay, fair enough. So let's start the first force calculation.
I need my calculator.
He needs his calculator.
Sure.
Okay.
Tell me what you want.
Is it one of those TI 84s? Those things are expensive, man.
Scenario where it's a center of impact,
Center of mass.
center of mass impact, right?
Okay.
Impact to the right arm.
Okay.
Let's start with that one.
Okay. And you want me to use like a 10 millisecond?
Yeah, be conservative. Yeah, let's use a 10 millisecond for
Okay.
the impact window.
Who do you think is smarter, Alessi or Welcher? And who do you think is smarter than a fifth grader? Do you think Welcher is smarter than a fifth grader? Do you think he should have been a medical doctor like his dad told him not to be, but he could have been, but coulda, shoulda, woulda? There's a great song for the playlist, huh? Little Taylor Swift action. Math is hard. Math is hard, but he's got his calculator. I don't know why it's taken him so long. Alessi is definitely smarter. Says, oh, sweetie, no. Melanie's Cupcake Posse, Sherilyn, says Alessi. Little White Lie says, you can use your toast account if you need to, Judson B. Judson Blair. AJ internally losing his shot, says Bev's buys beratements and rulings. That's a lot of, he's doing a lot of calculations, isn't it? Like, should it take this long to do the calculation? I don't know. You guys tell me. I'm not a math whiz. I don't even know if I'm smarter than a fifth grader. I got people for that. Texas Instruments and Radio Shack are back. He doesn't like the answer, says Sweet Caroline. Mitchell pointing out that Alessi is definitely smarter because Welcher is using Burgess's data. He's so extra, says Naz. Show your work. So go, Judy. This is he's got a calculator and a pen. Is it a Mont Blanc? I can't tell from here. Somebody says he's probably texting. He's racing. He's erasing. He's texting Brennan, somebody said.
Okay. Question?
What do you get for F of force in the F equals M times A calculation?
About 2,188 pounds. I made a triangular crash pulse assumption.
Right, and if you took the milliseconds in half, become less conservative, would you end up doubling the 2188 number?
If you cut it in half, you would double, yes.
Exactly, through a simple mathematical semi-algebraic
That pen is
application of the
that
number,
mechanical
correct?
pencil.
You divide,
We're doing a little simplification in terms of the crash
Yes.
pulse shape, but generally, yes.
right. So,
Is that your
but
final
let's
answer?
take the conservative number, the lower number, 2188 that you came up with.
Would you like to phone a friend? Dr. Judson
Do you
Blair.
know from the literature As you did with the head, you went to the literature and said, this is how much pounds of force the you would get to have to cause a break at the occipital bone. Do you know from the literature how much force it would take to break an arm bone?
I have an idea, yes.
What is your idea?
So for a distributed load, such as this, not a concentrated load, you're going to need somewhere between, I've seen, and this is for cadaver tests, a low of like 2,500, maybe a little lower, to a high of 7,000.
Sir, you have switched, haven't you? We're talking about center mass impact. Did you in your calculation just switch to a side swipe impact?
Smart,
Do your calculation.
He's so smart.
I'm asking about a center of mass impact. How much force would you need? Let's start with the hand. Maybe it's a simpler one. Do you know how much force it takes to break, any of the hand bones, you know what I'm referring to, the phalangeals?
Yes.
The metacarpals, and the carpals?
Correct.
How much pounds of force do you need to break any one of those bones?
Actually, I didn't find any distributed loading on the amount of force. I don't know.
Well, no, I understand, but I'm asking, do you know from the literature, not a calculation? Doesn't the literature tell you? Can't you go to the literature like you did with the head and you say, okay, to break the occipital bone, the literature says you need a minimum amount of force of this. I'm asking you the same question for the hand. If you don't know, it's okay, but do you know what the literature says for how much force is needed to break a bone in the hand?
So for a distributed load across the hand, there are distributed load tests that show you need over 300 Gs on the arm to do that. So it would depend on the mass of the hand.
What is the range of force that you would need to break a bone in the hand? Do you know from the literature? If you don't, that's okay.
He's humming.
I could probably figure it out.
How long would it take you to figure it out? Do you know from the literature what that number is?
Not off the top of my head, no.
Is 300 to 400 pounds of force sound right from the literature that it would take to break a bone in the hand?
For a distributed load,
Yes.
such as the taillight, no.
No, not a distributed load. A load from a motor vehicle going backwards.
Right, that's a distributed load.
Right. So you're saying 300 to 400 pounds of force would not be enough to break any bone in the hand. Is that your answer?
So for a flat distributed load, like hitting the taillight, you're gonna need higher.
How about another part of the back of the vehicle?
I guess if you hit on the very corner and it wasn't a distributed impact, like if you had a more concentrated impact,
Yes.
that could increase or decrease the amount of force required.
How much would it decrease it from the number you gave?
Depends on what you're hitting, what it's made out of.
The
Contact
Lexus
area.
SUV. Let's assume, I'm sorry.
Can you repeat the question, please?
Absolutely. Thank you. Let's assume we're talking about this Lexus SUV,
Mhm.
right? But let me back up. You don't know where exactly, under your theory, that there was a contact. You don't know, you testified to on direct, you don't know exactly where that point of contact is.
Correct,
You don't,
except it's on the taillight.
well, you're saying it's on the taillight, but you didn't observe any impact yourself personally, right?
Did I see Miss Reed's Lexus?
You didn't see the impact, correct?
That is correct.
So, and there is no firsthand witness that saw, under your view, that a collision occurred. There's no witness to say where the arm was, correct?
There's no person that saw it.
Right. And you have chosen a point of contact, okay? You chose that for your analysis, correct?
Correct.
And you picked that location, but it's also possible that under your theory that a collision occurred, that that arm could have been impacted any part of the back of the vehicle. That's possible, isn't it?
That's not probable, no.
I'm asking, is it possible?
Anything is possible. I don't deal in possibilities, I deal in probabilities. It's not probable.
So, but you don't know exactly where the point of impact was. correct?
So within the range of the light and the exact angle of the hand, no, I don't. What I do know is at the rear tail light area.
So your assumption is that it had, that because there's a tail light that is altered, it must have been by Mr. O'Keefe's arm. That's your conclusion, correct?
My conclusion is there are
I don't
tail
think
light
he wants
fragments, a broken glass, lacerations to his arm, and his DNA on the back of the vehicle in the area of the taillight.
Sir,
That sounds like confirmation bias to me. That those are not his. He said those are his conclusions. I gotta take that back. Sherry via Cash App says, now we know why his dad said no doctor for you. That's his conclusion. All of those things were things that were given to him. Those were alleged facts of evidence, and I use the term loosely, that were given to him. That's not his conclusion. Listen.
that's your conclusion, correct?
My conclusion is there are taillight fragments, a broken glass, lacerations to his arm, and his DNA on the back of the vehicle in the area of the taillight.
Sir,
It's your conclusion?
and
My-
I'm going to move to strike the DNA part of that answer for obvious reasons.
Look at David
I'm
United's
not
face.
going to strike it.
Okay, so you're making assumptions. You're taking what you view to be certain data, and you're coming to a conclusion, but that is based upon circumstantial information, correct? Is that fair?
Are you calling like pieces of the taillight at the scene around his body circumstantial information?
Sir, let me go to
Oh, wow.
go back to the force analysis. Let's
wow.
go back to the numbers. I want to stay on, if we can,
Bang,
just
bang.
the calculation.
Judson Blair.
So let's
Bang,
go
bang.
back to the minimum amount of force. You understand from the literature that it takes to break any bone in the arm from the finger up. Let's start with a hand. What's the minimum amount of force that can be applied to break a bone in the hand?
So it depends on the loading. So I don't actually know. In terms of the forearm, I can tell you there's data that shows up to 300 Gs of loading, you will not get fractures. There's one up to 750 Gs showing no fractures for a male of similar height and weight of Mr. O'Keefe.
Thank you.
You're welcome.
So let's take those numbers,
Okay.
okay? You said 300 and 750. Did I hear it correctly?
You did?
Okay, that's the numbers you gave that would break a bone, correct?
So the 300 actually didn't break any bones, I believe. The 750, the one example, didn't break a bone, but as you got above 350, you started to break bones.
So as
300.
you got above 350,
300.
above 300, yeah, because that's what I thought you said the first time. You got above 300, you start to get breaking bones, correct?
Correct.
And so if you take that 300 number and compare it to the 2,188 pounds of force, you have 7 times the amount of force necessary to break the bone, correct, in the force analysis?
No. If you take
No.
300 Gs
No.
times a 12-pound arm, you get 3,600 pounds. The calculation you asked me to run earlier gave you 2,188 pounds.
Right.
So you are 1,412 pounds above the force required. Like the tolerance is 1,412 pounds above the force you would say get in a 20-mile-an-hour impact in terms of the fracture forces.
Let's do it this way.
I'm sorry?
Let's do it this way.
Okay.
The force that you calculated from my hypothetical of this Lexus SUV going backwards, you came up with the F number of 2,188, correct?
I'm sorry, I didn't, what was the, you said? No, you said
2,180.
dyslexic? Or did you say Lexus? I didn't understand what you said.
The Lexus
My apologies.
SUV that you've been talking about,
Gotcha.
okay?
I didn't hear
You
it.
came up with a number for F for force of 2,188. Are you changing that number?
Nope.
Okay,
absolutely
so
not.
let's go with your number of force from this vehicle of 2,188. I'm just simply asking, how much force does it take to break a bone in the right arm of a human being? How much force, not acceleration, how much force does it take to break a bone in the right arm?
Sure. So
Sure.
somewhere between 2,500, the one cadaver tested the distributed load of someone of similar size and weight, and actually close in age to Mr. O'Keefe, showed about 7,000 pounds of force to break it.
Let's go to the hand. Do you disagree that the literature shows it only takes 300 to 400 pounds of force to break a bone in the hand? Do you disagree with that?
Your question's too general. I can't answer your question. It depends on the loading. If I take my pencil, which has a very fine point, and jam it through my hand, I can jam it right through my hand because it's a very small point. But if I distribute the load and a broader load, such as hitting a taillight, it takes much more force because the load's distributed across it. It's like if I sit on the corner of my bed.
Don't
I
look at
might
the
sink
jury.
in this far when I
Try
sit
and
on the
make your
corner of my bed.
nonsense seem.
But what happens when I spread my load out, when I lay on my bed like this?
There's
I
a
don't sink in
load,
as far.
that's for sure.
Has my weight changed? And weight is basically force. No, but I've distributed it over a larger area. So for a given force, you get less sinking into the mattress. So if you hit a broad surface like a taillight or a wall like
Broad
this,
surface like a
it takes
taillight.
much more force than if I were to take a singular small round object and jam it into the hand. That hurts. This does not.
Okay, if you can hear my question, if it's unclear, you tell me. For not a pen, not
When he said this hurts, he jabbed the pen or his mechanical pencil into the back of his hand. And he said, this hurts. And he even winced, like maybe it really hurt it. It hurt. Then he smacked the back of his hand against the side of his little box that he's sitting in and said, this doesn't hurt, in case you weren't watching.
your bed, but for a Lexus SUV of 6,000 pounds, is there any part of the back of the Lexus in any manner where you can get a break to the hand from 300 to 400 pounds of force?
Any part on the back of the Lexus?
Yes.
Probably.
Okay. So probably, your words, you can get a break to the hand from just between 300 to 400 pounds of force. That's what you just said, correct?
So you're taking the totality of the back of it? Like if you got it stuck in the bumper? Potentially, yeah. But from a taillight or a broad flat surface? No.
I can't do this anymore, you guys.
Any part of the back of an SUV, you agree that it is probable that you can get a break of the hand bones from just 300 to 400 pounds of force?
Your question is incomplete, right? You said any part of the back, but then you wanted me to not include taillights or not include the rear body panel. If you hit a very narrow part of the car, like say the edge of the tailpipe,
The edge of the
that
tailpipe
creates
now.
much more of a narrow contact. So force divided by area is pressure.
Looking at the
So if
jury
you have
again.
a very tiny
trying to
area, you
convince
have
them.
very high contact pressures.
Thank you, Mindy.
And so, but if you distribute the load over a larger area, the number on the bottom of that fraction is much bigger. So your contact pressure drops. So hitting the edge of the exhaust pipe is going to have a much higher likelihood of causing a fracture than hitting flat against the tail light.
Okay, what we're going to do to make this more efficient, excuse me, sorry. Mr. Wolf, can you pull up a slide from Mr. Wolf's or Dr.
Oh.
Welcher's presentation for the back of the
My God.
Lexus, please? The back hatch, and Your Honor, may we publish that?
Sure, do you know what number though, Mr. Alessi?
What just happened?
Mr. Wolf does, and
And
I
then
know
he'll
you
tell
need it, so
us.
he'll tell me before I publish, and then we'll give you the number.
Your Honor, may I look here?
Yes, I'm going to let Dr. Welcher look at his slide
Oh, sure.
here
Yeah.
instead of just.
Something just happened. I don't know what.
bad
Mulva
patch,
is
yes.
here, and I will always allow a good Seinfeld reference. Isn't Alessi also a pharmacist? Yes. Yes, he is.
You have one of just the rear gate. The one measuring the height, maybe. There we go. Thank you. Okay, this is your slide presentation. Is there any part of the back of the Lexus SUV that has that more concentrated area where if the hand hit it, 300 to 400 pounds of force could break it? Is there any part, for example, the edge of the license plates, above the license plates, the L symbol that sticks out that would be concentrated? Anything you see there could 300 to 400 pounds of force contacting at any of those points cause a fracture of any of the bones of the hand?
So, I don't know how to show this because in the middle photograph, right where the 2 is on the license plate,
Yes.
there's a vertical edge. That area is recessed in. So if you hit right on that vertical edge, that could potentially do it.
That could do it. How about the L of for the Lexus symbol if the hand is there?
No, it's not deep enough. The compliance of the hand is just going to sink into the car.
Is there any other part other than the license plate that the force applied, you would only need 300 to 400 pounds of force to break the hand?
Maybe the exhaust pipe, and potentially if you hand your hand up near the spoiler.
Right. So now let's go from 300 to 400. Let's go to the 2188, which is your number. Use 2188. Is there any place where in 2188 force you could have a fracture of the hand on that back gate?
Just to be clear, 2188 is the number I calculated for you. It's not, quote, my number.
I understand, but we did.
So-
I understand, but we did the calculation. Is there anywhere on the back of the vehicle where 2188 could cause a fracture of the hand?
So that was a forearm fracture tolerance I thought we were talking about, because we used the weight of the whole arm for that.
We did. And my question is there anywhere in the back of the vehicle, in your opinion, that could cause a fracture with that?
I'm sorry, what, to the hand?
To,
Just the hand or the whole arm?
I'll take any part of the right arm. You call it the hand, the forearm. Is there any part that could cause a fracture?
So probably similarly, if you got your forearm down near that transition, like, I don't know if you can see the little dot. I'm talking about this area.
Yes. Yes.
Right here.
Yep.
So that transition between the two body panels.
Yes.
That could potentially do it. That's back where the reverse lights are. I'd have to look at whether, that would take it before breaking the plastic. And then, again, maybe if you hit the exhaust pipe as well, it's a much more narrow loading condition.
Shut up, fool.
The corner of the tail lamp. I suppose if you had just your hand on the very, very corner, potentially.
But you didn't do any of that force analysis for this case, did you?
For the hand, no.
But you did it for the head, correct?
Correct. Because that I'm able to quantify.
Mr. Alessi, that was slide 108. I just want to
I'm
keep.
sorry,
track.
Your Honor. Yes, Mr. Wolf. Yes,
All right, thank you.
thank you.
Don't make me mad.
You are aware, Dr. Welcher, that Mr. O'Keefe suffered no fractures of any kind in his hand, correct?
Jesus.
So there were no fractures noted in the autopsy report. but they didn't actually x-ray, from the records I've seen, either his hand or his arm. So
Really?
there was, at least according to the autopsy report, no overt fractures, but the x-rays I saw, none of them were the arm, and the autopsy report said no sternum, spine, I think it said torso. They didn't say that there were no fractures there.
Was there any evidence in the medical records that you reviewed of any indication whatsoever of a fracture in Mr. O'Keefe's hand?
No,
Was there any indication whatsoever in any of the medical records you reviewed that there was a fracture of any bone in the right arm of Mr. O'Keefe?
not that I saw. Again, it wasn't x-rayed.
Was there any indication in the medical records and the autopsy that you say you reviewed of any fracture of any bone anywhere in the body of Mr. O'Keefe,
Yes.
What?
other than the occipital bone
Boner.
or the skull?
There's a couple bones in the skull that were fractured, but other than the skull, no.
Correct. So,
He's got no dog in
are
this
you
fight. He
aware
doesn't care.
that
He's holding on for dear life.
medical examiner for the state of Massachusetts, Dr. Shorty Bello, performed an autopsy on Mr. O'Keefe? Are you aware of that?
Yes,
And you're aware of it because you read the autopsy report, correct?
correct.
Are you implying, and it's a question, that Dr. Shorty Bello missed a fracture or didn't look properly for a fracture on Mr. O'Keefe?
No, I'm simply indicating that, for example, a hairline fracture, I didn't see any evidence that they actually x-rayed the structure, so there'd be no overt evidence of that.
There were wounds on the right arm of Mr. O'Keefe, correct?
Correct.
There were wounds on the right of him, Mr. O'Keefe.
Are saying that the medical examiner should have x-rayed that to determine whether there was a hairline fracture? Is that your testimony?
No, you're asking me about evidence and proof of absence of fracture. So I would look for an x-ray to see if that was the case. I haven't seen any evidence of an x-ray of the arms.
So it's your position that on every autopsy, there should be an x-ray of every bone in the body, and that the clinical judgment of the medical examiner should not be accepted, and there should be an x-ray of every bone before a conclusion can be drawn that there's no fracture to a bone in the body of the deceased. Is that your testimony?
Absolutely not. Like, I'm an engineer. You're asking me about proof. And so proof is somebody looked at it, somebody took an x-ray, somebody palpated and found a comminuted fracture. So we're talking about proof.
Sir, I didn't use proof in my question.
Ask me about the opinion of a medical examiner. I'm not a
Hold
medical.
on. Only one person at
Sir, doctor, but not the medical kind. You are sitting up there while a woman is facing life in prison on murder charges. Your smug ass demeanor is not helping you, but you are up there trying to give an opinion. You already gave an opinion that these injuries to Boston police officer John O'Keefe were caused by a motor vehicle. And now you want to back off and say, I'm just an engineer. I don't know anything about medical. I don't know nothing about x-rays. You're asking me about a medical, the guy thing, I think, bada bing, bada boom, bada bing. I don't know nothing about nothing now. Wow. Yeah, you're there to answer questions, not lead Fight Club. Well done, Magnolia Gypsy. Listen to this, because they're going to get into a brawl now. Listen.
He palpated and found a comminuted proof. And so proof is somebody looked at it, somebody took an x-ray, somebody palpated and found a comminuted fracture. So we're talking about proof.
Sir, I didn't use proof in my question.
Ask me about the opinion of a medical examiner. I'm not a
Hold
medical.
on. Only one person at a time. Mr. Alessi, let him finish, and then you can ask the question.
Thank you, Gilroy, for your 20.
Okay, then finish your question, Dr. Welcher. Wait for the question. And let Dr. Welcher respond. It's a nightmare for medical.
I understand, and I think I've been doing that, but I'll redouble my efforts. Dr. Welcher, I didn't use proof for my question. I'm going to repeat the question. Is there any indication in any medical record, autopsy report of the deceased of any fracture of any bone in the body?
That was not your original question, but to answer your question, no. Except for the skull.
Except for the skull.
Correct.
I too will be bald when this is over because I'm going to pull out all the hair on my head. I'll be as bald as every MSP trooper that took the stand during the first trial, during season 1.
Do you understand whether the
Snacks are here.
absence of any fractures other than the skull of Mr. O'Keefe was of significance to the medical examiner, Dr. Scorti-Bello, in the conclusion she reached in the autopsy report that you read?
System.
Did you read the conclusions of Dr. Scorti-Bello in the autopsy?
I believe so.
Are you aware of whether Dr. Scorti-Bello has analyzed whether the injuries to Mr. O'Keefe are inconsistent or consistent with a motor vehicle impact? Are you aware of any analysis to that effect?
So I'm going to see you on this one.
Wow. He read the autopsy report. He relied on the autopsy report. He likes to talk about medical evidence when it suits him in the Commonwealth's case that's paying him, I don't know, $325 plus 44, close to 400 grand for his testimony here and his expert opinion. He likes to talk about causation of injuries then, but when he's actually asked about it, he just says, well, nobody ever did any x-rays of the arm, so I'm just not going to answer your question. Kristen W. is rage cleaning. Big Boy says, by far the most ignorant human that has been on the stand in either trial. Zero doubt that the jury hates this man. Thank you, Big Boy. We were reading some of Sue O'Connell's observations before. They seem to be riveted like a tennis match. And in fact, one of them had to cover his face with his clipboard to apparently hide his expression. Misinterpretations, it takes less force to break bones of alcoholics, she adds in there. Thank you very much. Entry required no court evidence showing the taillight and John O'Keefe at the same place and time. Thank you. Thank you for that. You can see that all the way from, I think, Sweden or Switzerland. I'm not sure. Kelly says, I have watched many trials, but I've never seen a witness banter with the attorney like this. Is this normal? No. Nothing about this trial is normal in any way, shape, or form. The judge's behavior, it's a little out there, but it can be considered a little more normal than some of these witnesses that I have seen testify. It is outrageous. There's nothing like it. You'll never see. This is must-see TV. You're never going to see anything like this again, Kelly. So you are not alone. Okay, playlist Tightrope by Leon Russell. Thank you. Cat Q, again, I can't with this guy. He's so irritating. It is like, I don't know. Would you rather be having teeth pulled right now with no Novocaine or laughing gas or nitrous or whatever they give you at the dentist? Would you rather be having teeth extracted or sitting here for the rest of this afternoon with me? I won't be offended if you say I'd rather be having teeth extracted. It's 2:45. We have at least an hour and 15 minutes of this left. Tomorrow is a half day. Of course, it's a half day. Friday is allegedly a full day. How that's going to shake out, nobody knows. It's like we're spinning the roulette wheel every day when we come into court. Where are you going to put all your money? I don't know. It might be throwing it into a void. New Hampshire Woman's Song, Hold Your Head Up, Woman by Argent. Thank you. Spiritual Chuck says, this is making me absolutely insane. Ken, please return my head from Massachusetts to Venice Beach, California. If you're in Venice Beach right now, you are like 10 steps ahead of having a better day than all of us, because you can just go outside. You can put on your roller skates and you can, get out there and enjoy the sunshine. Because put your AirPods, you call those things, and go roller skate up and down the boardwalk in Venice, and it'll be way more enjoyable than this. Gen X 1968 Neo Maxi Zoom Dweeby. T.S. Tolkien says Welcher equals expert LARPer cosplaying as expert. Daniel Wolf's Dimples is here from Australia. Says, why am I getting Jessica Hyde vibes off this dude? But at least Jessica Hyde, although she seemed superior, she wasn't, I don't know. It was different. It was a different kind of superiority. It wasn't like the rich dude, smarmy, finance bro, Timu version of a sugar daddy. Like I don't even know how to explain this guy other than ladies in the chat. If you were out on a date with this guy, what would you be thinking? Right answers only. Thank you, Daniel Wolf's Dimples. Can see it all the way from down under. Sit down, demon says, how dare you? Get this fool out of here. Schloppy jalopy. Welcher is smart but biased, but he wasn't expecting Alessi to be able to follow along every step of the way, though. Yeah, he's usually the smartest person in the room, and today he's not. He's not. Although he keeps trying to say that Alessi is wrong, you science people in the chat can let me know if Alessi's wrong or if this guy's wrong, because I'm not smart enough to know. Because I didn't study Newton's second law for 18 years, like these guys did. RW, fellow pharmacist here. Alessi knows this guy has no idea what he's talking about. Can't stop laughing. Thank you, because that answers part of my question. Rhonda Hall, Chaka, I am your father. Now I am pissed. Crafty councilwoman, OMG, I'm going to have to call my therapist to help me process the frustration and trauma I'm suffering from this man's inability to comprehend and answer. I think after this, perhaps, maybe, I know a good lawyer. We might have a class action lawsuit against the state of Massachusetts, the Commonwealth of Massachusetts, for intentional infliction of emotional distress among each and every one of the 2.5 million viewers that are watching this trial every single day on YouTube. And that number might have grown. I haven't seen any statistics lately, but I wouldn't be surprised. Obbs, a law nerd, said Brennan moved for a mistrial before lunch. Where did you see that? Where can I find that? Did anybody? Let me check my inbox. He moved for a mistrial before lunch for reals? For reals? I'm sure there wasn't any sort of ruling on that. I don't want to spread misinformation. So if I'm wrong about reading that comment and it's actually not true, then I don't know what to say except for I'm sorry. Larry Foreman said it on Twitter. Is Larry in the courtroom? Is Larry in the courtroom? All right. I don't like to spread misinfo, because the last time I did that was merely me reading Howie Carr's Howie Carr's tweet. Howie Carr reported that a juror sent a note out and said, Judge, please stop sustaining the objections because we want to know what the witnesses have to say. Howie Carr reported that, not me. People were out there saying I reported it. No, he's not in the courtroom, so I don't know where Larry got his information from. This whole case is a mistrial. It's a miscarriage of justice. Larry might have been joking. I don't know. It's a miscarriage of justice. It is the framing of an innocent woman, because today is May something. All the days of the week this week are palindromes, or last week maybe that was. Today's 5/28/25. Now that is a palindrome as well. And it is 5/28/25, and Karen Reed was still framed. You can get this from Microdots on the website. Highly recommend. Oh, it's the instruction that he asked for. He asked for an instruction before lunch, not a mistrial. Okay, let's not spread misinformation. I like to deal in facts. Thank you for. Doesn't have any dog in the fight. Thank you, Big Hoss.
May I, Your Honor?
Yes.
Thank you.
T.S. Tolkien. Said
Dr.
Alessi for the win.
Welcher, I would like to talk now about your paint exercise.
Finger painting with Judson Blair Welcher, JBW.
You did not
He's taking notes
present,
again.
as you have stated, a force calculation
Objection!
with regard to the arm. You did a paint exercise.
Experiment.
And what I want to do is to reference, and if we need to bring it up, sir, to refresh you, slides 103 to 120 of your PowerPoint presentation in this trial. I'll just call it the blue paint exercise. Is that descriptive enough for you to know
Blue
what
man
I'm
group would
talking
be
about?
No, it's not an exercise, it's a test.
Okay, you want to call it a blue paint test?
Sure.
Okay, let's call it a blue paint test. I just want to try to expedite things and use parlance that we can agree on.
Okey-doke.
So,
Did you see my thumbnail
your
from
blue
today?
paint test involved painting the right rear taillight blue, correct?
Correct.
Positioning the test subject behind the taillight, correct?
Correct.
With the arm held out, correct?
Correct.
And at a right angle, correct?
Correct.
And then the vehicle, the Lexus SUV, is backed into the test subject, correct?
So I ran 3 different tests.
I know, well, let's just do each one at a time, okay?
Okay, so you're starting with the last one.
I'll start with whatever one you want.
Okay.
How about if we start with the one at 1 mile per hour?
None of them are at 1 mile an hour,
2 miles per hour?
2 miles an hour.
Let's do 2 miles per hour. Let's start with that one,
Okay.
okay? Now, did you conduct that test in an attempt to show that the injury patterns on Mr. O'Keefe's right arm are consistent with being struck by the Lexus taillight on that arm?
So generally, I wanted to show that the location, area, and span over which that headlight covers matches the location and area of the lacerations on his arm.
That's what I want to get to. So you discussed data that you say shows that that you say shows the Lexus SUV was traveling above 20 miles per hour during the period that you allege the SUV made contact with Mr. O'Keefe. Is that correct?
No, where'd you get that from?
Hold on. Okay. The answer is no. So did you do a test involving 20 miles per hour?
I did some other backing tests.
Yes.
I was looking at how the rear pedestrian system and what warnings you got from the rear pre-collision system, the PCS system.
Let me ask you this.
Mhm.
Would you agree that you did a blue paint test with the vehicle going at 2 miles per hour? Did you
Of course.
do that? Okay. You didn't do a blue paint test with the vehicle going at 20 miles per hour, correct?
That is correct. I was not going to hit myself with a Lexus at 20 miles an hour.
You could have done other tests where the vehicle was going at 20 miles per hour if you used a crash test dummy, correct? You
If
could have
you-
done that.
If you use the right crash test dummy, and then to set up the test, because generally you only get 1 or 2 shots at it, because you damage the car, you have to know everything about the parameters. And so again, pedestrian impacts are so very sensitive to initial angles. If I were to do a test and it was off a tiny, tiny bit, and we got some different results, I would be in here having to defend it. Well, your own testing didn't show it. Point is we don't have enough information to be able to conduct that testing.
So, your assumption, as I understand it, is that the Lexus was going 24 miles per hour in reverse and made contact with Mr. O'Keefe. That's your analysis, sir?
No, there is not one.
No. He said, you couldn't hear him because he walked away from the mic, but he said, your analysis is that she was going 24 miles an hour in reverse. And he said, no. Okay, well, that was the Commonwealth theory. I guess that's no longer the Commonwealth theory.
4 miles per hour. I understand it. Is
Mhm.
so. Your assumption, as I understand it, is that the Lexus was going 24 miles per hour in reverse.
Your assumption.
With Mr. O'Keefe. That's your analysis, sir?
No, there is not one single slide I have that says this is the speed he was hit at 24 miles an hour.
That's out of the theory?
Do you know, do you have a hypothesis at what speed you believe there was impact? Do you have a point of impact speed?
I do not know the exact speed. We don't know the initial point of contact. We don't know where exactly he was on the road. We don't have enough information to determine that.
You know nothing about nothing.
let's talk about the other information you don't have.
Okay.
You don't have the information as to from your alleged point of contact to where Mr. O'Keefe landed. You don't have that information, do you, sir?
I'm sorry, where is my alleged point of contact?
You allege that there was a point of contact between the Lexus, the back of the Lexus, and
Correct.
Mr. O'Keefe, correct?
Right, but I don't know where that is on the road.
You don't know that. I want to go through the information that you don't have.
Okay, doke.
So you don't have that. You don't have the point of impact. You don't have where in the road there was impact under your allegation.
Those are the same thing.
Right. You don't have where under your view, the body of Mr. O'Keefe landed precisely. You don't have that information, do you?
What do you mean by precisely? We know it's 7 feet off the road. We know it's near the flagpole. We don't know where it
Who's
started.
testified to
The
that?
problem isn't where it landed. The problem is where it started.
Right. And you don't have that information.
I don't have where it started.
Trooper Paul said he flew 30 feet in the air after his pirouette and landed on the
The paint
ground.
tests
I'm trying to think Trooper
you
Paul was
use,
better
aren't
witness.
those used, if they're used at all, as an element of physical impact reconstruction, an element, not as the focal point of the test itself?
So that was the focal point of that test. The focal point of the purpose of that test was to show the contact width and location of how someone of Mr. O'Keefe's height, which happens to be me, contacts and where it would contact where the broken taillight was. So no, that was the focal point of the testing. That's why I did the testing. That's why we're calling it paint transfer testing.
Right, but my question, sir, I understand you use paint tests as the focal point, but aren't paint tests in accurate accident reconstruction not used as focal points? They're used as supplements to other tests to get more accurate information. Do you agree or disagree with that?
You didn't give me enough information. I can't agree nor disagree. It depends on what you're trying to do.
Let's go to, on direct examination, you testified that after the 1162-2 trigger event, Ms. Reed's vehicle traveled a distance of 87 feet. Do you recall that?
You are mixing up two things. Remember, the trigger is in the middle of the event.
Give me the chart, please. Your Honor, I'll give you the, as soon as Mr. Wool gives it, the
Unfair view of justice. Well done with the username.
Slide
Could you imagine
23, I
being married to
believe
this
it is.
guy? No,
I'm sorry,
No.
what slide?
no.
Well, I want Mr. Wool to go through it to check. Let me ask it this way, see if we can get to it quicker. Do you remember talking on direct about a calculation of 87 feet where you added, there was like a 30-something number and a 50 number and you came to 87? Do you remember that in
Mhm.
your slide presentation?
We did the math yesterday 100
Slide
times. 'cause I
37,
didn't
yes.
understand it either.
Right. So if we could bring up that slide, please, Your Honor, with your permission.
Okay.
That's 36, but okay.
She just is. B.S. and Edmund, she just is.
No,
Why is she
I'm on
allowing this testimony?
36.
She just is.
Mr. Wool, do you have 33?
It's an
If you could go to
expert opinion.
33, sir.
Oh, sorry.
Yeah, because that's where your 87 number is, not on the other.
It's on a bunch of slides.
Yep.
Go ahead.
All righty. So if you could zoom in, Mr. Wolk, so Dr. Welcher can see the numbers in the column.
You're going the wrong way.
Yep. They're to the farther to the right.
Oh, I'm not the only one that has problems.
Oh, no, you're not the only one who has problems. You have all the problems today, sir.
Okay.
Your little
Sir,
jokes
do
aren't
you
going to help.
remember testifying about this to the farther to the right?
Farther to the right.
Yep.
Keep going. Keep going. Yeah, a
Is
little
that
more.
53 number down there? That column?
Right.
So
Can
you
we,
take-
can we scroll up a tad so you can see the headers?, There you go.
Okay.
No, okay, go ahead.
So am I in the right column relative to start? Is that the column?
So there's two columns, like Z is relative to where it started.
Yes.
And
Ashton
then
Kutcher's gonna
positive is
jump out.
forward. And then as you back up, once you go past 0, it becomes negative.
Right. So what I want to do is have you direct us to the column where you calculated 87 feet.
Please. We all want to know.
It's in two spots. It's at the end of column Y.
Right? We go all the way down. Is that in the yellow there? Is that 87, sir?
It is.
Okay, is that the 87 number you were
Hold
referring
on a
to?
second. You asked me to identify. So then it's, see where the one next to it says minus 53.429?
Yes.
If you go up, so it's not a little bit down, a little bit, and add, see where it's changing directions at 34.157?
Yes.
You add those two together, that gives you the same result. So it went 34 feet forward and then 50-something feet backwards.
Right. And what is the 87 feet traveled, is that what you're indicating is the distance traveled during the trigger? Is that what the 87 represents to you?
That is so 87 represents the total rearward distance traveled during the trigger.
Okay. So you believe 87 represents the total rearward distance.
Right.
Did I hear you correctly?
You backed up 87 feet?
Now, can you
Just
please-
hold on, to be clear. So it starts, it pulls forward, then it backs up, passes where it initially started, and goes 53 feet further back.
Really?
That's what I want to get to.
What?
How many feet did you say on direct, and did you just say now that it went 87 feet in reverse?
Totally.
Correct.
After hitting
From
him?
its furthest point forward.
Well, that's what I want to get to because I want to have this point clear. How many feet do you believe the Lexus went in reverse based upon your PowerPoint presentation? Not when it went forward and then came backwards. How many feet do you believe that vehicle went in reverse?
Your question doesn't make any sense because when it went
sorry.
forward, then it went in reverse.
And then kept going in reverse. That's what you just said, dude. I'm more of Alessi is like on a date with this guy. I'm home and he's waiting for me to return from the ladies' room.
How many feet do you believe the Lexus went during the trigger?
So it went a total of 80, it went 34 feet forward, then it came back 80, another 53 feet past where it went.
Exactly. So
34 plus.
you've testified that the
87 feet.
1162-2 trigger event represents a backward.
He's saying it went 34 feet forward and then 53 feet past where it originally was. So he is saying it went 34 feet forward and then in reverse 87 feet altogether. Do you understand? That is exactly what I thought he said yesterday. Everybody said that I was wrong, but he's saying it went 53 feet past its original position before it went 34 feet in advance forward. So now they're saying instead of 60 feet in reverse, now it is 87 feet in reverse. But he has no idea what the speed was. But in the first trial, it was 24.2 miles an hour, 60 feet in reverse. He says it went up 34 feet, then it went back that same 34 feet, and then it kept going after it hit John O'Keefe another 53 feet. Are we clear? Maybe. Maybe we're clear, maybe not. Ashton Kutcher is in the
You've
corner.
testified that the 1162-2 trigger event represents a backwards maneuver, correct?
So again, I was clear, it initially pulls forward and then backs up.
I would like you to define, so it's clear to the jury, do you consider the event of 1162-2 just backward movement, or do you consider the trigger to be forward movement and adding to it backward movement? Which one?
So can we pull the slide up?
Sure.
Jeez. Do you know how much more testimony there is to get through off this guy?
Could you zoom in? There you go. No, go back to the left. So that T in the third column for data ID represents the trigger. If you scroll over a little bit to the right, where the highlighted yellow blocks are, you can see 1 is a forward drive gear, 0 is neutral, 2 is reverse. So that's where it's switched from forward to reverse. I mentioned the brake. So you have it on the brakes coming in, slowing, stopping, going into reverse, and then backing up.
So you conclude that the vehicle for this trigger went 34 feet forward, is that correct?
Correct.
How do you know the vehicle didn't go 150 feet forward? How do you know it just went 30 feet, 4 feet forward? How do you know that?
So the only data we have is this 10-second window.
This guy's a beaut.
And so we
Well done,
have the
Margaret.
velocity when it's going forward. We know how much time it took to do that. So that tells us how far it would travel. Velocity times time is distance.
So are you saying that it is a certainty that it went forward 34 feet and there's no other number of feet it could have gone forward? You're absolutely certain of the 34 number?
No. Again, if you look,
No?
see where it says vehicle speed?
I see it.
So at the start of this
That's a good point.
event, which is the trigger -5. So the trigger is actually where it's triggered, and it takes 5 seconds before, 5 seconds after. But when the trigger happens, it's actually stopped. But the 5 seconds before, it's going 13.6 miles an hour forward. So at the start of the data, it's still going 13.6 miles an hour forward, but it's slowing down. You can see you have the brake where it says brake SW, which is short for switch. The brake switch is a 1, which means it's on. So when this event data started, it's going 13 miles an hour.
I'll ask the question a different way.
Thought he had no idea how fast it was going.
Are you certain that the distance traveled forward during this trigger event was 34 feet? Are you certain?
I'm pretty certain during this trigger
Pretty
event.
certain.
Pretty certain or certain?
Well, I've checked the math. I've had people check my math. So I try to be as accurate as possible. I would say I'm certain,
Okay.
but I'm an engineer.
Okay.
So there's no absolutes. There's no 100% in my job.
So you're certain of the 34 feet, and is it correct that you're certain of 53 feet going backwards? Are you certain of that, sir?
So backwards from its initial starting position.
Yes.
Correct.
Okay. And therefore you are certain of a total of 87 feet traveled that you have at the bottom in that yellow orange. You're certain of that as well?
87 feet of backing, correct.
Okay. Now, you also testified on direct, as I understand it, in slide 23, that different numbers represent different gear states of the vehicle, correct?
Correct.
Where's park?
And a 0 represents neutral,
I think it's either neutral or park, but I'm pretty sure it's neutral.
Think? Dude,
a 1
Dude.
represents drive,
Correct.
it's important.
a 2 represents reverse,
Correct.
or a 2 can represent slowing down. Is that correct?
Not for a gear shift number.
So you didn't say on direct that 2 could represent reverse or slowing down.
God, I hope not. It doesn't. So those numbers simply represent, is the transmission in drive? Is it in neutral? Is it in reverse? It doesn't tell you anything about whether it's slowing down or not. But the brake switch and the brake pressure and the longitudinal accelerometer data gives you some information on that.
Okay, so if Your Honor, we could go
I
to
think it's
slide
park.
30,
I'm not
please.
sure. It could be 0, it could be 3. I don't know.
Mr.
Not
Wolf?
really. I'm an engineer. You've told us. Lally must be losing his
And
head.
I want to do it generally. There's
sandwich
not a
says.
need to read any specific number. I just want it clarified.
Mr. Alessi, so is this 30 or 31?
I'm sorry, Your Honor, you are correct. It's 31 in the most up-to-date presentation. Thank you.
Expert witness
Do
for
you see
hire.
all the numbers in blue font on that slide, sir?
I do?
Those are all numbers that you have placed on that slide. Did I have that correct in your direct presentation?
You do?
Okay. So this Excel spreadsheet, there's also numbers in black, correct?
Correct?
So all the ones that are in blue, those are numbers that you have placed into the spreadsheet. Correct?
Correct. The one exception is column N, where it says ship position.
Yes.
I changed green to forward and red to reverse.
So the data in the columns in blue are not from the original data that was downloaded from the vehicle, correct?
Like, for example, if you look at
He
column
doesn't
H,
know.
column H, I simply did a unit conversion. So it's the same number, it's just in different units. But the black numbers represent exactly as it comes out of the vehicle, but it's the same number.
All right, that's what I wanted to get to. So for clarity for this slide, when you download this data from the vehicle, what is in black, those numbers just come right out, correct?
Correct.
As they're stated. But the blue numbers, they don't come out like the numbers in blue. You have to do something, some calculation, some application to get to the blue, correct?
Correct.
Okay, thank you.
You're welcome.
Poor Madam Court Reporter.
Now, and
Not to be
we're going
confused
to keep
with
that up,
Madam
Mr.
Court Reporter
Wolf,
Nancy
please.
from Trial 1.
Thank you.
She looks like a woman that
And
I watched
when
on
we need to
TikTok.
get to the specific numbers, we'll be fair and make sure you can see them. Now, in these columns, do I understand it correctly that you attempted to account for wheel slippage in the revolutions per minute speed values produced by the car?
Not here. You're looking, this is 1162-1. The wheel slippage occurred in 1162-2.
Okay, and so if we go to a slide with 1162.2, we will then go to the slide you believe represents wheel slippage. Is that correct?
There are data points in that represent slippage.
That's my question. In which slide, sir, would you like to pick?
35.
Thank you. So we will go to slide 35. So
I've highlighted the slippage.
exactly. So you agree
Well, you've
that
highlighted
there
the
is
slippage.
data that shows that there
First
is
right thing you've
wheel
said today.
slippage with the Lexus SUV during trigger event. Let's enlarge it for this one here. The trigger event, the number 1162.2, correct?
Correct.
And as I understand it, you testified that this trigger event was caused by a depression of the accelerator pedal at more than the 30%. Is that correct?
It's a transition into reverse and then a quick acceleration exceeding 30%
So let's
in reverse.
Okay, got it. So the accelerator pedal being depressed to this degree, more than 30%, can be the result of wheel slippage, correct?
It doesn't necessarily work that way. I mean, you can have wheel slippage at any acceleration, technically, depending on the roadway. It's just what is in the data that shows that it's slipping. It isn't necessarily because of the accelerator. Normally, that's what causes slippage. But it's the data. When you look at the data, you're like, well, that doesn't make sense. It's increasing in speed, but yet the longitudinal acceleration is dropping.
My question, again, doctor, is you can have an accelerator pedal depress greater than 30% and it be caused by wheel slippage. That can occur, correct?
The wheel slippage does not cause the accelerator pedal.
I'm not saying a cause and effect. I'm just saying a correlation. Do you understand what I mean by a correlation?
Let me, if I may, try and straighten this out. So applying heavy acceleration can cause the wheels to spin. Is that what you're asking me?
Yes.
Yes.
Okay, that's all I wanted to get at. Alrighty. So in your review of the materials that are related to January 29, 2022, did you become aware of whether there were, and you said you extensively reviewed documents, Did you become aware whether there were people at 34 Fairview?
Yes.
And approximately how many people, without regard to names, just number, how many people did you become aware were at 34 Fairview on January 29th, 2022, the early morning hours? How many people approximately did you become aware were present?
It depends on which time, but there could be as many as 16.
As many as 16. And let's talk about the time period from midnight to 1 a.m. Do you have an understanding of how many people could have been present at 34 Fairview at that time period?
So I'm going to see you at sidebar on this. Mr. Mayor.
How many people were in 34 Fairview on that night? I just put a poll in the chat. I'm going to try and remember to look at the results of the poll later. So if you're not watching, come watch, just participate in the poll. We've got over 21,000 people watching. I'd love to try and get some big numbers on this poll. The question is this: Welcher's testimony so far, A, helps the Commonwealth, B, helps the defense, C, helps nobody. You can vote one time. Please partake. We all want to partake in something. Some of you have taken edibles today. Some of you are drinking. Many of you are doing what you can to cope. Some are rage cleaning. Some are rage crocheting. This is a no judgment zone. This is a judgment-free zone. Except I would like you to judge his testimony thus far. Rachel would like to buy Bob Alessi a drink after this is all over, after his patience with this doctor. Tamara says, after the Commonwealth case, I'm convinced that Brennan has only two goals, and those are: number one, Karen Reed gets convicted of a DUI. Number two, no one can be convicted of killing John O'Keefe ever due to the evidence. Well, here's the thing. There is no standalone DUI charge, and so that's an impossibility. So I have to eliminate that possibility from your equation. There is no standalone DUI charge because she was not pulled over at the scene. She was not breathalyzed at the scene. They're using some weird junk science extrapolation combined with the serum results that are not typically used in DUI cases to try and show that she was drunk. There's also some admissions by her in some of the interviews that were played about how many drinks she had, which may put her over the 0.08 required for a DUI, but there is no standalone DUI charge. So the jury does not have that option. It is either one, murder, two, manslaughter, OUI, or three, leaving the scene of a vehicle, leaving the scene of a motor accident, leaving the scene of a motor vehicle accident causing bodily injury or death. That's it. Three choices. Ashton Kutcher is somewhere in the corner. I'm waiting for it. And I'm even going to go deeper into the archives and say Alan Funt is out there somewhere, rolling over in his grave.
May I, Your Honor?
Yes.
But he's
Thank you.
missing the opportunity to pop out of the corner on this one.
Dr. Welcher, am I correct in my understanding that you believe under your theory, the Lexus for event 1162-2 backed up 53 feet? Am I correct?
No, it backed up a total of 87 feet.
Okay, let's take your 87. It backed up a total of 87.
Even better.
Okay?
Correct.
And
I was
your
right. I'm so happy I was right about that. I thought I was going crazy. I was being
theory
gaslit so
is
hard.
that it did so and reached 24 miles per hour, correct?
Correct.
And you stated you have an understanding of a certain number of people, and I don't want to talk about the inside of the house, but just that were at 34 Fairview between roughly 12 and 1 a.m. Do you have an understanding of that, sir? Approximately.
I believe I do.
And what is that number?
Do you want them, people that were there for that entire window of time or
Yeah.
just?
Yes, 12
Yeah,
to 1.
throw Colin in.
Oh.
Colin.
So Mr. Alessi, just move to the.
Throw
last
Colin
question.
into
Right,
the mix.
sure.
Go ahead.
So, sir, did you assume that there were cars parked out front
Jeep.
of 34 Fairview at that 12 to 1 o'clock window? Did you assume any cars parked out front?
The entire time?
No, I'm just talking 12 to, yeah, any time between 12 and 1. Did you make any assumptions whether there were cars parked out front on the roadway at 34 Fairview? Did you make any assumptions with regard to that?
At a point in time, there was a vehicle behind it.
I'm sorry,
There was a vehicle behind it.
just one?
That is my understanding. In terms of on the street, is
On
your
the street,
question?
exactly.
Yes.
And what, do you remember the type of vehicle?
Yes.
What kind of vehicle was it?
An F-150 pickup.
Did you have any understanding as to whether there was
That's
a
Ricky
Jeep
D'Antoni's
vehicle
car.
on the road at that 12 to 1 time period?
I had seen testimony somewhere to that effect, but the majority of the testimony was there were no other vehicles.
But you did see testimony that there was also a Jeep type vehicle on the front, out the front of 34 Fairview between 12 and 1. Is that what you're recalling?
So I'm going to let that answer stand, what he's just testified to. Just go ahead and.
Okay, so Dr. Welcher, what I want to do is to have you, using your data, you say 87 feet for the backup, correct?
Correct.
1162, up to 24 miles per hour. Isn't there a likelihood, if there is at least one vehicle out in front of 34 Fairview, that there would be a collision of the Lexus SUV with a vehicle out front?
No, the vehicle had left prior to the end or prior to event 1162-2.
What information do you have with regard to how many vehicles are in front of 34 Fairview at between 12 and 1?
So I have Ms. Reed's interview statements. I have statements of a number of witnesses. I don't know if I'm allowed to say the names.
Say their names.
I was just going to say, let's not just number of vehicles.
Okay, so I have a number of witness statements at multiple statements from the same witnesses at different times, indicating the path and following the Lexus to the house and then leaving before the event.
Assume that there were vehicles, at least one vehicle parked out front of 34 Fairview. Is there a likelihood that given 24 miles per hour over 87 feet, is there a likelihood that there would be a collision given the weather conditions as you knew them to be at that time?
Well, the weather, I don't think necessarily plays into whether there would be a collision or not.
Really?
But we know it backed up 87 feet. So again, it goes forward
Weather
like
doesn't
35-ish and then back like 60 something. And so if something is within 65 feet of the rear of it, or whatever the numbers are, I would need my slides,
It was 50.
50,
okay. Yeah, go ahead.
57. If something is within that window, then it would hit it.
All right, good. So now let's look at another scenario. If it's going as you describe it, is there a likelihood that the Lexus would also go upon the lawn in front of 34 Fairview?
It depends on where it starts.
You have an opinion, don't you, as to where it starts?
No, I do not. That's actually why I have that diagram showing it off to the side.
That's
I'm
right.
simply showing how far it moved forward, how far it moved back.
Exactly.
We don't know where on the roadway it started.
Exactly. You don't know where on the roadway it started. And therefore, all you have is the distance covered, correct?
Correct.
So, but you're saying the distance is 87 feet, correct?
87 feet backwards, yes.
So backwards, 24 miles an hour. Have you ever driven a vehicle backwards 24 miles an hour, sir?
Yes, I think I've driven this Lexus backwards 24 miles an
Right.
hour.
So if anybody who's driven a vehicle back, have you ever driven any vehicle back 24 miles an hour at 1 o'clock, 12 o'clock in the morning?
I got to take that question from the top about have you ever driven a car from 24 miles an hour?
No, where on the roadway it started. And therefore, all you have is the distance covered, correct?
Correct.
So, but you're saying the distance is 87 feet, correct?
87 feet backwards, yes.
So backwards, 24 miles an hour. Have you ever driven a vehicle backwards 24 miles an hour, sir?
Yes, I think I've driven this Lexus backwards 24 miles an hour.
Did it?
So
24
if
miles an
anybody
hour?
who's driven a vehicle back, have you ever driven any vehicle back 24 miles an hour at 1 o'clock, 12 o'clock in the morning?
Probably not since I got out of high school.
Have you ever done it in
That's supposed to be funny?
when there's a storm that is beginning?
You were a
No.
reckless driver in
Have you
high
ever
school?
done it when there is less than clear visibility?
No and no.
And have you ever done it when there's low lighting?
Oh, maybe when I've been up skiing in the
Oh,
snow,
I ski too.
I've done it. But
ski.
again, that's been
Could have been a
decades.
doctor.
Right. So
Garmin watch.
87 feet, 24 miles an hour. Are you saying that in every instance that vehicle will stay on the road, and for 34 Fairview, it wouldn't go up on the lawn?
When you mean every instance, mean like every possible location on the road it starts from?
Correct.
No, there's some spots. If you start here, it's going to go up on the road, on the yard. If you start too far on the other side, you're going to go over into the neighbor's yard. So it depends on where you start.
Right. And so in given the conditions that we've just described, right?
Conditions
the weather,
have nothing to do
I
with where
need
you
to
start.
finish my
Hold
question,
on.
sir.
Only one at a time.
Yes, ma'am.
Let him finish his question.
Bada beep, bada beep, bada
Given the
boop,
conditions that you've described,
folks. Thanks, Pamela.
it is reasonable to conclude that that vehicle, under your parameters, would have gone up on the lawn. Is that a reasonable conclusion?
No.
So you don't think there's any possibility that could occur, a vehicle going 24 miles an hour at this location, 87 feet backwards, in the dark, with wet pavement at a minimum,
Enough
and
snow
low
to trap a
lighting?
cat.
You don't believe it's possible for the vehicle to, under your scenario, to have gone up on the lawn? That's not
So
possible.
your first question was reasonable, and I said no. Now you're asking possible. It, of course, is possible. Whether it's reasonable or not, I'd have to know the starting position.
Right.
If it's very close to the side, then it could be reasonable. If it's further towards the middle of the road because snow is building up on the side of the road, then it's probably not as reasonable. I would need more information to be able to determine whether it's reasonable or not. It's certainly possible. It's possible it could have shot off into space as an engineer,
Really?
but not probable.
Really?
You think it's possible that it could have been shot off into space, sir?
As an engineer, it's a possibility.
Wow.
It's a possibility that
Absolutely.
this Lexus could have been shot off into space.
Yeah. Highly, highly unlikely.
Wow.
But again, you're asking an engineer
Wow.
about possibilities and probabilities.
Let's get back to reality.
Anything is possible then,
So,
right?
in terms
Possible.
of
There was no
the
car accident.
Lexus itself, because you, under your method of analysis, don't have the starting point, you can't rule out that under your scenario, the vehicle would have gone up on the lawn. You can't rule that out, can you, sir?
I cannot. No, it could have.
Okay. Now let's go to the next topic. If we could, Your Honor, have Exhibit 168 published in evidence, which is now under the 167.
Did you ever think you'd hear an expert witness say that it's possible that Karen's Lexus could have been shot into space? Because he's an engineer, and he just said that. Totally possible. He was asked like 3 times because, you know.
Now, as I
Did
understand
everything
your
3 times in this
testimony,
trial.
Dr. Welcher, you believe that it's possible that the Lexus taillight could have caused these
No,
wounds
don't
to
show it.
Mr.
No.
O'Keefe's right arm. Is that correct?
Correct.
And
Gotta
more
take it down. Sorry.
specifically, it's your belief that the lacerations
YouTube hates it.
would have been caused by the vehicle scratching Mr.
You can hear, right?
O'Keefe's arm as it drives past him. Is that correct?
I don't know. I'd characterize it that way. What happens is, this 6,000-pound vehicle is coming, and he's standing on a, icy, snowy roadway area, and it's going to contact him and move his whole body and induce rotation.
Right. So it's going to contact him and, under your theory, induce rotation. So wouldn't such a movement of the car relative to his right arm result in horizontal injuries to Mr. O'Keefe's arm, as can be seen on his bicep above the the elbow.
So many of you
So
pointed that out
could we pull
yesterday.
up one of my slides to address this issue?
So many of you pointed it out yesterday that if his arm was at a 90-degree angle, the wounds would have been going in a different direction. And Alessi heard you and your prayers, and he's asking the question again. Listen.
Resultment of the quotation. So wouldn't such a movement of the car relative to his right arm result in horizontal injuries to Mr. O'Keefe's arm, as can be seen on his bicep above the elbow?
So could we pull up one of my slides to address this issue?
No.
Sir,
I'd like to answer your question with a slide that I have that addresses this exact point.
I'll just slide
I'd like
on
to
out of
stay
here.
with this slide, Dr. Welcher, and see if you can answer my questions off of this slide. So I'll repeat it.
Sure.
Do you agree that the injuries up at the upper part where you're familiar with the bicep brachialis?
I am.
And aren't those two up at the top, right over the bicep brachialis?
They're actually about midway between the biceps and the triceps.
Right. So you know which two I'm talking about, the two up there. Can you just use your laser pointer just so we're talking about the same two? Do you have one?
I'll give it a try, but the upper ones,
I know it's not your fault, but
on the
sometimes it
image,
doesn't
the
show.
upper left. I mean,
Yes.
technically the ones right to the right of that are also on the biceps and triceps.
Right, but
The
I'm talking,
biceps goes all the way to the elbow, so do the triceps.
right, so I'm talking about the two that are the farthest up.
Correct.
All right, would you agree that those are in a horizontal orientation?
Generally, yes, which is what you'd expect with your arm like this and the tail light coming across like this, which is what I showed in my slides.
My questions are
My slides, my
trying to keep this
slides,
moving.
my
I
slides.
just asked if those are in a horizontal orientation.
Yeah,
Yes
more
or
or
no?
less. They're angled down slightly, but more or less horizontal.
Okay. Isn't it true that if Mr. O'Keefe's arm were to be flexed like it was with the test subject in your blue paint test, the lacerations on Mr. O'Keefe's forearm would be oriented in a vertical direction?
Absolutely not. If you pull up my slide 117, it'll show exactly that it is like perfectly horizontal. When you're standing like this, and this is the tail light,
Oh, he's
the
demonstrating.
laceration, when it comes across here and pushes my body, it's going to make a horizontal laceration because the 6,000-pound vehicle is going to push me out of the way. As this pushes me out of the way, it's going to drag and create a horizontal laceration across my arm. This is exactly what you'd expect.
So let's talk about the forearm, sir. We may have miscommunicated. I'm talking about the lacerations on Mr. O'Keefe's forearm now.
So we're switching from the arm to the forearm.
Correct.
Gotcha.
Wouldn't those be oriented in a vertical direction?
No. Again, you have the vehicle. If this is me and this is the car,
He's
it's
standing up
pushing-
again.
pushing across like this, and with your arm bent like this, it's going to cause laceration as it pushes my arm away. It pushes like that.
Okay, I
And
got
it's, my slide shows this quite clearly.
So you disagree, you do not agree that the injuries to Mr. O'Keefe's forearm under your theory would be oriented in a vertical. You disagree with that. It's just want to get that on the record.
I disagree with that.
Okay. Now, also, do you understand that under your theory of injury here, that there would be injuries caused in two different directions by the same movement of the car? Agree or disagree?
I'm going to say I disagree. You need to give me a little more. You're going to have, again, this is a glancing or a clipping type impact. And so it's going to be it's going to sweep across the arm, which is what causes the horizontal lacerations.
We're talking about a flat surface, right, sir?
Hi, Yvette
approximately,
and
yes.
Michael in Texas. They say Judd and Jen McCabe would make an
And-
amazing couple.
Therefore,
No question would ever
you
be
would
answered.
have to maintain contact with the arm as the car moves. Am I correct about that?
Maintain contact with the arm? I'm unclear what you mean.
What I'm trying to do, sir, is to get under your theory,
Mhm.
right? Given the contact that you've described, what would you expect to be the orientation of the wounds to the upper part of the arm and to the lower part of the arm?
Just like it's shown in this photograph.
Okay.
Call confirmation bias. On top, you have my permission to go to the liquor store. Chaka is here. I put Chaka up there. I'll watch Chaka while you go to the liquor store. Okay? You got it.
Isn't it the case with your theory that the tail light would have to break? And after the break, the arm would have to maintain contact with the arm as the car moves.
So that is what happens in pedestrian contacts. There is a contact duration. For example, you asked me earlier in that calculation you had me ran.
So he
You
would have been
said 0.01
dragged by the
seconds.
car?
That was the contact duration. So when you have things like this, and that's why you have to allow, if you do testing, the body to move, because the car is going to hit the body. It's going to cause it to move. The body's going to rotate away, and the car is going to continue on in that clipping type impact.
And it would have pulled his
So
arm off.
The arm is definitely in contact with the rear of the car for some time.
That's what I wanted to get to, is simply that under your theory, the taillight would break, and also the arm would need to maintain contact with the taillight area as the car moves. Is that your supposition?
So at a point in time, it'll stop contact, but the 6,000-pound vehicle is going to want to continue moving on. It's going to push. It's going to initially contact the arm and then push the arm away as it rotates the body. So yes, it's going to maintain contact until the clipping is over and the vehicle continues on.
So my next question is simply, how long do you believe the arm needs to maintain contact with the taillight after, under your theory, it breaks, to produce those types of wounds that you say came from a taillight?
We don't have enough information to determine that.
Right. You don't have.
Please come vote in the poll. We only have about 5,300 votes, and there's well over 20,000 people watching. There's over 21,500 people watching. Just come click on the poll for me about whose testimony, about who's Welcher's testimony, if it's helping the Commonwealth, the defense, or nobody. Let's get some more votes in. Get your votes in now.
Have enough information to make that determination, do you, sir?
Correct.
And
But we know because of the laws of physics that it has to be some amount of time. It doesn't occur instantaneously.
so now we do apply the laws of physics to the right arm that weren't applied before because you applied a paint experiment. Is that correct? You're now applying the laws of physics to the injury to the right arm. But you
No.
didn't do that in your report.
Nope, always applied the laws of physics. The paint experiment, as you're referring to it, was to look at basically the orientation of the scratches that matched this. So that was an engineering experiment to correlate height, position of the taillight relative to height, orientation of the lacerations on Mr. O'Keefe's arm.
You just said, sir, if I heard you correctly, you, to answer my previous question, applied the laws of physics. That's what you just said, correct?
So the laws of physics cover more than Newton's second law. There's a whole law of physics. The whole field of physics is a broad subject. So a simple measurement of height is a physical measurement.
Sir, I have your entire report in my hand, right here. Where in the report do you apply the law of physics to the right arm of Mr. O'Keefe? Where?
So in the paint experiment we did, the laws of physics about gravity, orientation, things like that, I didn't apply Newton's second law as we already went through. But again, those simple positions, arm angles, the possible physical arm angles,
Rocket Man.
those are all generally
Motion
governed by the
granted.
laws of physics. The laws of physics are very broad.
Sir, I'll ask it this way. Where in your 14-page report do you even mention the laws of physics related to the right arm of Mr. O'Keefe?
So in terms of
What is he getting off the floor?
applying the laws of physics.
I'm not asking applying, just where in the report is it mentioned law
Show
of
us in the
physics
report.
relative to
Show
the right
us.
arm? Can you point me
I
to
don't know that I
where?
would write a report that said, these are the laws of physics. I would say, these are the numbers. But for example, the timing in GPS, how a clock times, the concept of a second. What does that mean? Those are all concepts of physics. So the timing, the GPS, the mileage, how we calculate the mileage, those are all based on the laws of physics.
I'm talking about injuries to the right arm.
That's not what you asked. You asked me about my whole report.
Sir, if you could, please, I just need to finish my question. Where in your report do you use any laws of physics in connection with injuries to the right arm of Mr. O'Keefe? Can you point me to a word or a page in your report?
Yes.
Where?
2A, 2A Roman numeral 1, 2A Roman numeral 2, 2A Roman numeral 3, 2A Roman numeral number 4, 2A Roman numeral number 5.
Sir, I
This is what you do
followed
with,
all of it.
this is what you call a
But
robot.
what I'm asking about is where in all of what you just mentioned is the word right arm? I'll take what you just said. Where in 2A and all of those is the word right arm? Where is it?
Oh, sorry, it's in number 3.
Oh, all
So
those
let's
numbers
go
you just
to
rattled off
3.
in an angry manner were not relevant. Okay, cool. Cool.
You state the location and orientation of the laceration on John O'Keefe's right forearm and right arm are consistent with the geometry and orientation of the right tail light of the Reed 2021 Lexus LX 570. Where,
Can you read the next sentence?
I'm sorry, is it see PowerPoint slides 102, 120, correct?
Correct.
All right. I want to just start with the report. Answer it, so be it.
I just answered it.
Oh,
Is
stop.
the
Sometimes it does that, Core TV. I guess we were a little bit ahead.
that in your report?
Nope, always applied the laws of physics. The paint experiment.
And applied the laws of physics. That's what you. Sir, I have your entire to the right arm of Mr. O'Keefe.
Those are all generally governed by the law. So
Oh, he
the
got something off
concept of
the
a
floor. I guess we kind of were on
second
real time. It must be
contact,
Core TV that
is
jumped.
it a direct in the center? You got
Assistant juror, more likely than not, horizontal clipping into my.
generally cause horizontal lacerations, but when you have a fractured tail is clip, you can't.
That given a horizontal movement.
I don't want to miss anything, so I got to get back to where we
So
were.
now let's.
Test.
This is correct.
So force was applied to my arm in the paint test. I didn't do an F equals MA force analysis.
Thank you.
You're welcome.
So now let's
Maybe we are there. I don't know.
go to
Kimberly, get
The-
wine. I'm not judging you.
horizontal movement we were talking about with regard to the car. And you can agree or disagree.
Sorry. The picture's done.
I'm sorry, we'll take that down. Do you agree or disagree that given a horizontal movement of the car, vertical lacerations would be an inconsistent injury pattern?
So horizontal motion generally will cause a horizontal laceration. You can get what are called stellate, which are blunt force, and it causes a splitting of the skin as well. But generally, when the vehicle is clipping or running horizontal across it, it will generally cause horizontal lacerations. But when you have a fractured taillight, you can get pieces going off in other directions. So it's not necessarily going to be perfectly horizontal.
So my question is, not with clipping, you keep inserting clipping into my question. My question is this. If you're given a horizontal movement of the car, do you agree that it's more likely than not that vertical lacerations would be an inconsistent injury pattern?
I'm trying to help you, but you
No,
got
you're
to
not.
give me more.
You're
So
not.
like, is
Hit
it
the
a
like
clipping
button, everyone.
contact or is it not a clipping contact? Is it a direct in the center of the car impact?
Okay, are there only two variables you need to
No,
answer the question?
But this is a good start.
All right, so let me do it this way. You can't answer the question on a general basis of whether there's horizontal movement of a car, whether vertical lacerations would be an inconsistent injury pattern. You can't answer that question without more information. Is that your answer?
So generally, again, horizontal motion should cause horizontal lacerations. But again, it depends on what's being hit.
Okay.
So for example, if I have something that bends as a result of the impact, it could bend up and create a vertical laceration.
So you would agree, based upon what you said, that generally horizontal movement of a car would be expected to cause horizontal lacerations. Is that-
Generally.
Okay.
Yes.
Now, during your blue paint test, the blue paint was featured more predominantly on your upper arm than your forearm. Is that correct?
I think it depends on the tests.
Do you want, we bring up a slide? Will that
I'd
help
love to
you?
bring up a slide.
We're going to be
I'd love
running
to bring up
the
a
thing,
slide.
so we'll just bring one up and you tell me whether this slide works for you, sir.
Do you want
Am
me
I
to tell you the slide I
overreacting
want?
with my
If we
complete
could
and
take
utter
a shot at it first, and then we may ask you for it. But I think we've
disdain?
got a slide for you.
last nerve that I am on with this witness? Am I overreacting?
111
Just
is
me?
on the screen, sir.
Hit the like button so you can help people find us, so they know that they've got an amusing place to watch this trial. So that when your head pops off, you'll have
Is
someone to catch
the
it
blue paint
in
more
another state or
predominantly on
country.
your upper arm than your forearm? Is there more blue paint on your upper arm than your forearm?
Probably.
Got a
This is the
punchable
one where I
attitude.
actually walked sideways into the back of the car. The one where the car is moving is probably a little better representation.
Sir, I'm just asking you a question about this slide.
We're on the last nerve train.
If
Okay,
you could just focus on this slide here, and if you can't answer it, so be it.
I just answered it.
Is the blue paint featured more predominantly on your upper arm than your forearm?
It sort of looks like it. I didn't actually measure the total area of it.
All righty. So on direct, you stated that in order for the injuries on Mr. O'Keefe's forearm to have been caused by an impact with the taillight, his arm would have needed to be held outstretched as you did in your demonstration, correct?
You would need some degree of outstretch, yes.
Yes. So isn't that
Hi to
an
Roger
example
B, everyone.
of confirmation
Hi, Roger
bias?
B. First timer.
No, that's matching the contact pattern to the injuries.
But don't you have to select among other choices
270 million,
this
Anilu. So much he sold his.
outstretching of the arm? You had to make that selection from among
Company
others,
for.
correct?
He's like a Timu
that
sugar
was
daddy.
Matching the physical evidence on his arm to the physical evidence on the car, and then running a test to see if dynamically those matched up. So it's, I didn't have it hit the exhaust pipe, for example, because there was no assertion to hit the exhaust pipe. There was no damage to the exhaust pipe. So it was based upon the evidence, and the testing was done to test, to use your vernacular, the hypothesis that that's where it came from.
Sir, have I ever asked you anything about a tailpipe in any of my questions today?
Yes.
I have not. I've never.
Yes, you
Tailpipe?
have. You asked me about the totality of the rear of the Lexus, which includes the tailpipe.
All right. I am not going to be asking any questions that involve the taillight in any fashion.
No,
So what I'd like to do
tailpipe.
is to go back to the
Tailpipe.
question that I'm asking, which is, did you consider, as part of the scientific method, in terms of more than one hypothesis,
Reverse engineering.
did
for
you
sure.
consider in your analysis any other orientation of Mr. O'Keefe other than the one you selected for your paint test?
Yes.
And where is that consideration of other hypotheses stated in any report?
It's not. I was just looking at the damage that was up on the sheet metal.
Higgins is absolutely watching,
So-
Terry. Absolutely.
Are you saying that you considered other orientations of Mr. O'Keefe relative to the vehicle as part of your analysis?
In terms of where exactly the hand would be, some slight different angles in the forearm, which is from the elbow to the hand. I did consider that, but all the physical testing is done with the hand hitting the approximate center of the taillight.
Do you have any notes that you took for these alternative
Wait.
orientations?
But the hand hitting the
No, I
taillight?
think I just included photographs of that damage.
Do you have any proof at all that you considered those other orientations? Anything in writing?
No, I don't believe so.
No.
Did you consider any other locations?
The poll should be up there unless you've already answered the poll.
Relative to the back of the
Poll is still up there. We've got
Sure. In the
7,200
beginning of
votes.
this, I started about, hey, it's all over, could be anywhere on the back of it. Then whittled it down based upon the evidence, started eliminating various hypotheses based upon the evidence, and came to this conclusion, eliminating hypotheses based upon the taillight fragments near his body, the lacerations, his height, the height of the taillight in the Lexus. So it was an iterative process.
Did you mention any of these supposed hypotheses in your direct testimony?
No, because I was able to reject them. I didn't come in here to tell these people what didn't happen. I came in here to tell them what I believe happened.
Would you agree, sir, that the scientific method earlier has the scientists identify various hypotheses, go with the data that
Put Proctor in the corner.
show your math as to why you're rejecting hypotheses.
Michael Proctor might be a better witness than this guy.
I'm asking for proof that you considered other hypotheses. Do you have anything in writing, any notes at all, any videos, any tests that you did, documentation of other hypotheses other than picking this one? Do you have any documentation of that?
So I did a bunch of tests with the Lexus. I did backing tests. I looked at how the rear system worked to see if it would autonomously brake. I confirmed it did not. So I eliminated that as a hypothesis. I tested the steering. I tested the transmission, what 1, 2 represented. So I did a whole bunch of tests on the vehicle.
Whole bunch.
I understand you say you did a bunch of tests on the vehicle. My question is, did you ever take the vehicle and position yourself or anybody else in various locations to determine whether or not your hypotheses could be properly rejected? Do you have any documentation that you did that?
I mean, I did do 1 static and 2 dynamic tests in very similar positions, though. So I did a total of 3 tests relative to the arm.
Where is the documentation for that, sir?
It's in the file. I gave it to you. Some of the slides are some of it.
Okay.
All right, so Mr. Alessi, I think if we're going to,
I am, and I'm going to move on, Your Honor.
So
okay, but Mr. Alessi, hold on. we're
We
gonna
have to
do
leave
that
soon.
one.
It's almost 4.
Can I ask, I just have
It's
one
almost 4.
other area, Your Honor. I can do it in short order if I
Okay.
could, please.
I wasn't finished with my.
Go ahead, finish your answer. I'm
So
sorry.
slides 109, 110, 111, actually through, I guess, 121 deal with the testing of the hypothesis.
we'll come back to this at another time, Dr. Welcher. So what I want to do
In one of the
is
rest of the days
to
this week that
finish
you're going to
up
be here
on
on the stand.
this
Change
point.
that flight,
So is
dude.
it your testimony that no part of what you did in selecting this area, no part of it is confirmation bias? You say there's no confirmation bias at all in what you did. Is that your testimony?
That's certainly my goal. I try and eliminate all confirmational bias. I didn't start out at this particular location. This is where the physical evidence led me to. So I would say the conclusions are supported by the science.
My question is, did you engage in any confirmation, and this will be my last question, did
The
you
answer is no.
engage in any confirmation bias in terms of how you approach the issue that you have testified about in written reports?
The answer is still no.
It's a good
All right,
written.
so, okay, thank you.
All right, so jurors, we're going to send you home because we still have work to do.
Oh, we do? We have work to do?
There will
Oh, I can't wait for the work that we're going to have to
Tomorrow
do.
is a half day.
Half day.
We'll see when exactly that half day ends, but we won't be here until, we won't go until 4 tomorrow.
It'll be a half day?
Those three
Do they get
cautions,
lunch?
Do not discuss this case with anyone.
get
Don't do
lunch
any
tomorrow?
independent
Half day?
research or investigation into
This is 6
case.
hours of my
Do
life
not
that I'm never getting
proceed
back. And
here
remember, we didn't even
or
start
read
until after
anything
10
about this
today.
case. Please disregard it and let us know. Fourth admonition, please be very careful with your social media use. We'll see you tomorrow morning.
Oh, he thought that was funny when she said, be careful with your social media use. He thought it was funny. Okay, jury's going out. What's going to happen next?
All right.
Not happy.
Okay, Mr. Alessi, it's your voir dire.
Oh,
a moment, Your Honor, to switch.
we have more voir dire to do. Okay. Okay, I got to get the banner ready. You know what? The banner is there. Court TV has the banner up, so.
Is that while you're sitting here answering questions? Yeah, can you do that while you're sitting here answering questions? Yeah.
The caption said, I love my slides. I don't know if that's what he really said, the witness, but the captions caught, I love my slides. OJP, outside the jury's presence. That's Court TV shorthand for, we let him go home for the day, but we're still working. We're still working here in the courtroom of Beverly J. Cannone in Norfolk County. Inside out, upside down matrix of the Superior Court, Norfolk County, Massachusetts.
Okay.
My favorite court officer, she's there again, front row, love her. Somebody find out her name and email it to me, please, 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 please.
30th.
You guys vote
Honor's
in the poll
permission,
so I
if
can
we
end
could
it.
Pull up the, Mr. Wilk, with Your Honor's permission, if we could pull up the January 30th, 2025 PowerPoint of Dr. Welcher in slide 36. You see that, Dr. Welcher? Do you recall that from your January 30th, 2025 PowerPoint?
This is from the January
I
PowerPoint.
thought I had replaced the video on the left-hand side by the time I produced it.
Sir, I got to
don't
go through
recall
this
that.
quickly. That image is a drone image on the left, correct?
Drone image.
Oh, correct.
And you had that in your original report, but you removed it in subsequent reports, correct?
Correct.
Where did you get that drone image from?
It was in the file.
Wasn't it in the CARS report of Trooper Paul?
I believe it was.
So you took that drone image from the CARS report of Trooper Paul, correct?
Correct.
Who told you to remove
Let's,
it?
if we could, Mr. Woke, go to diagram 1. Do we have that?
Nothing gets by
electronically
Bobby
of
Alessi.
Trooper
Nothing gets by
Paul's
him.
report?
He's like eagle-eyed. He's so smart. Nothing gets by him. And you should see the guns on him too. Him and Will LeGlaire took a picture in the courthouse on the steps inside on a red carpet. And let me tell you what, he's like 60. Somebody said he was 67.
Do you
I don't
recognize
believe it
that
until I
is
see a birth
diagram
certificate.
1 from Trooper Paul's report?
Yes.
So, and that's the diagram that you took that image and you put it in your January 30th, 2025 PowerPoint, correct?
Pulling up my version of PowerPoint.
No. He needs to pull up his version. He's got his computer back. Somebody gave him his laptop back. I will never get this day back. It is never coming back to me in my life.
Yes.
These are 6 hours of my
Okay,
life.
if
I'm
we
never
could
getting
take
back.
that down,
I
I'm
have
going
to
to go to the next
come to
example.
terms with it.
We could go to Dr. Welcher.
I'm sorry, actually, can we go back to that?
Yes. With, Your Honor, why do we?
Well,
We don't have
I
time for your
limited- go ahead.
shenanigans, witness.
that particular diagram I did not use. If you notice, the diagram I used has different cars and doesn't have all the writing about the position of things on it.
I am going to now, Your Honor, have to take the time to go to
Yeah, because this guy's trying to
To
control
Trooper
everything.
Paul's
He's a
report.
control freak. He wants to control the questioning, the questions. He wants it to be the judge, the jury,
We have
the
a hard
lawyer.
copy of Trooper Paul's.
Could you turn the lights on, please?
It's the love of the traveling Mary.
Your Honor,
Yes.
I'm going
Show
to.
Mr. Brennan.
Yes, Mr. Brennan, this is Dr. Welcher. You see this first page, do you recognize?
Dr.
this as
Vulture,
cover
it
page
says.
for the Trooper
The captions call him Dr. Vulture, and I will allow it.
Paul report that I was referring to?
Lisa, can you show me the signature?
You want to look at the report, sir?
I
I'm
do.
not so sure there is a signature on the report.
Thank you, Siobhan, for teaching me some Irish.
Signature block right here.
Yeah.
Yes, Trooper Paul, page 16.
I have that.
Yes.
Thank you.
Welcome.
Now, what I want to do is to go to diagram 1. And if I could, Your Honor, republish what was just up. I'm showing you diagram 1, sir, and I'm asking you, is that the image from Trooper Paul's report that you then used to put into your January 30th slide presentation?
No. See all the writing on here, the glass cup, all the dimensions here. Here's my January 30th one. None of that stuff's here. There's different, none of this stuff is here.
This is all outside the presence of the jury, so I'm going to ask for last call to vote in the poll about who, if anyone, you think Welcher's testimony has helped. Last call, 2 minutes.
Isn't it the case that this is cropped more and there's a larger picture of the same image or not?
See this tree?
Yes.
See these trees?
Yes.
See all these measurements by the trees? All
Yes.
these? That's right here.
Okay.
Those do not show up on my image.
Let me go to a different method then to do this. You have an image. Can we go, Mr. Wolf, to the January 30th presentation?
Slide 36.
Correct. Where did you get that image from that's in your PowerPoint presentation on the left?
Make a
I think
martini
it was from the
quesadilla.
file, a satellite image from the file.
What part of the file, sir?
I actually don't know at this time.
How close is the image on diagram 1, the drone image, to the image that you can't now recall where you got it from for your slide presentation? Are they similar?
So that one has a whole bunch of measurements and ID on it, but the underlying image is very similar. It's probably the same one.
Right. Yes. You're welcome.
Maybe sort
Do
of
you
the same
know
one.
of
maybe.
any other place you could have, let's put the presentation back up on the slide presentation. Do you know of any other location other than Trooper Paul's report that you could have got that drone image from?
No, I'm not sure I got it from the report. I recall getting it from the file.
My question is, do you know of any other source other than Trooper Paul's report that you could have gotten that drone image from?
Tully?
So this image is not in that report.
It's not
Yes, it is. You asked me anything but the report. That image is not in that report.
Did you get the drone image from any file from the Massachusetts State Police?
Yes.
Okay.
Thank you, 18 Wheels of Outrage, my friend, for gifting 5
Did
memberships. You're
Trooper
awesome.
Paul work on any drone images to your knowledge with respect to 34 Fairview?
I don't know.
But you would agree that the drone images are from the Massachusetts State Police file, correct?
Give me 1 second.
Therese Welcher, if you were my wife, I'd poison your coffee. Wife, if you were my husband, I'd drink it. Well done, girl. Thank you, Stephanie Flynn. I can't do that. I can't break from what I'm doing to read your email right now. But thank you. I will when I can, but I can't. There's too much going on here, and I can't be here
So
all
let me know
night.
you've had a fair opportunity to answer
Thank
that
you. I will
question.
look when I
Give
can.
me a second.
Good idea, Bella's mom. Good idea.
Yes, it came in a file called cars-trp.jopal.
Okay, so it came from, and that's the
Trooper
report
Paul?
of Trooper Paul, correct?
No, these are drone images that are not in the report.
No, I'm saying what you just read. Can you repeat it again, what you just read, where it came from?
I read you a folder
Yes,
that contains a bunch of things, including the report.
understood.
That image is not in his report.
Can you read the file name again that you just read?
The folder name
Yes,
is
Yes, you're right. Yes.
cars-trp.jopal.
okay. And
Trooper Joe Paul.
did you get the drone image from that file folder?
I did.
Okay, thank you.
You're welcome.
Now let's go on to the May 26, 2025 PowerPoint that you created. And I'd like to go to slides 25, 26, and 27. Have you discussed with anybody today at all the source of what is depicted up on this slide?
No.
Okay, so let's now go to where did you get you see the larger chart to the left there in the, looks like mostly a rectangle. Do you see that, sir?
What slide are you on? What slide is that?
25, I
25,
believe.
Okay.
Okay, and then if we could click to 26, because it looks like it's the same. If we can go to 26 and 27, looks like it's the same one. You tell me.
Similar,
Similar, okay.
yeah,
In 27,
correct.
see the same or similar one there. Okay.
These are all from Google Maps.
Well, my question is, may I approach, Your Honor?
Yes.
Thank you. Let me ask you this so I don't have to keep going back and forth. Do you have access, sir, to the cars report of Trooper Paul on your computer?
Think so? You remember the name of it?
What's the over under on that?
With the hard copy.
All of AJ's nickels. Think he brought another outfit for tomorrow, or is he going to wear the
So,
same one like Burgess
if I
did?
could, approach, Your Honor?
He'll just
So
put it on the
you
bill,
see what I'm
like the
pointing to
Lexus.
Right here, which is page 10 of Trooper Paul's cars report. Do you see that?
I do. Is this the same report dated 1/29/2022?
I believe so, sir. Let me just take a peek. This is, you can just compare this to the one I have in my hand. Take it and look for any identification it gives you, right? We got the same one.
Yeah, mine's frozen.
Okay,
So let's do paper.
okay. So we have that report.
Mhm.
And I now am referencing page 10 of that report, and I'm looking at the chart on page 10. Is that chart on page 10 the same or substantially the same as the chart that is up on your slide presentation right now?
So it's not the same. I did not use this data at all, but we both use Google Maps.
Okay. All right.
Hey,
Now
boots on the
let's go
ground.
to,
We're here. We're right here. Curious.
Your-
Savage.
continuing on the
81.
same slide, if Mr. Woke, we could go to slides 22 and 23.
Okay, and this will be the last on this, Mr. Alessi. If you want to get to the autopsy photo, we're wrapping this all up at 4:10.
Okay,
No.
Your Honor.
We're a couple minutes behind. Yeah, she's got hard stops, because there's only a woman facing life in prison, and we got to be on her schedule. 4:10, we got to be.
You see the photos that are up on that?
I do.
Okay. Do you, in terms of those photos, do you recognize any aspect of those photos?
Yes.
What do you recognize
Yeah.
in terms of the person in it?
Oh. You want me to limit it to just these 3 photos?
He's asking
Any
the
photo
questions.
that would be this photo or any photo similar to it. But let's start with just these 3.
If I have to limit it to these 3, I don't know who that is.
Okay, and if you don't limit it to those 3, who would you conclude it is in those photos?
It appeared to be Trooper Paul from other photos.
Okay.
Oh, that's Trooper
You
Paul.
can tell from other photos that this is Trooper Paul in these photos, correct?
I have photos of Trooper Paul in the car. I don't
Right.
know that someone else switched out. I have no reason to believe this isn't anybody but Trooper Paul.
Okay. Would you have any understanding that there's any other trooper that would be doing this type of analysis other than Trooper Paul?
Someone else took the photographs?
No, I'm talking inside the vehicle.
I'm sorry?
Look at the judge.
Inside the vehicle doing what's depicted here.
She's had it. She's cooked.
Someone is inside the vehicle
Stick
taking
a
the
fork in
photograph.
her.
What's your
She's
best conclusion
done.
as to who that is?
Trooper Paul.
Thank you. Your Honor, that is,
Okay, so next topic.
yes,
Go right
thank you.
ahead.
And I just need to reload, if you will,
Reload,
with
please.
regard to that topic.
A lot of whispering going on. Karen's getting involved. She's got a binder. She's got sticky notes on it.
If you could, if Your Honor, you can go to slide, and I think I can do this fairly quick.
If it's autopsy
If you
photos,
can
I'm taking
go,
them down.
Mr. Woke, to slide 131 of Dr. Welcher's PowerPoint presentation. And it's now 132. I don't believe that's the right one.
He
It's
does,
the-
Hannah. He makes
One
bucolic
before
seem
that.
immutable on cross.
Yeah, okay. So this is slide 131 from your slide presentation, correct, sir?
Correct.
And if you look to the far right, I'm sorry, Mr. Woke, you go to the other one. Yes, that one, and scroll down so we can see what's in green. For that depiction, that is from Dr. Scorty Bellows' autopsy report, page 3, correct?
Mhm.
Is that where you got that from?
Look at the fracture lines in green.
Take your word for it on page 3.
So, but it is from Dr. Scorty Bellows' autopsy report, correct?
Correct.
Now, if you could go to, if we could zoom back out
Look at all the different skull fractures.
and go to the multicolored image in the center. up at
Droopy
the top.
dog. Clarity says he looks like Droopy Dog.
Yep, I got it. Yep, thank you. If you can go to the very top line, it says autopsy report performed by Irene Scorty Bello, MD, PhD. If you could scroll back over, date of autopsy, January 31, 2022, and then you see final diagnoses. That is all directly from the autopsy report, is it not, sir?
Yes.
And that is in your slide presentation, correct?
Here's what I'm going to read it to you. It says final diagnosis. This is Irene Scorty Bellows' autopsy report. We have to relish in this because we've never seen the autopsy report. And this is the first even bit or piece that I have seen. Autopsy performed by Irene Scorty Bello, MD, PhD. Date of autopsy 1/31/22. Final diagnoses: blunt impact injuries of head and extremities. A, abrasions and lacerations. B, subscapular hemorrhage. C, multiple skull fractures, base of skull and calvarium. D, subarachnoid and subdural hemorrhages. E, C, report of neuropathology. And that would be Dr. Renee Stonebridge. They have not called her either. She examined his brain after it cured in a jar for, I don't know, maybe a week or so.
Correct, sir? This is page 131 of your slide presentation, correct?
Correct.
That's all I have, Your Honor.
Okay, you are all set,
You're
Doctor?
all
Thank you,
set.
All right. Oh, did you have any questions, Mr. Brennan?
If it'd be helpful to the court, I have a couple quickly.
Okay.
I keep on-
Oh, for the love of the traveling Mary, Brennan is going to do something here.
Dr. Welcher, you were shown a photograph of the street of Fairview Road. Did you know that didn't come from Trooper Paul? It came from the CERT report, and Trooper Paul then took it from the CERT report and put it in separately in his presentation. Did you know that?
I had no idea. I just was given it as a folder.
And the photo you were using, it didn't have the markings that Trooper Paul put on his report, did it?
It did not.
When you used that photo, was it because you were borrowing, relying on, or using any of Trooper Paul's reports for your conclusions or any of your decisions or analysis in this case?
I did not use his report at all.
It was simply limited to the use of the photo to show a different demonstrative issue.
Correct.
And then when you saw diagram 1, again, that was different than what was used in Trooper Paul's report because it had absent in it all the writing. Isn't that fair to say?
That's fair to say.
Did you rely on Trooper Paul's analysis or conclusions in this case for your conclusions and your analysis?
Not at all.
Is that why you went and downloaded the information and looked at the car and did everything individually, separately, and uniquely from Trooper Paul?
I wanted it to be independent in my analysis.
Regarding Dr. Scotabello, did you ever consider her conclusions regarding manner or cause of death as a basis for your analysis and conclusions?
Yes.
And when you considered her analysis, did you consider the conclusion of undetermined cause of death? Was that part of your analysis?
Oh, no. I was using like the skull fractures, the description of the injuries.
So you were considering the information in her autopsy report?
Correct.
How about her conclusions? Did you rely on her conclusions to do your studies or any analysis in this case as far as cause of death or manner of death?
Only I thought I said blunt force trauma and hypothermia.
Okay. Regarding her conclusions about whether this was caused by a car accident or not, did you consider that as the basis of your opinion?
No, I wouldn't take a person like that's opinion for that.
Did you ever have a conversation?
Wouldn't
with
take a
Dr.
moron like
Scotabello
Trooper
about
Paul's
her
seriously.
expertise limitations?
Is what he wanted to say.
No, I would want a biomechanical analysis.
Was your opinion regarding the collision in this case, did it have anything to do whatsoever with Dr. Scotabello's conclusions regarding cause of death, whether it was accident, undetermined, or homicide?
No.
Okay.
Thank you.
Yeah, Your Honor.
All right, one question. Can we just?
One?
wrap it up?
No.
I'd like to hear you argue, but we don't have time, so I'm just gonna,
I have
Decision.
two questions, Your Honor. You put in your slide presentation information from the autopsy report of Dr. Scotabello for a reason, correct, sir? And that reason is because you considered the autopsy report as part of your analysis, correct?
So I considered portions, which are the portions I included here for the autopsy report.
And part of those considerations were the final diagnoses. We can put that back up, Mr. Woke.
I agree with you,
But
Bonnie.
you recall the slide that you had has the final diagnoses of Dr. Scotabello, and you put that in your slide presentation because you considered that as part of your analysis, else it wouldn't be in there, correct?
So the final diagnosis is in there. There's a line, then it says cause of death, and then manner of death.
Right.
The things I highlighted are the things I thought were important. So the highlighting on slide 130. So the final diagnosis, again, does not include cause of death. It does not include manner of death. There's that horizontal line demarcating those. The important things that I was looking at are the under or highlighted, which is why I highlighted them.
Exactly. So the ones that you highlighted, you considered are from the autopsy report. That's why you're highlighting them, right, sir? You
Correct.
considered that.
Correct.
Thank you. No
You're welcome.
questions, Your Honor. I
All right.
appreciate that opportunity.
so I'm not gonna let you argue now. I'll hear you very briefly tomorrow before we stop. But Mr. Alessi, how much longer are you going to be tomorrow?
However long it takes.
Yes.
However long. Look at the court reporter's face. Did you see that? She had to her jaw has been clenched all day. What did he say?
I'm about halfway through, Your Honor.
Halfway through. It was a full day.
I think it will take up, look for it tomorrow. If we can get some things quicker, I would like to do that, but given today, that's my best estimate.
So we're half a day tomorrow.
Yeah. He's going to have to change his flight until next week. He can't answer a question. It's his own fault. It's your fault.
So it may be that we have a 20-minute break tomorrow.
Thanks, Abacus.
And we finish up by 1:30 by going straight through. We've got a juror who has an appointment that we told her she'd be able to make. So I'd like to do everything we can so that Dr. Welcher doesn't have to come back or stay here another day.
Tough. It's too bad.
So let's just see what
Too
we can
bad.
do. And we
Shouldn't
will
have
do the same
overcharged
thing
her.
for your experts
Shouldn't
as
have
well.
charged her at all.
No, I understand, Your Honor, and I respect everything that Your Honor is saying. I must say, Your Honor, to state the obvious, this is the key aspect of the case, and we've got to be able to proceed through to the question. He covered a
And-
lot on his direct, and he probably.
And I'm not asking you to curb it. I'm just hoping that we can do it. So I will ask you tomorrow at a certain time to see whether we're able to do it with the 20-minute break and finish.
Fair enough, Your Honor.
Okay.
I'll
Not
give
finishing.
My answer is that that's the point.
Okay. All right. Thank
The
you.
court officer's name is Eugenia.
Thank you, Dr. Welcher.
Thank you, Elizabeth. Her name's Eugenia. Hi, Eugenia. We love you. We love you. You're the star of the show as far as we're concerned. Star of the shit show, starring Eugenia, one of the amazing court officers in the courtroom of Kim Jong-un. What a day. What a day. I'm exhausted. Are you exhausted? I'm exhausted. And Alessi's only halfway through. He's never going to finish tomorrow. He did a full day today. That means he's got at least another full day. And it's the witness's fault for not being able to answer a freaking question without a roundabout way. Let's end the poll now. If you are going to leave before questions, please smash the like button on your way out. Here is what the poll said. The last 8,800 votes. Nope, 9,430 votes. Here is the results. I'm going to just screenshot that for later. What is that? Oops. It is ending now. Welcher's testimony so far at there are 9,482 votes. Helps nobody. 52% of you has said it helps nobody. 42% of you said it helps the defense, and 5% of you said it helps the Commonwealth, and that is 94 of you lovely friends voting in that poll. I guess it's going to depend. We're going to be able to take a better poll after we see the ARCA witnesses, and then we can compare the two testimonies. The testimony of the accident reconstructionist for the Commonwealth, this guy, and the testimony of Dr. Wolf and Dr. Rentschler from ARCA. And that is going to be interesting stuff. Crunchy Cat, Fun Cat says, go Buffs, go Buffs. Will you be going to the Crime Con in Denver this year? I don't know. It's in September, right? We'll see. See what happens. Free Karen Reed. Free Karen Reed. We'll see what I'm doing and, what I'm covering at the time. So my schedule depends on, the trial schedules, really. Who knows what's going to be happening in September. I don't think we'll still be here covering Karen Reed, but you never know. Piney with Long Crime says also Alessi needs to ask to review this expert's computer texts and notes from the stand. Exactly what I was saying before. I'm behind, but thank you. Mr. Entry Required is a New Yorker, and Mrs. Entry Required are watching daily in Sweden. That's what I thought. SEK was Sweden. Thank you so much. Happy to have you guys. Kelly points out that his last name is wrong on his email is Weckler, WECLHER on his CV, that you searched Welcher and it didn't come up on the Aperture website. That's crazy. Casey Jones, you better watch your speed. Jeff Mickle says we got to put that on because who the hell's driving this train? We don't know. Michelle Conley is a materials engineer, and she says the polycarbonate tensile strength is higher than the amount of force to break a bone. Polycarbonate breaking point is 4,500. A bone has a much lower breaking point. I'm a materials engineer. Well, this guy, Judson Blair Welcher, could not tell us how many pounds of force it takes to break a bone. He just couldn't. A bone in the hand. He would not commit to anything. Did he ever give us a final answer? Is that your final answer? Remember, she's already asked one witness, is that your final answer? And we're all laughing like, really? Do you want to phone a friend? How many lifelines do you get in the hot seat of the witness stand of Judge Beverly Cannoni and Preposterous? Peckerwood said, I want this man to walk on all the Legos. Well done. Miss Anthrope says, trying to get an arrogant narcissist to acquiesce is like banging your head against the wall. Wish I didn't know this. I think there are many of us here who wish they didn't know that or have a degree in toxic narcissism. From Instagram, Will Wallace chiming in with biomechanics. In Welcher's case, can we abbreviate that to BS, which is what his testimony is due to his faulty, tampered evidence, along with his ludicrous simulation, which he's based his hypothesis. Thank you, Will Wallace. Appreciate you. Patty McDaniels said, are we on candid camera? Are we being punked? Yeah, Ashton Kutcher and Alan Funt. I'm dating myself with the Alan Funt reference, but if you know, you know. He was the original host of Candid Camera, going back many, 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 many years. Shonda Baldwin says, my kid is 40 pounds and he fell directly backwards directly backwards on her arm with her hand flat on her back from the monkey bars and broke her hand in 2 different places. I have 5 kids. We have suffered many a fractured wrist in this house because that is what kids do. They brace their hand on the ground when they fall on the ground. Unlike Colin Albert, whose knuckles scraped the ground when he went to break his fall. And they've happened all sorts of ways, right? From ice skating, skateboarding, trampoline, you know. No, he's not done. He's coming back tomorrow for at least the half a day tomorrow that they will be in court. And he may have to change his plane ticket to next week because Alessi's only halfway done. The other Linda says, YouTube will not let me send the message I want to, so I have to leave it to everyone's imagination. Thank you, Linda, for keeping the chat clean. Ham sandwich, pizza, and pancakes, oh my, that is taken directly from Jessica Hyde's testimony, says 1.0 travesty, 2.0 Brennan level of slime. Is the defense going to make sure his notes are taken before recross? Says tequila is now my social lubricant. We have to see when that will be. Recross, recross, you mean redirect? Redirect might not happen until Friday at this point. Tomorrow's only half day. They're going to cut the break. She said, maybe we'll go to 1:30 because a juror has an appointment, so they can only do a half day. And that is very nice to be able to, there is court on Friday, full day. The Spotify playlist mixtape is pinned in the chat. If you want a copy of it, just click on it. If you use Spotify, you can get it that way. Julie said, Hank asked for an instruction, not a mistwile. If he knew how to speak clear English, we'd know what he said. Yeah, a couple of people sent me that tweet. It seems that he asked for an instruction to the jury, not a mistrial. So I don't want to spread information about anybody asking for a mistrial because that just did not happen. Lone Wolf 482, Bev said the Commonwealth. Again, nothing was wrong with that line of questioning. No, Bev saved the Commonwealth. Again, nothing was wrong with that line of questioning. They want to hide too much from the jury. Good. I'm glad you're picking up what they're laying down, Lone Wolf 482, because we've been here in this nightmare on this channel since January 2024. I can't wait to see Garrett Wing testify. Michelle, again, is a materials engineer. Did he take measurements of John O'Keefe's body before he began his experiments? No. Not everyone has the same body build. This is junk science. Ridiculous. Thank you. Thank you for your opinion with a reasonable degree of scientific certainty, because, my friends, there is no such thing as a reasonable degree of engineering certainty. That is not a thing. It is not a thing. Scientific certainty. Brian Flynn, what's the name of Welcher's dog in this fight? Blue, ambush, confuse us. That was very well done. So I had to highlight it for later. Lynn, thanks for becoming a member. I went to the sidebar with Melanie Little, says he acts like an indignant 14-year-old getting questioned about his science experiment. Yes, I've seen 5th grade science experiments that are better than that. Lena B, I can't even with him. I think he's slamming a sharp pencil through my hand would be less painful than watching this guy's ego try to figure out how to pretend he's the smartest person in the room. That was very well done. So even though I put it up earlier, I wanted to read it aloud to the class. Smurf Paint says, how is this guy for real? It's like we're all participants in the weirdest social experiment in modern history. I keep waiting for Bev to leap over the furniture and say, you're on candid camera. That is. And then the guy didn't come out alive, said, I picked a bad day to stop sniffing glue. Thank you for that. 2 words, do it. Exactly. If there are so many unknowns, you can't do a reconstruction. The best you can do is say, if there was an accident, then this scenario is possible. Exactly. But he wants us to believe that Karen backed up 87 feet into John O'Keefe, didn't hit the Jeep with the plow on it, because I don't even think he knew it was there, but maybe he saw a statement that it was there. But I think he said the only thing he knew about was the F-150. We are all on the Truman Show for sure. Says genius Dr. Alessi saves the world. Hulda from Iceland. We are all on the Truman Show. All of us. Bev's biased beratements and rulings says, can ARCA rebut these new claims by Welcher? Yes. Oh, yes, they will. Angels above, please go over Carl Steinbeck's last 20-minute live stream from last night. Carl found something about this guy. I can't play it on the air. I don't play other creators' content without their permission. And so I would not do that, but you guys can all look for that later. Thank you, Angels above. Megan, the defense needs to tell the ARCA guys to be as nice as pie to Brennan. They know. If anybody knows how to behave on the stand, it is Dr. Daniel Wolf, Dr. Andrew Rentschler. They are class acts all the way. I don't even think they need to tell them anything. They know how it's done. Dr. Daniel Wolf smiled through that entire voir dire, and those dimples are everything. And I agree with you, but I think they know. I don't even think they need to be told. And she says, the defense needs to tell the ARCA guys to be nice as pie to Brennan, show them what an actual profession with no bias sounds like. Oh, look at me. I'm the first one to view Microdot's new dropping. The Commonwealth theory fails. Karen Reed, it's 6 minutes long. Go watch it after this. You know what? Maybe I'll redirect to that so you won't miss it. I will do that if they allow it, if they allow redirects. Show them what actual bias looks like. Thank you, Donna. Texas says, married to him. Hard no to a narcissist. They're always right, and there's no reasoning with them. Thank you for that. Churicity is also an engineer. She says, I'm an engineer. We have no certainties. Oh, no, you're quoting. I'm sorry. You're quoting the witness. Trial over. Reasonable doubt, right? Yes. Reasonable doubt, because this guy didn't know anything about anything. And according to Sue O'Connell's observations of the jurors, they were picking it up. Shelly says, I'm wanting to send Karen and her team dinner. This man is insufferable. You can do that. The link to the defense fund is below in the show notes. They would, I'm sure, greatly appreciate any and all donations at this point in the trial, because they are feeding multiple people every single day. They're housing all of the attorneys every single day. The attorneys moved here for this trial, and they're going to be here until it's over. They have office overhead. They have, even though all of the attorneys are working for free. And quite frankly, during the direct examination portion of this case so far, Bob Alessi has been carrying the load here. He has been carrying the heavy load. He's been load bearing. He's been the load bearing attorney. And he is so outraged by what is going on here that he is working for free. He is a New York attorney who bills out at something like around about $1,800 an hour. And he is here working for free to free Karen Reed, because he too is outraged by this outrageousness. And we should all be outraged. And I know many of you are. Microdots does not allow redirects, and so I don't know that I can do that. Okay. Can I? No. He doesn't. All right. So that's the problem, is that you can't redirect unless creators have that button checked off. All right. So here we are. We're moving on. I'm sure they would happily accept your donation, and you can even put in the little RE thing. This is to buy you guys dinner, lunch, whatever. They're buying all these meals. They're feeding everybody. Thank you, Carla, for buying a matcha latte, and says, after this frustrating day, you may need a little pick-me-up. Love my matcha latte. Thank you so very much. Also, Michael says, I don't truck around Manhattan, so you'll have to take yourself out for a coffee. Oh, thank you, Michael. I appreciate that. A lot of truck drivers in here, and I love it. I love you guys. I'm so glad we can keep you company. Heather, thanks for your Venmo. Says, these past 2 days have been unbearable. Thank you for being angry with the rest of us. I am angry. And I'm like an acquired taste. Really, there's no middle ground. It's like Dave Matthews. Like, you either love him or you hate him. Like, there's no middle ground. That's kind of like me. It's kind of, people stop and they leave me like comments like how, oh, I used to listen to Emily Baker and then she stops her stream too much, and you're getting like that too. And you're talking over testimony and you're stopping too much. It's like, come on. If you don't like me, there's about 400 other people that you can watch. You don't need to stop and tell me why. I don't care. I really don't care. You're not going to hurt my feelings. And you leaving an extensive comment about trying to hurt my feelings isn't going to work. It's not going to work. I'm rubber, you're glue. Whatever you say bounces off of me and sticks to you. Thank you, Mindy, for also coming in via Venmo to buy some some coffee. And Sherry, thank you very much. I think I thanked you earlier for the Cash App. That was very sweet of you about the doctor. That was the doctor comment. Now we know why his father said no doctor for you, because you just couldn't cut it. Natasha, thank you for the matcha latte, for thanking me for all I do. You guys are so amazing. Sarah, thank you for the Venmo. There will be a spinoff, which is still in production, of The Handmaid's Tale. Oh, really? The Testaments will be 15 years later, no release date yet. Oh, that makes me happy. So it's going to be like kind of in the future. Oh, I like that. I like that. I did have a box of tissues next to me last night for this season finale. Did you guys watch it? I don't know. Maybe we need to do a stream on the finale of Handmaid's Tale after everyone has a chance to watch it, because also, you know who watches it? Mark Betterow. I haven't talked to him about it quite yet, but he and I will be talking about that. Maybe we'll do a stream on it. You tell me if you guys would be interested in something like that. Auntie Deb and I also have the same taste in a lot of television. And so we do talk about things like that on Sunday night streams when we try to distract people from the Karen retrial, because if we weren't all crazy, we'd all go insane. That's the great Jimmy Buffett. Lauren, thank you very much for your Cash App. Says thanks for everything you do for our community, for your community. You're very welcome. And so you can do that, Shelley, by donating to the defense fund. If Karen's tires spun on snow, what happens to the distance traveled? Says Jackson Ivy. And vehicle speed readings. Well, Alessi's not even halfway done, and you can be sure that that is on the list of questions for him to be asking. I'm Cora, not Chloe. David Reese says Bob deserves a double Jameson. Neat. The only way to drink it. Higgins. Kelly was rage pet grooming today. 7 cats and 2 poodles. I hope they didn't get any crazy haircuts. Bex, chat, you can answer this. Thanks, Mel. Does anyone remember if McCabe testified about the Jeep this time? Can't remember. Did she? I think she was asked about it. I think she did ask about it. The Catbox says, Welcher, I can be anything you desire. Tell me your fantasy. Yes. And then just me chimed in. Wait, he saw testimony about the Jeep in front, or he has statements. Which is it? I think it was a statement of Jen McCabe. Maybe, but it's unclear. It's unclear, just me. And you're a doctor and you're even confused. So there's that. Chloe Albert's revenge said the weather has nothing to do with whether there was a collision or not, but her statements do. No wonder the Commonwealth had hired you. And then so say we all says, was Karen driving the Fortnite bus? I'm not a Fortnite person, but I'm assuming that was funny. And so I'm putting it up for those who do partake in the Fortnite. We can read Welcher's paid testimony says no pictures of the crime scene. Why is he getting so frustrated with the questioning? Is so being paid for this testimony. How can he be serious? Love you. Thank you for everything. No, I love you. Olaf said Spaceballs, the Flying Winnebago. And so on, and so on, and so on. Denise pointed out if a witness is telling the truth, he does not need to try and validate every answer. It's true. Will Wallace says there definitely was a collision. It just wasn't vehicular. The evidence I've seen convinces me of that. However, I'm watching this freak show. These people peeing everywhere, and their explanation is, oh, that's just rain. That's right. That is right. Massachusetts saying Alessi's composure is off the charts. Amazing. I just can't even. I know. I don't know how he did it. Bev's biased beratements and rulings from Canada said, oh, not from Canada, from across the pond says, me and the Traveling Mary have hit the booze for the sake of our sanity. You're all welcome to join us, but no driving. That girl coming in with a lot of super chats today. So thank you very much. I've noticed I've put them all up on the screen. His length measurements with contact, G with continuous contact, would be body was dragged and not in that location found. Thank you. Thank you. Thank you. I know. Siobhan teaching us some Irish words, and Amadon is an Irish word for fool. I will allow it. Melissa would like some feedback from the people voting helps the Commonwealth. There was only 5% of the votes, and it was like 9,400 votes. So it was not a lot of votes at all. But I would like to know, just curious for the reasons that it helps the Commonwealth. Because you know what? If some people buy into it and like, oh, yeah, that's plausible. She hit him with his car. I've been saying this, screaming this from the beginning. One question. First thing they do when they go in the jury room, was John O'Keefe hit by a car? Go around the table, yes or no? If everyone says no, that's it. We go home. That's all. That as simple as it is. That girl again with a $50 super chat. Thank you so much, and thank you also for your service. And my sympathies go to. I think you were in here the other day talking about the friends that you've lost, and so I'm sorry about that. He had blunt force trauma to the head. Newton's second law, equal in both magnitude and direction to the force imposed on it. The arm, hand doesn't matter, the impact to the head. Thank you. Thank you. Sandy Jimenez. Jughead Juddy is like a broken calculator full of numbers, but completely out of touch with reality. PhD from the University of Crackerjack Box. Ryan is a snow and ice driver. Karen could have put her car in snow or manual mode while driving. We haven't heard if this shift could throw off text stream data for a few seconds. Nick Indy pointing out, Karen said in a clip, Karen said the word clip in an interview. Yes, she did. I didn't know. Could I have clipped him? So he was told to say clip. I think you might be onto something with that. Melanie Little's head bucket is here to catch my head and says, I'm 5 months sober and this guy makes me want to drink. My blood pressure's through the roof as a fellow engineer. Don't do it. It's not worth it. It's not worth giving up your sobriety. Pamela Bailey. My grandmother always said fakakta. Yiddish word pronounced fakakta. I say it all the time too. I said I was saying it yesterday, fakakta. I'm verklempt, I'm fakakta. It's a mishigas. It's a shanda. It's a Yiddish word, slang term used to describe something crazy defective. It can also be used more generally to describe something ridiculous. I like it. Priscilla, thanks for your super sticker. Tracy, I wish Bev would tell Welcher to answer the question without a big debate. She has no control over this courtroom anymore. It's gone. It's like to the wolves. Arca versus Aperture. Fealty. Thank you, T.S. Tolkien. Tamara said the evidence spoke to him. He's not biased. Never, never. He needs to stop the sidestepping and answer the questions. It's never going to happen. Simply 68. Alessi is my official hall pass. Who would have thunk it? Let's go crazy. Prince and the Revolution. Thank you. New version of PowerPoint tomorrow, says Edmund. We'll see. Bruce West, no one considers wheel spun in the snow. Imagine that. No. Michelle Roy and Lauren Elizabeth, both new members. Welcome to the circus. Hank Brennan's floating timeline is here and says, if I were the defense, I would have eyes on Welcher tonight. He's mad. He's going to probably have to change the flight to next week. I don't think they'll be done with him this week, but maybe. Miracles can happen. We always pray for miracles, don't we? Farmer Whitehair says Arca has answers to Alessi's questions. Yes. Dragons and a Horse says if arm was hit by a car, wouldn't there be a bruise? Yes. 100%. 100%. The arm would have been shattered at 24 miles an hour. But now this guy is now backing off the speed, saying that he doesn't know what the speed was. And that yet at another time, he knows the speed. Make it make sense to me, please. Someone talk to me like I'm 5. Farmer Whitehair says Arca has answers to Alessi's questions. Is there anybody out there that can explain this to me like I'm 5? Because that's what I need. It's been a really, really, really long day. So we're going to break for today. We are going to come back tomorrow for the half day. Tomorrow they are starting at 9. So we are going to be here through all of it. We're going to hold each other. We're going to hold each other through it and see what kind of fakakta, asinine, mishigas hellhole we're going to find ourselves in tomorrow. And I'm going to be here for it with you. And so at least there's that. At least there's something to look forward to. Thank you, Jessica, for your Venmo. Says if Karen hit John, wouldn't she have injuries, bruising from seatbelt or the steering? Yes, that too. That too. Yes. If she backed up at 24 miles an hour, now 87 feet in reverse. But according to this guy, she hit John and then she kept going another 50 feet or so at 37 or whatever the hell it is. I don't even know. I'm so lost. We're in the land of the lost. Say hello to Chaka. He's our mascot. He's up in the right-hand corner occasionally to help us through this with his Chaka energy. What is it that you say we're doing here other than pinning it on the girl? Shannon, the liar, says this guy turns out not to be an expert, just a jerk. He makes Shannon look better every question he answers. He makes Trooper Paul look like the best witness of all, right? Everyone smash the like button on your way out, please. Please, please. Like, subscribe. Make sure you have all of your notifications set to all, of course, as always. Moderators, I love you. I could not do this without you. I think you are the most amazing people in my life and in my world. Aside from my kids who on stream yesterday, and they planned to do this on stream. And I was away last week because of an emergency with one of the children. And then there was no court Thursday, Friday, and then no court Monday. So they wanted to do that cake for me with the candles for the 100K celebration while I was on stream, and they came marching in. It was like the Saints came marching in, 4 of them yesterday while I was on the stream at the end, singing happy 100K to you, and presented me with my candles in a rainbow cookie cake. And it was delicious. And my kids are amazing, as are you and all of your kids, because being a parent is the hardest job you will ever have, but it is also the most rewarding. Hug your children, as Vinny Politan says at the end of his streams. I love you all with all of my heart. I will see you bright and early tomorrow at 9 a.m. And stay cool, stay kind, stay classy, each and every one of you. I know you guys can do it. I know you can do it. And your life will be so much better for it. Peace. I got to go rest my voice. Good night, everyone.